This is the resumption of day 5 of the district plan hearings. We have first up Mr. Warburton speaking both on Ms. Smith's submission and on his own. How do you want to proceed, Mr. Warburton?
I just intend reading through the notes, which you already have.
Okay, that's all good.
Alternatively, I'm easy if you want to accept those as taken as read.
Well, why don't you, you've got a helpful, well, we've got, how long have we got? Well, we've got 40 minutes, so why don't you just read the covering comment. You don't need to talk about your own background, sort of start at the primary submission points.
Okay.
Yes, so we know who you are. So you, even if it was just down the tube.
Okay, so I'm Brian John Warburton. First up, I'm here representing Robin Smith. Robin has submitted 168 on the proposed district plan. She's also a further submitter in respect of submissions made by Kaonga Ora. So on to paragraph number 8, submission point 168.36, scope of plan change 18. The provisions of proposed district plan do not apply to Plimmerton Farm. This is explicitly stated in the public notice. There can be no doubt. Submission point 168.64, extent of ECNAs. The planning maps for the proposed district plan depict ECNAs within the Plimmerton Farm site. It is not possible for the ECNA policy overlay to apply in the proposed district plan to apply to the Plimmerton Farm site. Refer my Robin Smith's submission point 168.36. 168.98, existing uses in residential areas. Under rule GRZ R1 and standard GRZ S6, no credit is given for those existing residential developments where it is not possible to comply with GRZ S6. So it's conceivable that a resource consent would be required if only minor additions and alterations were proposed. Submission point 168.99, effects from vegetation that are equivalent to the effects from buildings. The plan needs provisions to manage vegetation in the residential area where it can affect amenity, such as shading and views. Submission points 168.100 and 168.101, height of fences on boundaries with public reserves. Permitted activity standards GRZS9 and MRZS10 specify that the maximum permitted height for a fence is 1.2 metres where the site boundary adjoins a public reserve. Ms. Smith supports this provision. Submission point 168.102, height in relation to boundary. Permitted activity standards GRZS2 and MRZS2 specify the permitted height of buildings depending on their distance from the boundary. This standard needs amendment so that the vertical component is limited to 1.2 metres where it relates to a boundary between the residential land and land within the open space zone. Submission point 168.103, extent of medium density zone in Titahi Bay. Ms. Smith is opposed to the MRZ zone being any greater in aerial extent. Further submission point, Ms. Smith has further submitted on the submission by Kaonga Ora, submission 81. The Council Officer's summary of Ms. Smith's further submission point leaves a lot to be desired. Some of Ms. Smith's submission points are overlooked completely and not assessed at all, and some relate to submission points that Kaonga Ora wish to withdraw, but despite this, they are mentioned in section 42A report nonetheless. But in summary, Ms. Smith's opposes all of Kainga-Ora's submissions points that attempt to expand the plan change beyond which was notified and exceeds that what any reasonable person might have envisaged and anticipated and considered making a submission on. Ms Smith mentions previous failed attempts by Kainga-Ora to expand the scope of a plan change applicable to housing intensification in Hutt City. That was Plan Change 43, by way of a submission. I'm happy to provide clarification needed by the panel or answer any questions it has.
Mr. Warburton, I suggest that you just roll straight on with your own presentation, and then because Ms Smith's focus was the notified plan and your focus is on the variation, and then we'll go from one to the other.
Yep. I am participating in these proceedings as a submitter 64 and a further submitter, FS 64. My submission relates to matters associated with variation 1 to the proposed district plan. My further submission was in respect of matters associated with the submission by KM and MG Holdings Limited. Primary submission points. I have prepared a summary of my submission points, which is attached to this presentation. I intend to speak briefly to each point. First point, height in relation to boundary. The height in relation to boundary permitted activity standard needs amending to address uncertainty about the scenario outlined in my submission. That relates to the internal boundary of a site being subdivided to create a rear site. Second point, qualifying matters general. Variation 1 does not apply to the exclusions provided for in section 77L of the RMA, nor does the plan change explain why those exclusions have not been applied. For all intents and purposes, variation 1 has been prepared and notified in complete ignorance of qualifying matters. That was not the government's intent. Submission point 64.3, qualifying matters, land subject to a qualifying matter overlay. Variation 1 should be amended so that the housing intensification provisions of Variation 1 do not apply to land identified in the PDP as being an SNA, subject to the National Environmental Water Standards for fresh water, having cultural or historical values and or within a coastal high natural character area. Submission point OS 64.4, qualifying matters, land adjacent to land zoned as open space and or subject to the ONL SAL overlays. Variation 1 should be amended to include specific development controls applicable to residential land due to its proximity with other land with open space or landscape values. Submission point 64.5, qualifying matters, infrastructure. Variation 1 should be amended so that any intensified housing is deferred until such time as the land has adequate 3 water servicing. Titahi Bay is already subject to frequent overflow of untreated wastewater. Any additional housing will intensify this adverse effect. That's a fact. The subdivision/development servicing provisions of the operative district plan do not prevent these additional effects, so the PDP provisions will achieve nothing more. Submission point 64.6, qualifying matters, coastal margin. Variation 1 should be amended so that there are adequate provisions to avoid buildings, and the adverse effects on coastal natural character therefrom due to intensified housing on land located within the coastal margin. The definition of coastal marine area needs amendment so it is relative to a tangible mean high water springs. That definition of coastal margin needs amendment so it is relative to a tangible mean high water springs and not one based on an erroneous concept derived from cadastral boundaries which in places can be askew by hundreds of metres. Submission point 64.7, extent of the MRZ RIP in Titahi Bay. As far as the residential intensification precinct in Titahi Bay and the accessibility parameter of the National Policy Statement on Urban Development is concerned, Council should discount St Pius School in Tuki Street, Titahi Bay. The limit of the RIP in Titahi Bay must be amended to reflect the fact that primary school education for about 90% of children is not accessible in this Catholic school. Submission point OS 64.8, policy ratification. There is no available public record confirming that Council has understood what they were agreeing to when they adopted a recommendation from Council officers that an intensification planning instrument, i.e. variation, we be notified. Commentary I have cited from the relevant Council meeting confirms the Council's decision to notify Variation 1 in its current form was made in a policy vacuum. Therefore, the content of proposed Variation 1 has not been suitably ratified by the Council, and the RMA process currently underway is invalid. Submission point 64. Can't be 7, sorry, I've already talked about 7. Might be 9.
That's 9.
Okay. MRZ RLP walkable catchment. In common with other councils and in accordance with MFE guidance, the council agreed to notify Variation 1 on the basis of an 800-metre walkable catchment. Despite this, and in the absence of any submission support, the council's urban designer now considers an acceptable walkable distance as 1,000 metres. Screenshots showing the discrepancy are included in my submission and attached to the summary. The evidence of the Council's urban designer is an attempt to expand the scope of Variation 1 as notified and should be discounted accordingly. Further submission points. As noted, I have further submitted on the submission by KM and MG Holdings Limited. KM and MG Holdings Limited has sought, by way of Plan Change 19, amendments to the overlay maps, specifically but not limited to Map A, applicable to land commonly described as Plimmerton Farm, and by way of Variation 1, amendments to the provisions of the Operative District Plan as far as it relates to Plimmerton Farm, so that the housing intensification provisions of Variation 1 will apply to Plimmerton Farm. KM and MG Holdings Limited seeks outcomes from PC 19 to the Operative District Plan that are not within the scope of PC 19 as it was notified. PC 19, as it was notified, specifically only addressed those matters required to give effect to the Resource Management Enabling Housing Supply and Other Matters Amendment Act. It is a matter of law that Variation 1 can't apply to the Plimmerton Farm site. The variation only applies to a proposed district plan, not one that is already operative. It is a matter of law that the amendments of PC 19 sought by KM and MG Holdings Limited exceed those that can be achieved by way of a submission. In short, the scope of what the submitter seeks exceeds what any reasonable person who might have envisaged or anticipated considered submitting on. If there are actual mapping mistakes, then a specific plan change process is the RMA means by which this can be rectified. Slipping such a significant amendment in via the back door does not accord with good practice or natural justice. Natural justice would not be served if KM and MG Holdings Limited submission was accepted. Again, I'm happy to provide clarification or answer questions.
Thank you, Mr. Warburton. Going back to your presentation for Ms. Smith, specifically about 16899, we talked to Mr. Racklin about this, and his evidence was based on his experience in Selwyn, that kind of provision on the height of vegetation isn't practically enforceable, and in Selwood wasn't enforced because the trees had existing use rights, so you could only ever target the incremental growth, and the issue was proving how much had they grown. So what's your response to that?
Yeah, I can appreciate that comment, but that dilemma is not confined to just vegetation. It's confined to other things where the council's ability to keep track of incremental development can't be achieved via some sort of regulatory process such as the Building Act. The Building Act allows the council to keep a track of buildings, well, some buildings, but it doesn't, for example, allow the council to keep track of hard surfacing, and yet the district plan or the proposed district plan has a provision in it relating to hard surfacing or impermeable surfaces. What I'm saying really is it's a landowner is actually able to breach the impermeable surface of the district plan without the council being aware of it. Just like if there was a provision in the plan about the height of vegetation, that would also become difficult for the council to keep track of.
And the submission 168103, has that effectively been overtaken by the NPSUD? It needs to be viewed in within a different lens.
I think Ms. Smith's submission, the point Ms. Smith was making was that she's put a line in the sand, essentially. And that sort of goes to her opposition to any attempt by Kainga Ora to expand the scope.
And sort of more generally, talking about scope, I'm looking in more detailed notes you've got in relation to that further submission, that specific. So it's FS 9.1. And I'm puzzled because, like, it's a whole, like, putting aside the subsequent overlay of the variation, as notified, the plan was a whole of plan. So how can anything be out of scope? That I'm thinking that there's the High Court decision in Auckland where Justice Fotter said basically that there's virtually nothing that is not on a whole of plan review.
Well, I'm not aware of that case law. But surely when you have a map included in a proposed district plan, any attempt to increase the extent of a zone must be out of scope.
But another way to look at it is, rather than increasing the zone, you're just asking for additional land to be, that's in this case, if it was notified as MDRS and the submission was seeking that the neighbouring GRZ was rezoned MDRS, or you're just seeking a rezoning. Is it an issue of scale that because there was so many and so large a set of changes, and like I understand the issue about understanding the scale of the changes that were proposed. That like I can, but does that affect the scope?
Sorry, you've lost me. I'll go back to Kainga Ora's attempt to expand the scope of medium density housing in the Hutt City.
Yeah.
The legal opinion provided to the hearing panel in that case was that it would be out of scope if Kaingaora's submission was accepted.
Yeah, but like that was a plan change, not a whole plan. So it was possible. Like, so I okay. I think you probably taken as far as we can, and as so it's been overtaken. Does anyone else have any questions on Mr. Warburton's presentation from Ms. Smith?
Thank Mr. Warburton. Excuse me, number 10 on page 2, 168.98. This is about the GRZR1 and the standards not being given credit. What is it? That was not, so let's find it again. Oh, yeah, here it's my writing. Not referred to in the Section 42 report. In terms of the new rules that have applied for there, given that it's the GRZ, as you said, is being deleted, is that issue still there? Have you looked into it? You're saying the officers haven't, but have you had an opportunity to look at that?
No, to be honest, I haven't. No.
Okay.
Sorry, GRZS6 has been deleted, has it?
So, this is 168.98. This is GRZR1 and the standards issue that you referred to. Okay.
Sorry,
No,
has
that's okay.
that rule been deleted?
As far as I'm aware,
Oh, okay.
all those rules have been, but I wondered whether the same
Well,
issue...
the issue might still be there.
Yes, yeah, so, but you haven't looked at... No, that's fine, thank you. No, that was me.
Yeah.
Thank you, Mr. Warburton. Just in reference to your item 12 on the height of fences on the boundary with a public reserve, I note in the officer's report that Mr. McIndoe has recommended an amendment so that there is perhaps some degree of raising the height where it's adjacent to the nearby dwelling, or alternatively having a fence that's visually permeable in some of its, raising the height, but having the height over 1.2 metres visually permeable. Do you have any comment on that on behalf of Ms. Smith? So effectively it's raising the height of a fence between a residential dwelling and public open space selectively and appropriately, as they say, to provide some privacy from the residential point of view.
I don't know, I haven't spoken to Ms. Smith about this, but I wouldn't imagine she would have any difficulty with that.
Thank you.
Okay, we'll go on to your presentation on your own submission. First of all, addressing your point 2 and point 3, as I understand your underlying thesis, it's the council officers have relied on the existing overlays, but they were drafted against a background of much less intensification, so how can you know they're appropriate? Have I got that clear?
So, which paragraph are you talking?
This is sitting behind your analysis of your point 9 and 10, sort of use of qualifying matters as opposed to overlays. To say
Oh, sorry. Yes, I'm with you now. Sorry.
So my understanding is that your essential thesis is that whatever might have been the merits or otherwise of those overlays, they were considered late 2021 against a background of a much lower density,
Exactly.
and
And
they
on that basis-
remain untested against.
On that basis, they should have been revisited. Yeah.
Now, that of course puts us in a cleft stick because they haven't been. And so if you were to, just taking the SNAs as an example, clearly they qualify as a qualifying matter in terms of the list A to G or A to H, I've forgotten what it is, in section 77. But G, the Commissioner corrects me, but you also need, before you do that, you need an evaluation in terms of section 77J, and you haven't presented us with any evaluation that would meet that. That's about testing it against the loss of intensification urban capacity, which do you so how do we get over that gap?
I guess that's something for the panel to answer. It's surely not my position as a submitter to solve the council's problems. Sorry, if you mentioned the SNAs, but I'd like to refer to another example where, in relation to buildings in the coastal margin, I'm thinking of a scenario where you might have the residential intensification precinct, which potentially allows buildings up to 5 stories high within the coastal margin or within 20 metres of the mean high water springs. Whereas when that coastal margin, that 20 metre wide coastal margin was considered in the PDP, or when that provision was assessed in terms of section 32, the people undertaking that assessment or preparing that section 32 report would have only been considering buildings 2 stories high, not 5 stories high. So conceivably, if they had looked at the possibility of 5-story high buildings within 20 metres of the mean high water springs, they may have considered a 20 metre wide buffer wasn't sufficient.
Going on to your point in paragraph 14, talking about St Pius's school, you say it's not accessible for 90% of the children. Is that because 10% on the census identify as being Roman Catholic?
That's correct.
Can you tell me, does St Pius, as a matter of fact, admit non-Catholic children?
I don't think they have an exclusion policy, no. I'm not sure about that. I think the point is that the parents of who are not practicing Catholics are unlikely to consider St Pius School as being a school which is accessible. It's not the school's policy as such. It's the fact that I would imagine, just personally speaking, if I had children who needed an education, I would consider St Pius School to not to be accessible to my children.
And going on to paragraph 15, you've drawn attention to issues as you see them with the council process. I suppose again, sort of, what do you think we can do about that? Like even if we agreed with you, what could we actually do in practice that we've been delegated with the job of considering submissions?
Yes, I know. It's a difficult one. I don't think there's any easy answer to that other than probably providing some sort of commentary in your decision report or your recommendation report.
The going into the commentary at the back, talking about walkable catchments, you're saying 800 metre distance consistently adopted nationwide. I don't know if you know that that I'm on the Wellington panel. It hasn't been adopted Wellington.
It hasn't been.
No, it's adopted a time.
Oh, okay. I knew there was some debate about it. That's interesting.
So, but you're saying, well, we should discount Mr. McIndoe's assessment. Well, the only other urban design witness who's given evidence for us is Mr. Ray for Kaingora, who's pushing the envelope further. So is he a preferable option? It's sort of between the devil and the deep blue sea.
Oh, well, it's a shame I didn't know about the Wellington Wellington situation, because I might have actually recommended a time limit, because children generally walk slower than adults, don't they?
Yes, we had a lot of evidence about how fast people walk. And the fact that the usually referred to statistics are taken from mountain hikers who are fitter and faster than most people. Any other questions, commissioners?
Yeah, Mr. Warburton, on that walkable catchment in the 1,000 square metres, is it that you think that should be 800 rather than 1,000 for that particular issue? That criteria of it, because they've got within 400 the distance of an open space network. So my understanding, it's kind of that they stack all of these things on top of each other, and it's a limiting factor rather than just 800 metres that you need. They included these other ones in the methodology for how they determined what a walkable catchment would be. So is it more from your point of view that if they're using it for schools, it should be 800 and not 1,000 in terms of the methodology?
Well, I think my concern was that there was no justification for it. There was no explanation why there was a jump from 800 to 1,000. And as I've mentioned there, there's no support by any submitter to that, to an increase. It seems like an error, perhaps. I'm not quite sure. But once again, my view is that if it was advertised, if Variation 1 was notified on the basis of an 800 metre walkable catchment, then 800 metres should be it,
Right.
or something less, perhaps.
And you have you looked at the section 32 and the documents that refer to? Because I think that's the justification for that's included in that. But if you might not have had the opportunity to look at that.
Well, it was notified with 800 metres, and then Mr. McIndoe's report refers to 1,000 without any explanation.
So it was changed to 1,000 after notification.
Yeah,
Yeah.
Mr. McIndoe's section 42A report refers to 1,000.
Okay, thank you.
Juliet? You go.
Mr. Warburton, just on that last point, the Section 32 report that was published at the same time that the plan change and variation were notified included a report from Mr. McIndoe entitled Urban Development Report 20, and that the panel have obtained a copy of that, and that referenced the 400 from parks, 1,000 metres from schools, and 1.2 from supermarkets that are used and bundled together to see where they intersect with the 800 metre walkable catchment to determine how that walkable catchment might be nuanced. So that information was in fact available at the time of notification. That's the point I'm just making to you.
Oh, okay, all right.
Okay. Just two questions of clarification to you. One, going back to the...
Sorry, I suppose it must have been, otherwise I wouldn't be able to make it in the submitter.
Exactly.
submission.
Yeah.
Sorry.
It's worth reading that report, I think, and there'll be a lot of
I'm
discussion.
pretty sure I have actually, but anyway.
There'll be a lot of
A long time
discussion
ago.
on that this afternoon when Koyangora presents. Sorry to go back to St Pius School, but I just wanted to seek clarification. Are you seeking to delete the influence on the RIP altogether, or to reduce the influence?
The outcome I seek is to have the 800 metre walkable catchment from a primary school determined relative to the primary school in Kura Street.
And okay, as opposed to St Pius. Yep.
Yeah. And if you do that, you
Have you done that?
Yes, he has.
Yeah.
yeah, I've provided an aerial photo with the relevant properties coloured yellow.
It's on page 15.
Yeah.
Okay. Thank you.
Like so.
Yeah. So, second question is in relation to the RIP and any coastal margin. Do you have a feel for? Oh well, first of all, is there any RIP in the coastal margin that you're aware of?
Yes.
There is. Okay.
I may be wrong, but Plympton is RIP, isn't it? Council officer will know that. Stein Avenue.
I think it's
Plympton's high density
High
zone.
density.
high density.
Yeah.
And also Titahi Bay.
Okay. Thank you. Thank you.
Yeah, you go for it.
Sorry, Mr. Warburton, just coming back to St Pius School, we questioned the council officer, Mr. Racklin, who told us that his reasoning for including it in the walkable catchment was that it is likely to remain a school. Even no one seems to know whether it limits its population to only Catholics. Do you have any comment on that? I mean, I suppose I note that the existing Titahi Bay School, the Kura School, has limited access. I mean, it's oversubscribed. So, do you have any comment on a school that may, at some stage, open its role to a wider catchment if that should stay in the walkable catchment area?
Well, that's sort of crystal ball gazing, really, isn't it? Why should we make planning on something which there's no evidence to say or no justification to say that it would actually happen? Otherwise, we're making planning decisions about all possibilities, regardless of how remote they might be. I would say that's fairly unlikely, isn't it? A Catholic school becoming a public school. Are there any examples where that's happened?
I think there are many examples of Catholic schools that have opened their roles to a
Well,
wider...
I think the roles are already open. That's what I said before. I think it's already open. But that's not the point. The point is for the parents of those children, if I was one, I would say that it's not an accessible school.
Okay, thank you.
Any others, commissioners? Thank you very much once again, Mr. Warburton.
Thank you.
So typically detailed and helpful.
Thanks.
We'll take a break, have a coffee, and we'll be back at 10 to 11. resume the hearing. Mr Winchester, I presume, and Mr Cumming.
Yes, good morning. In accordance with from Mr. Cumming, and I have also provided some I'll be guided by you how you want to hear from us. Where I guess what the issue is quite very narrow. And in terms of processes, the answer oh, thanks. Out of practice. There we go. I don't propose to say any more by way of introduction or scene setting, and I'm happy to take questions. What I will alert you to is the fact that I'm keep getting kicked out of the council's Wi-Fi, so am somewhat hampered in my ability to access legislation if you have questions about it. I might be able to borrow Mr. Cummings' laptop or commandeer it.
Okay, that I think, well, speaking personally, I've got a reasonably clear fix, or at least I think I have, about the issue you've addressed. I've got two points for you, Mr Winchester, and one of them fades into Mr Cummings' domain, so you can defer to him if you like. So I start at paragraph 26. You're saying it's plainly an area. The area is of very limited ecological interest or value. Don't we need an ecologist to tell us that?
No, in my submission, sir, you don't. And the reason for that is essentially due to the procedural path that matters have travelled to get us here. And I know, obviously, Mr McDonnell's recommendation in his Section 42A report was that evidence should be led. That was never the thrust of the submission. It's essentially around rectifying a procedural error and a procedural regularity. I guess the import of it is self-evident in my submission from a number of the areas that have been incorrectly mapped.
I understand your point that it's an error, like Mr Cummings has given a chapter and verse on how it came about. But from my perspective, however it happened, it's sitting in the plan.
Yep.
That you're saying it's, in effect, the nature of the error is that areas are identified as being of ecological value that are not. And so in terms of changing the plan, our section 32AA evaluation, don't we need some evidence to satisfy us of the underlying merit of that proposition rather than just saying, well, it was cock-up in the previous hearing process? Is that sufficient for our section 32AA analysis?
Yes, in my submission it is, sir, because if you trace back into the genesis of the provisions, as Mr. Cumming has indicated in his evidence, there was at least some evidential foundation for the two sets of bore areas that had been mapped, being in the precinct plans and the planning maps. So we are not revisiting the merits, sir. We are revisiting the process and the outcome. And if it assists the panel, my submission to you is you don't even need to consider expert ecological evidence about whether areas have value or not, because essentially, as a product of the previous process, those areas contributed to the mapping. So it's all, the answer is self-evident, and it doesn't need a gloss on it in terms of, I guess, reality testing or ground truthing.
And the second question is, to the extent that the errors relate to Precinct C, that's not an urban zone. So is there a motor machinist's problem?
There is a challenge. I'll certainly be open about that. It is an urban environment, and I guess the way I would tackle it, sir, to give you the tools that you need, should you want to go there, is that Plan Change 18 is, and what's in the operative plan, is the Plimmerton Farm Zone. The precincts are effectively overlays or subzones, some of which have been picked up. But when you are thinking about what a related provision is, I certainly adopt Mr. Cummings' view of things, that it is a related and integrated set of provisions. Many of the provisions apply across all of the precincts. And they are obviously subject to their own express standards and considerations, but it hangs together as an entire integrated urban zone. And I guess that's where you were going with your indication that my answer probably bleeds into Mr. Cummings' evidence. But I have read the legal submissions on behalf of the council, and there's not much that I really take issue with in there. I do think they've taken a very firm and possibly unnecessarily strict view of Section 80E And like anything, the more you look at some of these provisions, you find some unusual wording features in other parts of the Act that relate to the the intensification streamlined plan process. And certainly one of them I found this morning is in section 77I, which is obviously, it's part of the mix. It's descriptive in terms of what it says qualifying matters are, and it's pretty broad. So you've got these descriptions of qualifying matters in section 80E in terms of what can be related provisions, but they're also described in other parts, and they don't entirely, well, I guess if you put them together, I say it enlarges matters in terms of what the panel's scope to address matters is.
Well, why don't we address that with Mr Cumming shortly, but I'll just ask if my colleagues have any other questions of you. This looks like a no.
Oh.
So, Mr Cumming,
Disappointing.
can you you've obviously got the drift of my question about on scope. Yes, if the light's showing, you're good to go.
Thank you.
Can you explain to us the nature, Council describes as an integrated urban zone. Can you describe to us the, stepping back from this, the structure of the Plimerton Farm zone and how the precincts fit into it, and where the Bora fit in structurally as opposed to a rule by rule? Like, I'm looking more for a conceptual analysis than sort of rule X says this and rule Y says that.
Thank you, Mr Chair. I'll do my best to get my head around that question. I mean, Plimerton Farm was always designed as an integrated whole. So the constraints and attributes of the site were identified spatially regardless of where the underlying provisions of the precincts ended up. So there was a lot of initial work on landscape stemming from the Kakaho Special Amenity Landscape layer, a lot of ecological investigation, and so on. And obviously the landowner had some aspirations and some ideas about what might go where, what might make sense. And the early precinct plans showed an indicative retirement village, for example, an indicative school location, neighbourhood parks. The indicative roading layout was key. If you look, it's certainly not an easy site, and the roading and cycleway pedestrian network was key to making the site work. When I think about part of your question being perhaps how integrated with the rest is Precinct C, well, some of the areas that have been mistakenly identified as Boras are the route of the road to get to parts of Precinct C. So it's that integrated that if there are constraints on getting there, Precinct C is certainly going to struggle to come into being in its intended form. I'm not sure if I've fully answered your question, Mr Chair. You might like to give me some guidance if you need to.
So is that just the Precinct C map, or does it looks to be to connect all the way around from Precinct A in the south, round to the far end of the site and back into Precinct B?
I'm sorry, which map are you looking at?
I was looking at the precinct map that's attachment 1 to your evidence. Like it looks, that road appears to be a link road to the far edge of the site, out of precinct A to the eastern edge and then back again into the urban area. So it's integrated to that extent.
Yes, that's correct. The road I was referring to goes from the bottom of the site east and then along the ridge.
So is there a ridge line at the eastern margins of the site?
Yes, there's a dominant ridge line associated with the Kākoho special amenity landscape.
And that road is on top of the ridge line?
It's in the vicinity of the ridgeline. The ridgeline is shown as the thick green line which trails around. I can approach and show you if I'm not being clear.
That seems to go off the site.
Which figure is it? Sorry.
It does go off the
Figure
site in
number
places, yeah, further
13.
east onto the neighbouring property.
Oh, yeah.
So most of the special amenity landscape is actually off the site to the east.
Sorry, Mark?
So, which figure number is it that you're referring to? Attachment 1, and it's got no figure
It's,
Paragraph 6.
yeah, paragraph 6 of Mr. Cummings' evidence.
What, for those of us that weren't involved, what was the zoning of this area prior to the recommendation, to the process that was undertaken?
It had a rural zoning.
Right, so it wasn't a future urban zone?
No, it was actively farmed or attempted to be farmed.
You go, Mark.
Yep. So in your evidence, do you have a copy of a plan showing where, if we were to agree to the change you're looking to make, what it would look like?
Yes, Mr. Chair, in that I've suggested that the Bora layer should be as notified in the notified precinct plan.
So
where is
can
that?
tell me which plan that is. In attachment 3, I've got a whole lot of plans in there. Is it one of those?
Attachment 1, at paragraph 6, it is also in that that list of plans, well, shown as that list of plans in various forms, but certainly in terms of relief sought, I've pointed at the notified version of the precinct plan.
Does that actually show the borers? Are they the grey hatching? The issue is that there's no key on the map on paragraph 6.
Yeah, they are. Yeah. Mr Chair, figure 2A shows the precinct plan as notified on the 20th of May 2020, and it does have the full key that was included.
Where is that?
Attachment 3, page 18, the bottom figure. Yep.
That's correct.
Correct.
Yep. So the piece in red written on that, the borers replace steep slopes and indicative offsetting. That's just for illustration purposes and doesn't need to be there.
That's an annotation that I've added to try to explain what
Yep.
it's on.
And you, as I read your evidence, you said you picked up there was an error in that plan.
Yes, Mr Chair.
Didn't
well,
show something.
I really need to give credit to Mr McDonnell for pointing that out to me. As I said in my evidence, I had a discussion with him to try to understand the council's position, and he pointed out that the PDL submission had shown a map that had the same shapes as some of the Bora areas. So I did a bit more detective work to try to understand where that map had come from. That particular one was from the original ecological report that was part of the Plan Change Section 32 report. There was an equivalent landscape report that had some other shapes in there. So as I've said in my evidence, I concluded that in fact that there were some additional areas that weren't shown in the Bora areas in the precinct plan as notified, and I don't know why that was, but I think Mr Winchester has used the phrase unders and overs, so that's where I landed, that I think both versions are wrong, both the precinct plan version and the planning map version. And as you know, I've suggested that you revert to the precinct plan version and rely on the provisions of the plan, which require that subdivision has thorough, comprehensive ecological analysis assessment of what's on site. They're called areas of significant terrestrial indigenous biodiversity, to have another strange term thrown in there, but essentially, in my mind, that means that anything that isn't in a Bora or an SNA, but perhaps should be, and some of those might be just because of the passage of time as vegetation has grown, or a more thorough investigation might find some lizards, for example. So those areas would be picked up. So to my mind, that's where the panel can have a level of comfort over what I'm suggesting in my evidence.
Sorry, you go, Barry.
Yeah, so why wasn't it fixed at PC 18?
So there was a streamline directed by the minister. One of the procedural was independent hearing panel. Commented. It's a
Right.
there's other ways of. Oh, sorry.
So then,
And look, I'll be open. I was advising the council at that point, and that was my advice to the council and the panel, that they simply could not rectify the mistake at that point.
If for whatever reason we found that we couldn't rectify the mistake, I take it there's another plan change process to get Plimerton Farm out of the operative and into the, or does it just sit in the operative plan for the rest of its life, as it were?
It's operative. It's in the operative plan.
Yeah,
And as you go through your process in dealing with the proposed district plan and issuing decisions, and those decisions get adopted and then not appealed, the corresponding provisions of the operative plan that they replace disappear. And so here's PC 18, operative,
yep,
proposed plan provisions like a magnet join it and become an operative plan
so
as
plan
well.
change
So you've
19.
always got an operative plan. It's just
Yep.
it's in a state of flux as you go through those processes.
So the PC 19, as it is now,
Yep.
is effectively a
It's a change to the operative
operative
plan.
plan. And then when, so it's still when, for instance, the proposed, whatever we come up with, a proposed plan, things such as SNA overlays and that don't appear on PC 19 in the same way they do to the rest of the district?
Well, no, they won't.
They won't,
And,
so-
and the reason for that is because PC, Plimerton Farm, the area of the Plimerton Farm zone in PC 18 was excluded from the proposed plan as notified. So it's out of play.
Right,
So in terms of what the Commissioner says, it's not wholly right to say that the plan change would be required to bring it into the PDP, but I think the issue that the staff have identified for us is that PC 18 and now PC 19 are not consistent with the national planning standards, and so there will be a further plan changed to bring it into line with the structure of the PDP rather than, as you say, it will form part of one document, but it will sit like an island
yes,
on the basis that that's the only part of the end result that's not written to be consistent with the national planning standards. As
and the
so for instance,
Yeah, the
using the
overlays.
SNA overlays
don't apply.
rather than the way that's been done in this plan
Plan.
change.
Yes. Well, I guess that's a question of technique as opposed to compliance with the national planning standards. My recollection, and you'll just have to take my word on it, is that at the time, what was constructed and the way Plan Change 18 was drafted was considered compliant with the national planning standards. It's just that I guess it sits there as a discrete
Yes,
part of the operative plan, and stylistically other parts, what you're considering in the proposed plan process are different, but not necessarily. I wasn't aware that there was a compliance issue, but that
no, sorry,
Look-
that my question is, it's not a compliance issue,
Yes.
it's just whether
stylistic.
that, and to have an integrated whole plan that applied to the whole district, would that would require a plan change? If that was what you were if the council was proposing to do that?
Well, that depends. I mean, there's a clause, our old friend clause 16 of the first schedule, but there's some fishhooks with that as to whether stylistic changes are minor amendments. Look, I don't know about those other council processes or possible decisions.
Well, suffice it to say, we've been told that will be, in the
Yes.
fullness of time, there will be another plan change.
Okay, well, I appreciate that advice, and that's useful to know. So I don't necessarily think it detracts from the submitter's desire to have matters rectified through this process to the greatest extent possible. And I suppose the other observation I would make about another plan change in future is it would need to be more than just stylistic, it would need to be substantive if it was going to address this issue. And so I guess if it's going to be an omnibus plan change to do a mop-up, as it were, which is common, then that could work, but obviously timing is a factor.
But going back to, no, you go.
Another alternative, so if we found, following the council's legal advice, that we could only change appendix A and, precincts A and B and not C, is there a copy of a map what that would look like? Rather than, what is it? You told us the one which applies to if we were going to change A, B and C, but what if we only found it that was only on A and B was appropriate? Which map would we be looking at just to show those areas, or is there one?
I'm not sure there is one that it would probably need to be something of a hybrid between two existing maps. So if you left precinct C as per the PC18 decision, it would look like it does, and then you would essentially just put two maps or plans together to get the result.
Right.
I'm sure the GIS people can do that
Yeah, I know.
quite readily. I don't believe there is a visual resource available right at the moment, and I don't think my client has one prepared.
No.
So I'm sorry about that.
So we, I don't know if you heard us when we were quizzing the staff about this, but we weren't that enamoured with maps anyway. When they say one, it says not to scale, and a visual scales provided, so there's no north points on some of them, all sorts of issues. So the clearest one is that, paragraph 6 in attachment 1, and then as shown in, I'm talking from your perspective, then it's essentially figure 2A on page 18 of attachment 3 to Mr Cummings that we should be using.
Yeah,
And then-
look to my eye, sir. Figure 2A is the clearest and best quality map, although
Yep.
it obviously has a
Yeah,
bit
the
of...
scale might have something to do.
Yeah.
Yep.
Mr Chair, if I could just comment on that, though, I mean that the Bora layer is a GIS layer, and it could be applied to any of the council's mapping systems, and there would be absolute clarity around that. It looks clunky on these PDF type images because that was the technology of the operative plan, if you like, rather than it being an internet web-based type system. So that's why everything was presented in that way at that time.
As you can tell, I'm a fan of A3 and printing it out so that people of challenged eyesight can possibly read it. Mr Cummings, could you tell us what the implications of, is what you think might be the implications that if we, don't make the corrections for your client as it is, and then conversely from that, what the other, effectively from the other side, what the implications might be.
Mr Chair, I think if you keep the borers as they currently are on the planning map, then you have some areas on the site identified as qualifying matters that clearly appear not to have any ecological value. That does create a problem for the development of the site, as I referred to some of the roading, for example. I think there probably is some sort of pathway for the landowner through the consent process to deal with borers in the wrong place, but I think ultimately the biggest problem with that is they would have to go somewhere else on the site. So at some point you end up with areas not being developed that have the potential for development. So I think it does work against the whole thrust of housing supply as a desirable outcome.
How
So,
big, can we just get a fix on how big are the areas we're talking about? What's the spatial extent?
Mr Chair, I haven't tried to put a number around them.
Finger in the air?
There are several hectares. I mean, I would imagine of the 10 to 20 hectares sort of range, something around there.
Sorry, Mark, you go.
Yep. Sorry, what is it that you the second part of that question, what is it that you understand is the problem?
If we do.
If you do revert the borers to the precinct plan, then that was my explanation earlier, that you would use, a consent application would use the provisions of the plan, would be forced to have in-depth ecological assessments of not just SNAs and borers, but all other areas of the site to identify areas of significant terrestrial and indigenous biodiversity. And those areas are given substantive weight by the plan provisions, the same or very similar weight to the SNAs and borers. So a subdivision assesses those areas would have to be identified, and you would go from there. So the constraints on development of those areas would be effectively the same as if they were identified as a borer.
Remind me again what BORA stands for.
Biodiversity Offsetting and Restoration Area.
If it's an offsetting area, does that mean that it doesn't necessarily have ecological significance of its own because it's offsetting loss of something else, or not to the same degree, because it then needs to be the subject of management work to enhance it?
That's correct, Mr Chair.
Sorry, Mark, I'll keep interrupting you. Interrupting your flow.
So, possibly going back to Mr. Winchester's earlier part was about. So I understand that it was the idea of PC18 was to make Plimerton Farms move it from rural to urban, and the fact that some of it through precinct plans or zoning or whatever was made into biodiversity offsetting in significant natural areas, but and that's through a zoning technique in Plimerton Farms, rather than overlays in the PDP.
No, it's a mixture of overlays and associated standards and quite detailed plan provisions. So to the extent that borers are mapped as overlays, which is what the product of PC18 is, there's very extensive plan machinery that goes with that about there's objectives, there's policies, there's information requirements for the initial resource consent or subdivision consent for the site that specifically refers to what you need to do. And so I guess this is the issue, is that because there were areas of sensitivity or are areas of sensitivity on the land, the very first subdivision application for the site is seen as pivotal, and it is made pivotal by the provisions of PC18 to essentially front load all of the information about the entire zone that deals with its ecological sensitivity. That all needs to be identified. And then, as subsequent stages are rolled out, identified again and again. So it is a very conscious layering approach to, one, dealing with the risk of a changing environment, and in fact the likelihood of a changing environment when it's not farmed, areas will start recovering, and therefore they need to be captured. So that's how it is intended to work, and very clearly how the plan requires it to work. And that's why I've said in my legal submissions, the risk for the panel in getting it wrong, if you say let's go back to the notified precinct borers, is actually very low from an environmental outcomes point of view, because the machinery of their plan change already deals with it and no one's seeking to change that. But the cost to the landowner of not going back to that is potentially very great, and in terms of the council's housing supply goals and in fact directions from central government, because if you start with borers that are mapped incorrectly, it's very, very hard. They're assumed to be correct. So things don't go the other way. It doesn't get any looser. It only gets tighter. And so those are the costs and benefits that you are being asked to weigh up on the merits of the relief sought.
Just pick up on that question though. How significant is the loss of housing capacity if it's out there in precinct C, which is low density anyway?
Well, I guess the issue depends upon, I think, as Mr. Cummings said, it could be an accessibility issue. So it might, in fact, the land area might be small, but because it's intended to carry a road which provides access to all of that precinct, it may make the entire precinct of very marginal viability in terms of its overall contribution to housing supply. So, and And that's I guess, comes back to the underlying point, which is about the intensely integrated nature of Plan Change 18. So there's quite potentially large knock-on effects across the precincts in my submission.
Judge, just looking at that though, if I understand where the error is out on the eastern margin, the road appears to go around the outside of it, on the other side of the boundary.
Look, I can't answer that question. Mr. Cumming might know a bit better.
Here, the road's the green bit.
No,
No.
the road's the dashed, I think the road is that, on there. Okay, the road is one of the, is this.
The road is the grey blobs.
Well, so I'll go back to paragraph 6. There's
Which is this guy.
it's
This is the road here.
well that's what I originally thought.
Yes,
and
yep.
I think somebody I think it was Mr. Cumming said it was the green.
I don't know, that's the special amenity. See, there's the legend there. This is the special amenity stuff here, and the road is, you don't have an
Mr. McDonnell has an
A3 of this.
All right, so I'm wrong. It's the green area is not the road.
No, it's this thing, that grey bit.
Well, that's what I originally
Yeah.
thought
Yeah.
of that bit.
Yeah.
And so that's what I originally thought, and then one of you said it was the green line, and that was outside the boundary.
Oh no, that's the sort of the ridge line,
Yep.
sir,
So the green line's the ridge line.
and the boundary of a landscape unit, a special landscape
Oh yes,
unit.
all right. Go back, Steve.
Mr. McDonnell, do you have a copy of figure A2 at A3?
I'm mindful I'm still to respond to the panel's request for A3s on these maps, and in fact I printed some off this morning. I didn't hand them out before the presentation because I was mindful of the submitters being here and you needing to flap through A3 maps. But even through this discussion, I've realised I haven't included the legends for these maps, so they're not very much use to you, so I need to reprint them again anyway.
We'll have the legends on a separate page, not to take up any space on that. So if we could have the legends on a separate page, just stapled to the back of it, and I'm happy to put the submitters through the inconvenience of listening to me, Russell, on A3. So if we could have them
Okay, I can
now.
hand them out now.
And just to be of, sorry, am I supposed to? Are these one set each? One.
Yes, so
If the staples one set each, and I should pass
Yes,
them
yes,
along.
yes.
Oh, okay, great. Thank you.
please pass them on. So just for context, the first 3 pages, there's some headings at the top. So the first 3 pages are the notified precinct plan. The second one is the notified open space map. The third one is the notified environmental overlays. So those are the ones that were notified in, as part of the plan change. And then the last 3 pages are what the maps in the operative plan. So there's the operative precinct plan, operative open space,
Right.
and the operative environmental overlays. And I've carried through those same red circles to each map. But apologies, both of the precinct maps are missing their legends, so I'll reproduce
that's
those
right.
for you after this.
So that the fourth plan in. The fourth plan in, is that the same as figure 2A in Mr Cummings' evidence?
No, it's not.
The first plan is the same as figure 2A.
Okay,
So that's the notified precinct plan.
And just using those three borers, or four borers, as a reference point, the precinct plan on page 156 has the top one and the bottom one, but not the two in the middle. So can somebody explain to me where that came from? What is that precinct plan?
this is the operative plan, in the operative district's plan.
Correct.
That's the precinct plan in the,
Yes,
well,
it's in
that's
PC 18.
That's the PC 18 decisions version,
Correct.
which is essentially a problem, but it doesn't show holes. So tell me, Mr. Cumming, in a perfect world, would we correct all these errors at one hit?
Mr Chair, I would certainly encourage you to take the opportunity. I mean, when I read the legislation, ADE, and the leeway that government has given the process, I think clearly they intended that there not be kind of artificial barriers to getting a sensible result. So I would just encourage you to get the right result here and have a level of comfort that there isn't a downside to it because of the provisions as explained.
If the and this took this streamlined planning process, if this was going from usually it goes in Porirua, as I understand it, from rural, it would be first indicated to be future urban zone before moving it to the next one. If it had taken that, would we be in the same? Would the same issue arise in terms of the difference between precincts A and B and precinct C if it was fuzz originally?
Well, I'm not sure anyone knows that because I'm not sure the genesis of the planning provisions makes much difference to what was an inadvertent error through the process. Errors can happen through any process. So my answer, sir, is that it was still one of the first SPPs. I think Hastings was the first. This was probably the second. It was early. There was a lot of information. It was a big process, and these issues, through really no obvious fault of any person, just slipped through the net, and that can happen in any sort of RMA plan making process, whether it's a fast track one or otherwise.
Anyone else?
Good morning, gentlemen. Sounds like a messy situation. I certainly wasn't involved in the streamlined planning process, and I'm
Thanks very much.
Thank you for dropping your colleague under the bus.
Neither was I.
I'll add that, as Mr. Winchester elegantly said, there was very little that could be done in any event.
Thank you.
Mr. Cumming, you you're of the view that both the precinct plan and the planning map versions are flawed and incorrect.
That's correct.
And basically they should be corrected to the extent possible, the greatest extent possible, I think was Mr. Winchester's terminology. I'm interested in the event that it's your paragraph 41 where you say that if the Bora precinct plan version emits, if the Bora precinct plan version is adopted, then there's this sort of belts and braces consents process that can apply, and we've heard that it's the risk is low, but the cost to your client might be high in going through that process. You seemed in your comments, Mr. Cummings, to think that there was a consent pathway through that process. I just wondered what the activity status is and whether the nature of the policy wording is directive.
Mr. Chair, can I just clarify the question? Are you talking about the consent process in terms of
Subdivision.
but looking at the areas of significant terrestrial indigenous biodiversity?
Yes, your paragraph B of 41 on the top of page 11.
Okay, so that process is a requirement of the subdivision application. So I'm not concerned about the cost to the applicant in doing that. That's a requirement of the plan.
Yes.
That they have to do in any case. My suggestion is if you rewind the borders to the precinct plan, then that simply becomes part of the area that would be assessed. Well, I mean, the entire site,
Yes.
borders, etc., would be assessed. If I made a comment earlier about cost to the applicant, that would be a problem in my view if the borders were left as they are in the planning maps, because as Mr. Winchester said, it's difficult to unwind something that's there in green and white on a plan. You can't uncook that.
Yes.
It would have to be at least an equivalent area found on the site, and that's potentially problematic.
Yes, I know, I understand that. Just going back to the mechanics though, that information requirement sub PFZIR-1, is that a precondition to subdivision being of certain activity status, or is it information that's required to accompany a subdivision consent?
It's information that's required to accompany an application, and there's very strong policy support for that position.
Yes.
So
What's
that
the activities, what's the entry status for subdivision?
It would be restricted discretionary, I believe, and that provision doesn't change the status of the application.
Okay.
Unless, of course, they didn't provide the information, then they would trigger probably full discretionary, I think. But I would have to check that.
Presumably the application would be rejected under 88 if they didn't.
Probably that would be the first step.
Yes. Okay. So what was your intention in bringing that process to our attention?
Mr. Chair, I was aware that I was saying that you had two versions of a plan and they're both wrong. So that didn't seem particularly helpful. So I was trying to point a way forward for the panel and just toss around, I guess, the pros and cons of each of those approaches.
Okay. And okay, I won't take that any further. Thank you for those clarifications.
I think we're good to go. I think we understand it as well as we are going to. Thank you, gentlemen.
Thank you.
Thank you.
The next submitter is the Grey Street, Porirua Bay Residents Group. These gentlemen have unloaded their messy bunch of plans. Grey Street, Porirua Bay. Wait one moment. See where they might be. What's this? 5 minutes. Find a pew. Are you the Grey Street Residents Group? Wow, welcome. I'd say make yourself at home. Should have two.
So one of them's just the maps, which are a bit bigger, because when I printed it out, I realised I'm actually half blind and couldn't really see it very clearly. So,
We're familiar with that problem.
so thank you for having me here today. Thank you, Council, for having me here today. As I said, my name's Rebecca Davis, and I represent the Grey Street Porirua Bay Residents Group. And our submission is relating to the Northern Growth Development Area. So Grey Street in Porirua Bay is close to where the Muri Road development is going to be. And a number of our properties border on to a council reserve area on Grey Street. And one of the things living there that we are really aware of is that when the Murray Road development happens, there's going to be the removal of a large area of pine forest. And while pines aren't native and nobody really loves pine trees, it is providing a habitat for a large number of different native birds. So there's going to be a destruction of a habitat at some point. And one of the things that we've worked through from the very first days of the structure plan was in some of the first public consultation meetings with these lovely people here, was we talked about whether or not we could look at an ecological corridor that would connect on to the existing council reserve land there, which a number of us residents have with council support and council providing trees from the nursery. We have been planting that area up over time. So to be able to have that ecological corridor connecting onto that reserve land, we are hoping will connect to the significant natural areas that are there to help with that habitat for birds, and there's also a lot of lizards that live in the area. So we put forward our submission, which was fantastic, and on this page here, so that was what we had originally submitted, that we asked that the ecological corridors would actually be mapped out more clearly to show the 50-metre width rather than how they were, which was just with blue arrows. We understand that the structure plan is a foundation document, and if we get that right, then it's in a really good place when development occurs. So that was what we requested. If you then turn to the next page, there's this map. So this is what came through in the council officer's report, where the mapping was partly accepted. And the reason, so if you have a look on here, the difference between those two maps is that there is an area here which has not been included as an ecological connection. And the reason given for that not being included is that it creates a kind of funny little awkward spot, which is the piece which is outlined in yellow. I've outlined it in yellow. So the council officer said that it would create a strange little piece of land that would be difficult to develop on. I guess I had considered that that awkward little space would be included in the ecological corridor. And now the reasons for that are that, sorry, there's a bit of flipping between pages. If you go back to this one here, where you've got an ecological corridor in blue, you've got significant natural areas in green. To develop on that parcel of land, you'd then have to put a road through an ecological corridor, which defeats the purpose of a contiguous ecological connection. So our request today, and please be kind to me if I'm using the wrong language at all. I'm just using layman's terms. This is not my area of expertise at all. Our request today is that you'll consider that actually this diagram 3, that those full areas will become the ecological connection, including the funny little yellow awkward bit. So you get this very clear, contiguous ecological connection for meaningful habitat for the birds, for the lizards. It borders onto the council reserve, which is that pink part. You can see that also shown on the map here, there are 2 waterways, which that piece of land sits right in the middle of. One of the waterways is slightly obscured, sorry, by my pink part of council reserve, but that's a wetland. It's also a runoff from the flood maps. So this blue area here at the end of Grey Street is mapped as a flood-prone area. It goes down a bank, so this area all through here is provides drainage. So does that make sense, what I'm communicating?
Hey, you're going well.
Okay. So that
Just keep rolling.
Okay.
I think we understand what
yeah,
you're doing.
so that's the first part. So what the relief I am seeking is that this diagram 3 will be adopted as the map for the structure plan.
So could I just clarify, so that's the areas that are the black rectangles?
Yes.
Plus the area that's highlighted with a yellow edge around it?
That's right.
Yeah, okay, thank you.
And can I just clarify, please, that the yellow, on map 3, the yellow outlined area, what you said is, well, if there's no access to it, the only access to that area would cross one of your ecological connections.
Exactly. You'd have to put a road through an ecological connection or through a significant natural area. And actually that piece of land along here is actually it's a skinny little piece at the top of a ridge line where you've got waterways directly beneath it. So, and in terms of, I know that council has to provide land under the NPS UD, but in the grand scheme of things, that small area to lose that, it's not big in the grand scheme of the northern growth area. However, the ecological benefits to include that in that ecological corridor feels like a compelling and reasonable request to me and the 30 other residents that I am representing here today.
Can you, do you have any sense about how big it is in square metres? I'm not suggesting you have a survey plan or anything. What's the finger in the air?
Well, if the width of it is 50, I don't know, can anybody do basic maths better than me? The width of those are 50 metres. So what's that, 50 by 150 approximately?
So it's not 50 metres wide.
This here is 50 metres wide.
Yeah, the yellow bit, I mean, is not.
Oh, the yellow bit. Oh, well, I think, the council officer said it was about 850 square metres.
Okay.
Yeah, 875 square metres. So I suppose I never really envisaged that would be left as a building plot.
Because your point is that it's an island.
It's an island anyway. That whole rectangular strip becomes an island when the ecological corridors as mapped in blue in figure 2, you can clearly see that piece of land is an island.
What's the pink strip used for at the moment?
It's used for nothing. That is the area that the council is providing the residents' trees to regenerate into native bush, into native trees. So we've worked, the council's neglected that piece of land, and the residents, because it's inaccessible, you can't actually access that in any way because it's also landlocked. So the residents have I've lived there for 7 years, and the residents have cleared blackberry, we've sprayed gorse, we've planted trees that we've bought ourselves, and through our council parks team and the nursery, they are supporting us to regenerate that land.
So it's not used for nothing, it's a revegetation area.
Oh, well, it's used for, and we hope that, we'll, like I said, it's quite, I know that development has to occur. We know that pine trees aren't the ultimate. Originally we had hoped that that area could be left in the pine trees, where we know, as you can see from my really terrible photo in this one, you can see these lovely little moorporks and all sorts of birds nest there. So that habitat is absolutely going to be decimated. I tried to convince my 10-year-old girl to come in today and let you know her feelings on why she believes that council should leave land for birds to live in so that she will continue to see them and her children will continue to see them. And that's why I'm here, because I feel I have to be able to look her in the eye and say that we, the adults, have done everything we possibly can to at least allow some area for our native birds and our native lizards to continue amongst the development. In this area of land, because it is on the boundary, it borders the council land already. We've shown as residents we're committed to the regeneration. So that is my first point. I know I've only got 15 minutes, so just quickly. The second point is in regards to a request that we made, was asking that not only is it mapped, but there is some specification that if the pine trees come down, that the planting, the native planting to occur, and this is me not probably using the best language because I'm not a biologist, but that it's somehow specified that it needs to be planted in trees that over time would become habitat for those birds. Because otherwise my fear is that if it's left to a developer, they could put in a bunch of scrappy little low-lying grasses that defeats exactly what we're trying to have happen. Again, I'm not an expert on pine trees, but I do know, for example, at Zealandia, they have kept parcels of pine trees for that very reason, and they are a prime example of what you can achieve when you leave habitat for bird species. How much of this actually gets laid out at this particular point of the purpose of the district plan and the structure plan, again, it's not my area of expertise, but my request, and on behalf of our residents, is that we just do everything we possibly can to keep a habitat for those birds who are there, where there are, like, I'm not sure exactly what size the Muri Road block is, but it's, you know, it's a substantial amount of habitat which is going to be lost, and if we can keep this little part for them. So that was under 3.16.1334. So that was just rejected by the officers in its entirety.
And point 3?
Yeah, so point 3, again, this is relating to the ecological connections. In the policies, in our original submission, we sought an amendment to replace the wording which says with a sufficient width scale to read with a minimum width of 50 metres. Our reason for this is because the actual 50-metre width of those ecological connections are specified elsewhere, so we believe that they should be included in that paragraph as well, so that it's absolutely no doubt about the size for ecological connections. And then also we sought an amendment to replace the wording around those ecological connections. It says appropriate mitigation of any severance caused by roads to be replaced by no severance caused by roads. Because as I said earlier, if you sever a contiguous area with a road, it's no longer a contiguous area. And in this particular area, as shown on the map, there's no need for a road because it effectively would be a road to nowhere. So that was why we were seeking that. it was, those 2 points were just rejected. There's no explanation in the officer's report as to why those 2 requests were rejected.
When you say that the, regarding the sufficient width scale, 50 metres, is it the 50 metres has been specified elsewhere? So where else has it been specified?
Under the policies and around the subdivision, in the appendix which talks about ecological connections, it clearly has said earlier in that document that they are to be 50 metres, but then later on it says with a sufficient width scale.
Yeah. Sorry, could you just help, which document are you referring to that said that? Do you know?
It's in the annual plan in the variation, which was what we submitted on, so it would be in the policies,
In the variation.
in the Dev NGP2 subdivision policies. Sorry, I don't have a copy of that with me.
Sorry, just to be clear, did it mention 50 metres or does it say something?
It specifically says 50 metres, which is why I've mapped 50 metres. It's in the policies Dev NGP2 subdivision 5B.
Sorry, just because our version's different, could I get you to show this to the submitter? I can't find the 50 metres.
Oh, it might be earlier in the stuff that talks about ecological connections then. There's a previous area where it speaks about...
So I've just got showing us, maybe that your copy... where you're
I
reading
don't have a
different.
full copy of that
No.
variation.
Could it possibly be the Section 32 report?
It could be the section that talks about the ecological corridor connections.
Right.
Sorry, it is in there somewhere, but I don't have that full document with me.
Mr. Smeaton, are you able to assist us?
Yes. So in the policy, it refers to appropriate width. In the Rule 3, if you look at Clause 1C, I, the scheme plan which identifies the ecological corridor as being no less than 50 metres wide.
So I think it's already nailed, is the answer.
It is there, but it's not in that. Can it not say throughout 50 metres? For consistency, rather than of a sufficient scale?
Excuse me, Mr. Smeaton. Sorry, can you say exactly where the 50 metre?
Yes.
Rule 3,
R3.
R3,
Yep.
1C1.
1C.
Right, here we go.
And so, yes. So we got that sussed. Thank you, Mr. Smeaton. So your issue would be needs to be in the policy for consistency.
For consistency, yeah.
Now, any question? We've been interrupting Ms. Davis while she's been going. Any other questions for her?
I don't have a question. I just want to say thank you for a really detailed submission. There's plenty of information in there for us to look at, whether or not the terms are planning sort of terminology. I think it's very clear to read. Thank you.
Thank you.
Yes, I echo that. I don't think you should feel embarrassed or in any way overwhelmed. Did a good job.
Thank you.
We've got a clear fix on what you're seeking and why you're seeking it, and that's ultimately what we want.
Great, thank you. Nothing else? Lovely, thank you. Thanks for your time. Thank you all for your time.
Thank you. Mr. Morrison, I presume. Hey, we've got 15 minutes and we need to, we'll crib a bit more. So tell us what you would like to tell us.
Okay. My submission essentially covered when I first wrote it.
Can you press the button? It's on there. It's a microphone.
Yeah, I have. It's showing green. Is that right?
You're good?
Yeah.
Just need to be a little closer to you.
Yeah, maybe. Yes, my submission essentially covers two areas. Do you want copies of this, by the way? Would that help you, or would you
Yes,
rather have it for later?
If we could get a copy, that'd be great. That means we won't have to write it, busy writing it down. We can just listen to you.
Okay.
Linda will come around the other way.
I think this is a strong one to cut on there.
That's right. Yes. Please proceed.
Thank you. Yes, my submission essentially covers two areas, the first of which relates to wastewater infrastructure, and the second relates to traffic, transport and roading. In both cases, I point out the pressures that the proposed developments north of Plimmerton will put on adjoining communities, especially the Parramatta community. And I've asked that the adverse effects are recognised and addressed. Firstly, looking at wastewater infrastructure, my submission describes how the existing wastewater system along Mana Esplanade is unable to cope at present, and the adverse effects this is having on the community and the harbour. I've asked that we be assured that no connections would be made from the Plimmerton Farm or Porirua Bay developments to the existing system until the capacity of that system has been adequately enhanced. Now, I notice that the officer's recommendation on this matter is to accept in part that section of my submission, but I'm not sure what that means. Is there, for instance, somewhere in the zillions of pages of the proposed plan or somewhere else that says it cannot happen? The infrastructure report compiled by Envelope Engineering clearly stated that wastewater discharge from the site could not connect to the existing, this is the Porirua Bay site, could not connect to the existing public downstream reticulation without the current capacity issues being addressed. However, the same report then goes on to state that there would be no requirement for council to undertake immediate wholesale upgrades to the downstream reticulation system. So I'm a bit confused and simply ask again for assurances recorded somewhere in the plan or elsewhere that the existing system will be upgraded sufficiently to cope before any further connections from the new developments are made to it. Traffic, transport and roading. This part of my submission relates to those provisions of Plan Change 19 that are likely to result in additional traffic which could adversely affect adjoining communities, and I ask in my submission that those effects not be overlooked. In response to the officer's report, under Part B, District-Wide Matters, states that These concerns are addressed through the provisions of the PDP for connection of sites to the transport network and high trip generating activities, and that's when resource consents are being assessed. My view is that leaving consideration of such concerns until developers apply for resource consents does not seem particularly wise. As described in previous submissions, that the narrow road corridor through Mana was never expected to maintain its current configuration after Transmission Gully opened because of its substandard width. We are hopeful that Waka Kotahi will belatedly honour its commitment to remove the clearways and revert to 2 traffic lanes very soon. We've just been going through a so-called consultation exercise with Waka Kotahi, where there were 5 parties, the Parramatta Plimerton Residents Association and the 2 councils, Boris City Council and Regional Council and Ngāti Tawa, were required to be consulted by Waka Kotahi. Hopefully Waka Kotahi will belatedly honour its commitment to remove the clearways and revert to 2 traffic lanes. But if there is a need to provide 4 lanes in the future, the prospect of having to purchase significant amounts of property in order to meet roading standards should not be ignored at present. As suggested in my submission, it would seem prudent to be increasing setbacks for new buildings on Mana Esplanade at this stage, not reducing them. In fact, I believe that zoning at least the western side of Mana Esplanade for intensification will prove to be a big mistake. Based on previous surveys and my knowledge of the area, I don't believe that Mana residents will want 3-storey or 6-storey apartment buildings going up next to or opposite them, destroying their privacy, reducing their sun and blocking the views that attracted them to Mana in the first place. Nor do I think that people driving, cycling or walking along Mana Esplanade will welcome the oppressive feeling and lack of sun that will result if 3-storey or 6-storey buildings line the road. When the Environment Court was asked to approve the construction of the BP service station on the western side of Mana Esplanade, and I can't remember how many years ago that was, it gave major weight to not obstructing the excellent views of properties on the other side of the road and adjacent slopes. I don't understand why retention of those views is no longer considered a worthy objective. Intensifying housing on already flood-prone areas, thus increasing the number of people affected in future events, is also a concern. During current consultations with interested parties, Waka Kotahi has indicated that it intends, with Porirua City Council, to prepare a strategic plan for the full State Highway 59 corridor, which will consider future growth projects. It seems to me that there's a danger that such strategic planning will be compromised by provisions in the district plan, and it could be seen as irresponsible to be promoting new medium or high density construction within 1.5 metres of Mana Esplanade's road boundaries, when there is a possibility that those boundaries may need to be shifted to accommodate widening of the road in the future. I guess the response to that will be that there's nothing that can be done because such intensification is a government requirement. I don't pretend to be well informed on such matters, but if nothing else, I would ask that my submission in this presentation be seen as just as another expression of concern about the wisdom of such decrees in these sorts of situations. My knowledge of the district plan procedures and government requirements and what mechanisms can be used to add or subtract to the plan is very limited, so I'm really relying on officers or yourself to address my concerns as best you can if you see any substance in them. Thank you for the opportunity of saying that.
Thank you, Mr. Morrison. I ask my colleagues for any questions. Mark?
Thanks, Mr. Morrison. Just have you seen at all the amendments that the staff, this is from a much previous hearing stream where they were talking particularly about the Three Waters chapters which has objectives and policies to, you're supposed to restrict development until such time as wastewater or other infrastructure issues have been addressed.
No,
Have you,
I don't believe so. No, I must admit,
no, that's, as you said, there are gazillions of pages. We had Waka Kotahi present to us the other day about this State Highway 59 strategic plan that they're looking to put together and seeking limitations on developments, particularly Northern Growth Area.
oh, is that right?
So, yeah, so again, it was just whether they've been here and told us what their view is anyway in terms of looking at that, and just whether you'd had the opportunity to look at that at all.
I mean, they've given us their intentions before the consultation started, which
Right,
was
okay.
basically not to do anything with it for an unspecified number of years. They just said within the next few years or something to that effect, which of course didn't go down very well with ourselves or with the Porirua City Council. I don't know whether you've seen the Porirua City Council's submission or response, but basically they weren't prepared for a change, to sit back and wait for a strategic plan to be prepared before doing something with the situation there at the moment.
Okay. Thank you very much.
Any questions, Tim? I understand what you mean about the last point. We need to ponder just how much flexibility we've got, because we'll hear from Kaingora this afternoon, who will tell us we've got very little flexibility.
I imagine so.
Unless we want to increase the intensity, not decrease it.
Well, I don't believe they should be intensifying the construction on that, at least on the western side of the road there at this stage.
Well, I don't have any questions. We appreciate you taking the time to come and talk to us. You've thrown a few little time bombs in our lap, and we'll have to figure out how best we address them.
Thank you very much.
Thank you. We'll adjourn the hearing until 1:30, or when Ms. Keenan arrives, whichever comes first. we'll resume the hearing. We have Ms. Claire Keenan. If you just pass them to the lady on the end, and we'll go from there.
Ko Brad Keenan ia, ko Miriam Munn ia, and I'd like to start by acknowledging mana whenua and saying thank you to the commissioners and to the council members for allowing us a chance to speak. Okay, so before we start, just letting you know, Brad is my husband. He's born and bred in Porirua, and this is his sister, Miriam Munn, both from Te Atiawa descent, and we're here as a team to put forward the submission. So I'm just going to put my timer on, if that's okay.
Hey, feel free, we've started early, so you've already gained 10 minutes.
All right, I won't worry then. Right, why are we here? We are here because, number one, we do not support the introduction of a qualifying matter to the proposed district plan restricting height to manage shading effects on residential slopes that are south-facing, in particular height control shading C. Just being really clear, all good with the ones that are already in the MPSUD around natural heritage sites and sites of significance to iwi, just around the new one. The second thing is that basically the outcome we're seeking is we want the minimum standards that are set out in the original qualifying matters of the MPSUD to be applied to us and our property. So splitting this into a few sections to chat to you around. The first one is around actually the downslope shading as a new qualifying matter. So we don't support the introduction of a new qualifying matter. At the heart for us, it goes to the actual intent of the MPSUD, and in some perverse way proves why we need it, because it's actually said on the MFE website that it's about removing barriers to intensification. And for us, it's also addressing many councils' disabling rather than enabling mindset to land provision. It's acknowledged in the document itself that there will be winners and losers in the implementation. However, the way that it's set out, it promotes transparent and consistent standards to be applied fairly and without prejudice across the motu, and not at the discretion of local bodies. We think that introducing this new qualifying matter goes against the directions provided to territorial authorities by the Ministry for the Environment. In their understanding the RMA EHS general overview, it says under the medium density residential standards that territorial authorities' district plans must include the density standards or standards that include greater development. And I note that this was something that was raised by commissioners earlier on. We also think that the new qualifying matter builds on a case of the uniquely steep and variable terrain of Porirua. That's my paraphrase, not a quote, but I think it gets to the intent. We'd like to note that Wellington and Hutt Valley share the same or steeper topography and have not seen fit to do so. The other thing is I'd like to tautoko Kainga Ora's Karen Williams' submission on points around the shading controls. I think she did a fabulous job. In particular, we agree that the case for sunlight and adjusting height controls in relation to it is overstated. In particular, Mr McIndoe's own indicators of health and wellbeing in the built environment actually says that, curiously, access to sunlight does not feature prominently among wellbeing indices. And also Ms Williams' submissions includes the results of MFE research across 47 studies that show that there's limited evidence linking sunshine on a range of human wellbeing outcomes. So our assertion is this appears to be a rather weak evidence foundation for the introduction of a new qualifying matter, let alone whether or not it is considered in the same standing as the original ones, which again was a point that you made as commissioners. It does appear that Mr McIndoe has articulated a very narrow view of wellbeing. He has dismissed some of the more holistic frameworks, such as Heara Waiora, which I don't think he even mentions, and the Living Standards Framework, which could provide a wider and more robust view. We do acknowledge they're not necessarily that easy to apply to every situation, but I don't think that difficulty means that they should be discounted and an easier option sought. I would also be interested to know what advice has been sought from actual wellbeing experts and any independent peer review that has been undertaken to attest to the quality of thinking and conclusions drawn through this particular process that's resulted in the height variation controls on shaded south-facing slopes. We also think there's a couple of assumptions in the underlying premise. So if people need a certain amount of sunshine per day, and apparently some people can have 3 hours and some people can have 2, which suggests that high-density humans are not quite as important as everyone else, but we'll move on from that. There's an assumption that actually the midwinter sun should only be accessed from inside your house, and, calculated in the middle of winter, in the middle of the day, where some people are at work, quite a proportion I might say, not everybody, and indeed it may be rainy or overcast. We actually believe that daylight is a more reasonable measure and indeed actually precedes the sunlight section of the report. Now, I have searched hard, and if I have failed, and it is there, I apologise in advance to the council members, but I have not been able to find details of the cost-benefit analysis relating solely to the shading aspect. It seems to have been amalgamated with the actual qualifying matters. Happy to be wrong around that, but I've been unable to find it, and if I could, what I would be looking for is the tangible and intangible costs, including the exercise around Mr McIndoe and co, in relation to the benefits expected from the outcome sought, which are listed as percentages of sunshine, anyway. And I'd like to see consideration of the impact of trade-offs. Basically, loss of supply means poorer affordability and basically increased time, financial pressure and stress of dealing with unnecessary administrative overheads. Additionally, not only does this new qualifying matter create inequality of outcomes across the country for people in the same or similar positions, it doesn't actually reflect the thinking in line with changing times. As we will continue to be affected by events like Cyclone Gabrielle, councils need to be focused on managing potential hazards and flooding, which may reduce availability of viable sites for building. As you have fewer viable sites, the ability to intensify and go higher is actually what's going to support us to make maximum use of that viable land. Considerations on how to best utilise sites created through intensification should be managed through the building design and consent process rather than the site process. And forgive me if I haven't got the right language around that, I'm not an expert. I do recall a comment was made by Mr McIndoe that although heating could potentially offset the effects of shading, that not everyone could afford it. We'd like to propose a counter in that the financial argument that costs may be prohibitive for heating also brings into play questions around the affordability of rates, which is directly related to how the council uses ratepayer money, and perhaps lower rates might actually be something to consider rather than a height restriction. Lastly, I'd like to note that stress is a huge contributor to health and wellbeing. Navigating the council processes has proven stressful for us, and there are articles on the internet about other people in the last 3 years who have had a horrible time trying to navigate through things with the councils. I'd also like to take the opportunity to comment on the transparency of PCC processes related to this matter. Before I do that, I'd like to actually note that the people that we have dealt with at the Porirua District Council have invariably been polite and invariably made themselves available. However, we do believe that the process that's been employed here has shown a lack of transparency. It was very difficult to find the information to start with, that we were affected by a height variation control. You had to get into the right plan. When you got into the plan, the default was the shading wasn't there, although it appeared as if it was because it was collapsed under variation 1. You had to open that collapsed panel, you had to tick the height variation that you may not have known was there, and then you got through to understand that your property was on the list. Then, sorry? Once you went into it. Yeah, it wasn't. No, it only came into play on Zoom. To find out what that actually meant when we realised this at the 11th hour last year was even more difficult. You couldn't search under height controls, all the standard things, and I'm a reasonably tech-savvy person. It took me 3 hours to find the McIndoe report and find out. So I think it's been an incredibly difficult process. Currently, even the PCC homepage doesn't feature the proposed district plan. It's got a whole lot of other stuff, and you can only find that if you put that in as a search term. So there's something there about transparency of information. We would say that those properties currently designated as height control variation areas represent a major deviation from the intent of the MPSUD. And we believe too that if the council valued transparency, they would have approached the affected property owners directly. Apparently we're only a select few, to ensure that we were aware of the situation. If I was a betting woman, I would put a lot of money on the fact that there will be people out there who are affected by this but unaware of it, and also unaware of the fact that they've got no right of appeal after this process. We also think that the process for selecting the south-facing sites is based on a GIS plan with solid blue markings indicating the south 15-degree slopes. We actually note that this methodology is not discerning. So we've been looking at the blue blobby diagram, as we call it, quite a lot, and notice that there are marks on there that include 3 concrete steps that go up to our neighbour's property, a small rockery garden about this high, and there is also a line. So we were looking at ours, and there was one place where it went right across the section. The slope at that particular point, just for noting, was 8 degrees, not 15 degrees, as was intended. The council have made no notes or calculations in relation to the decisions made on our property. We know because we've asked. So when we asked what was the process, Mr. Ashland kindly sent us that through. He sent us a map, the blobby picture, and another map with ticks on it. No key. I went back and I said, what do the ticks mean, and are there any notes and actual calculations? I was informed there were not. So I suppose I'm making the point here that I'm not sure that that actually meets the regulations for consent issuing authorities, or at the very least is pretty poor practice and goes again to transparency of PCC processes. It's very hard to argue or to contest something when you have no information to contest unless you find it out just before the hearing. I've got a note here, breathe. So the next thing, and the last thing that I'd like to put on the table here is thinking in relation to our specific property at 35 Terrace Road. I'd like to reiterate that we want the minimum standards that are set out in the original MPSUD to be applied to us and to our property as they are to others around the motu. We actually still contend there are no steep south-facing slopes on our property. PCC's own analysis didn't actually say that the site wasn't steeply south-facing, gosh, that's a mouthful, until after we met with staff to provide them with the topographical. We tried to understand why. Mr. Mackenzie, who was involved in the actual process of determining them, was there but was unable to explain to us that apparently it's not that we're on a slope, it's that we're at the top of a slope. So that was news to us before the hearing. We'd also like to point out that the contours shown in the GIS map in figure 1 of Mr. McIndoe's court evidence that you will have in front of you do not represent original ground levels. It's pretty obvious if you think about the houses that are overlaid in there. So You can see from the shape of the contours themselves and from photos taken before this area was developed, and Brad is going to talk to that a little more shortly. We do concede that any buildings erected at the lower east end of our section would shade the houses below. Notice any buildings. So we've done some modelling ourselves, and no matter what height we or they build, they're going to be shaded on those Vella Road flats. We used actual figures rather than the diagram that was presented by McIndoe. All buildings would shade the houses below. However, that doesn't relate to the slope per se. So that's an interesting thing, right? You have a slope, and then people have to make a building platform. To make a building platform, you have to excavate to a degree, and the degree to which you excavate will create certain drops between properties. We're saying that's not about the slope, because everyone's got to excavate kind of somewhere. People make decisions to either do split level on the slope, or they choose to excavate or build up. So you can actually still see, what this relates to is unconsented excavations conducted at 3 Vella Road to create the building platform. So you can see from the original ground level at the west and south of the property that this has been excavated and reflects the building choice made by the developer at the time. The blue area in blue on the GIS blobby map on the south boundary of our section relates this to a sheer vertical drop. And if we were really being pedantic, and I think the council probably is, around whether or not things are in IPI or on the PDP and all of this kind of thing, a vertical drop doesn't actually have a slope because you don't have a run to divide by, and you cannot divide by 0. It isn't retained, so we can't use the NPS definition of the exterior of a retaining wall either. We have raised concerns about the excavation of the Vella properties with PCC before. There is no record of consent for earthworks for this in the building packet which we have obtained. A PCC staff member advised that they had, quote, not been able to establish the considerations in relation to the cut on the boundary adjacent to 35 Terrace Road, and furthermore that revisiting the decisions made when Vella properties were established is not something we are prepared to undertake. And I do recognise that that is due to them being historic. But when I had a look on the Porirua City Council website, I found that PCC considers everything historic after 5 years, and additionally provides, quote, no mechanism to legitimise unpermitted work before 1991. So we would actually conclude that this building, earthworks, is not legitimate. If we instead use the boundaries of Vella Road, and we actually went with the maximums, right? The maximum drop is 4. At the very skinniest point, it's 7.8 metres, not counting the narrow driveway part. I'm talking about the platform. The slope is actually 12.7%, which goes to my point of, well, when is a slope not a slope? We acknowledge that it does become steeper down the driveway, but again, given some of PCC's own commentary around it, I think we need to recognise that this area is narrow and can't be built on. Therefore, it could be said that the Vella Road property could be considered to be immediately at the top of a steeply south-facing slope. We've done our own calculations based on figure 4 of McIndoe's evidence. I mentioned that before. It makes no difference. And lastly, before I hand over to my husband Brad, I wanted to make sure that I noted that we are unaware of any other options put forward by PCC to ensure maximum use of our section or site. We bought a big section. We thought it would be available. We believe that it's different across the section, and that there is a requirement to see what can be done to maximise utility across the section. While PCC have done that generally across sites, I don't believe they've done it for our site. And just to finish off, Brad's got a couple of things that might actually better illustrate some of the points I've made about our particular property, if that's okay. Go, Brad. Thank you.
Good afternoon, panel and council members. I'm going to try and do hard to and you can see, and that whole is even. After the next set, if you look on plan, but this one, that property there actually excavated. If you look at this old picture, that's the drop-off area at the front. That's a set. Okay.
You're going well. Keep going.
Yeah, so actually this whole the topography marks.
Ours goes to the east.
We can't leave. I mean, it doesn't go past our property. Here I put the yellow line all the way down to here. Did approve. Not consented.
Can I just ask, sorry to interrupt, the one that's been dug out that's on your boundary, is that number 3 Vella Street?
Yes, that's 3 Vella Street.
And the other, the property further down from that,
Yes.
that you show as a whole?
One.
I can't remember, it's Penny.
If I could approach you with this.
Oh, yeah.
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 Or even pass it.
Thank you.
So unless you're going to hurdle,
I'll come out from it, but it doesn't look like we're meant to. Yeah. If you want to have a look, this is the modern day photo, and you can see where our house is, right down the bottom of our property. Not to the south. Yeah. Yeah, 3. Yeah. And so our house is described by the council easy.
Easy to moderate slope on the council records.
We were, it's not my brother's. This is. This is the house at the moment. Angle of the land, which is drawn here at 10%. And yet it's only about 8%. There you can see the same line north.
you mind stepping back and I'll capture this for posterity. Gotcha.
Thank you.
The orange markings.
Ah, good lady.
So the orange markings, that height. Sorry if I pull it back to you here.
Get those two.
So this house here, which is further south than our property, is okay. Okay, this right here. That one's not okay because that's on the edge of the drop off. This is where the hills really starts to drop off here in front of this place, 22 metres south of our boundary. This property here, ours, and the neighbouring property here, they said you can't build on, and yet it's that same slope.
Build
You can
up
see in
on.
this photo, it's all on one side. Right? As you can see, the slope is all the way up. You stand, see down to the bottom. So slope. The slope was the original.
Uncontested and unconsented excavations, which are not legitimate.
If somebody builds, you can do on your property. If there's any question, if you want to have a look at this. You can see where I've put in pink. Okay. Line label to that photo. And that's 22 metres away from our property to the south at 8 degrees maximum. So, you know, it's a pretty flat piece of topography, I think. It's very hard to a fall, but it's not a fall.
So there.
Just,
Yeah, we'd like to thank you for the opportunity to dust off our school C tangent sign and coastline work to see how we can work out
just
the
to
slopes.
clarify for it, it's the, you're saying it's the existing ground level, or sorry, the original ground level rather than the current ground level that should be
Yes,
considered?
because of the
Right.
excavation we've been putting.
Yep, okay. And then,
And I might say that was
Unconsented.
unconsented.
Have no consent for the earthwork.
unconsented by Porirua,
Yes, it was Makara at the time, I think, that became Porirua City.
that require regional consent at the time?
We believe so, although we did ask Porirua City Council if they could provide us a copy of the district scheme at the time. They were unable to. We almost got to the National Library.
How long ago was it?
Morning. The excavation,
Yeah.
1974.
1974. However, as
So
with
it has
the,
been from that an objection, but nothing's been done.
And in relation to your submission, your submission is that you want this height to boundary variation thing, you want that removed in relation to number 35?
We do.
Yep.
Possibly. Yes.
35?
Yes, 35.
Okay, yeah.
and also rather lately, we were actually just objecting to the whole thing besides it being done. And
When you mean more lately, what do you mean?
what I mean is that it has taken us, because of the short amount of time and working full time, working through this process has led us to the conclusion that not only is it not appropriate for 35 Terrace Road, it's not really appropriate in terms of the standards for the MPSUD. So while that wasn't originally part of our submission, and I acknowledge that, as we prepared for this, given the evidence that came to us rather late around it to work with, we've actually come to the conclusion that we actually don't think it's right for anybody. We think it's putting discretion.
You want to amend the submission to say that it's now, you don't want the height in relation to boundary anywhere within the district?
Are we allowed to have more than one? Are we allowed to use this? Is there
Not
an
really,
administrative process?
but you're allowed to raise it, and we've noted that because we have the power to push beyond submissions. And the other thing is that even if it's not in your submission, it's certainly in Kaingora's. But I should note that you've got another problem that you don't know about, and that's we also have a Radio New Zealand submission seeking to impose height limits within effectively a kilometre of the Whitireia radio tower.
Right.
EMF waves, electromagnetic radio waves.
Surprise.
So
Are they giving them to us?
Only if you go too high.
Yeah.
Yes, what I was fumbling around was looking for a map, and I think you are within it.
Awesome.
But like, I know, it's incredibly difficult to keep track of all of the moving parts in this process.
Yes.
Radio waves.
Yeah.
Oh, you have made
No.
you guys.
Oh yeah, it's nice to think we do, but we're also listening to what everybody's telling us, and trying to
Balance everything.
balance everything. But I'll ask my colleagues if they have any questions for you. That so I don't mean to ruin your day, but I thought I couldn't let you leave thinking that this is the only problem in the firmament.
Anyway, thank you for advising us.
Yeah. Keep knocking your head on the wall. don't you?
Yeah, it is.
This is the.
Can I ask what? You can go up to.
That's a good question. It depends on how far you are from the radio tower, and I would need to work that out.
My neighbours.
Depends how high he is.
That would be.
Oh yeah, like I got a fix on where your property was, and I've just got a raw map, but I need to find the right map. So we'll, if we can find the information, we'll let you know.
Council members don't have it to hand. Council members don't have it to hand.
I think that it needs somebody to measure it out.
Okay, awesome.
So we might ask the council to provide us with that information.
They couldn't move the. Well, it's just that.
Yeah.
And it's. Could they actually move the?
Yeah. Yeah. You wish.
Worse than this.
No, but is it?
Well, it's not within our power because it's subject of designation. It's an historic right that they have. They took out the old aerial, but they've got one left. So, so we'll ask the council to measure it and pass that through to you. The reason I'm hedging is because it's a sliding scale. Depending on exactly how far you are from the aerials is what the trigger height is.
Bit like shading.
But we're not.
Anyway, we'll figure it out. It's all
No, yeah,
theoretical at this point.
Yeah. By the looks, you might be 800 or 900 metres. Just
I'll whip up the remove.
200 metre aerial behind barbed wire. Don't want to hear you stuck on the top of that fence. But thank you very much all. I think we've got a fix on your issues, and so we need to ponder it some more.
And possibly a site visit.
And well, they'd say we're open to come and see if we can.
That would be.
Well, will there be anybody home tomorrow afternoon?
We'll make someone home tomorrow.
I'll go home and clean.
No.
They're seeing the section. Okay.
Yes. If we were to say 4:30, team?
Tomorrow, yeah.
Yeah, 4:30 tomorrow.
Thank you very much.
We'll come and see you.
Can I say thank you? Ngā mihi ki a koutou. Tēnā koutou, tēnā koutou, Tēnā koutou katoa. Thank you for your time.
Can I also say thanks to allowing us to have him? Giving us an opportunity. Thank you.
You.
Would you like anyone?
What's this?
Mr. McIntyre,
Like,
Leave this here, okay?
okay.
wouldn't mind, we can.
I've got a photo. I've got a photo of your board.
Yeah, they've got a photo of the board.
Yes, thank you very much.
Thank you.
Thank you.
Have a good afternoon.
It's there. That's interesting. Where are we? We have the Parramatta Residents Association.
Well, one of them.
One of them.
One of them.
That's the bunch, please. That'd be good. Just pass them over the top, and we'll deal with that. I think we're four.
We have had them on designation. Remember that.
Sorry.
I thought I could see a green light, but not the right one.
Just put it on the end.
Okay. Our submissions on the PDP have previously focused on the flawed, ignore the word logic, I changed it to concept. It's a flawed concept of widespread intensification on hillside suburbs and low-lying land, simply because they are claimed to be within the walkable catchment of a rail station. And I say claimed because it's based on cadastral maps and probably a compass. And you're probably aware that hilly suburbs have very winding roads. So what I did, I drove from the Parramatta railway station to my house, just out of interest. It was exactly 1 kilometre. Now, the walkable catchment is supposed to be 810 minutes. I used to walk it every day until my legs gave up. And it used to take about 14 minutes. So why it's within the intensification precinct, I don't know. And there's a lot of other houses around in a similar situation. But that's not what I want to talk about today. I want to talk about the unplanned consequences of this decision. When you look at the PDP, the high density residential and the medium density residential zones, they clause HRZ01 and MRZ01, item 3. They're similar, with different words. A quality built environment that provides for health and safety being of people and communities residing in the zone. An urban environment that is visually attractive, safe, easy to navigate and convenient to access. Okay, this is planning speak. I understand that, but I think we should take off our rose-coloured glasses and have a look at facts. It sounds enticing, but the reality is often different, and I've seen this in my professional work. So I would like to examine the statements in a bit more detail. First one, quality built, visually attractive. The concern here is, as a country, we've had many instances of multi-storey buildings that might look good initially, that's subjective, but they turn out to be leaky, they have building issues, or they turn out to have inadequate seismic resilience. And it must be getting quite tiring for people in this situation, because I've read many news reports of building problems and apartment blocks where owners are generally left to foot the bill. I personally know of 2 people who've been made bankrupt because of this in Auckland, so we're okay in Porirua. But I'm not naive enough to believe it will never happen here. The other aspect of this is three-storey housing sounds a good solution, and I think back to the muse of London, and narrow, tall, brick facades. Now, our buildings tend to be of less durable materials, and they need more external maintenance. They can be difficult to maintain. I know I have one part that is three-storey, and I can't, even with all the scaffolding I've got, I can't safely get up there. And I can't find a painter yet who's prepared to do it. So the major cost is likely to be scaffolding, and I've heard reports from colleagues in Auckland who are talking about townhouses 3 stories tall, built only a few years ago, already looking, and they said, tatty. They need a bit of painting, a bit of maintenance. What I'm concerned about, well, the Parramatta Residents Association is concerned about, is that this PDP will result in future maintenance headaches for Porirua homeowners. And we can kid ourselves that it won't happen in an ideal world, it won't be a problem, but history should tell us that it will be. The second issue is safe and easy to navigate. Leaving a developer to decide how many, if any, off-road parking spaces for residential buildings will inevitably lead to increased parking on the road if other off-road spaces are not provided. It will result in rows of vehicles, creating unsafe driving conditions, especially on the winding roads of our hilly suburbs. I've said corners and cars are not a good mix, particularly when you've got lines of cars and 2 blind corners. And this happens in my suburb every day. One day I'm going to get hit, I know it. It's happening already. Our roads are starting to get clogged. I live in Parramatta, in Kahu Road, driving down Lauderdale Road, Estdale Road, in the 39 years and 6 months I've been there. It's gone from being open to being a dodgem course. And the number of times you meet a car coming on the other side of the road, overtaking vehicles, or when there are vehicles parked opposite each other in contravention of the road code. But it happens frequently. I don't know how buses get through. It's certainly difficult for cars and cycles, and it's not safe. And that's the situation now. It's only going to get worse. I don't believe the lack of off-street parking will deter residents from owning a vehicle. Some might. Problem is, Porirua is not a compact city. It's spread out. People value their transport freedom, and in many cases, it's necessary to get around. In general, public transport is inadequate in this area, and often it's not a viable option to access many locations. The whole focus here is on walking to a railway station which is linear and it goes in 2 directions. There's a lot of places people need to go that are not north or south. They can be east and west. And our east and west traffic, public transport is limited. I'm speaking here from my personal perspective, but a part of this country's appeal to me has always been off-road parking for the majority of houses. It provides a more tranquil environment and it allows unobstructed and safer transport. This will be lost under the NPSUD restrictions. You only have to look at the streets of English towns and cities jammed with parked cars to see the eventual outcome. And I was brought up in a 100 approx housing estate with no off-street parking, terraced houses. In the 50s, the streets were empty. By the 70s, they were clogged, totally clogged. Nobody had an off-road parking space on their property, but it didn't stop them having vehicles. And I don't believe that it will be any different here. There may not be the same vehicles. They may be electric or other mobile means, but they will still be vehicles. Unless qualifying matters are introduced that require off-road parking, Porirua will be expected to cope with the problem through this comprehensive parking management plan. All I can say is best of luck with that. I don't know how you're going to do it, and the people I've spoken to in council don't know either. Yellow lines everywhere is not a complete solution. The other aspect I want to bring up is setbacks under the health and well-being. Again, both the high-density and medium-density residential zones have standards identifying 1.5 metre setback to a road and 1 metre other boundaries. First thing I'd say is a strongly object to Kāinga or as submission to remove even this small setback, particularly on road frontages, and endorse the officer's rejection in section 32, Rory Smeaton, is it? Who wrote it? I'd say well done. Lack of any setback creates practical and privacy issues, and this is already occurring in other parts of New Zealand. I know of two apartment blocks where they're built right onto the footpath, and it's creating real problems. Now, we can argue that 1.5 metre setback is not sufficient or safe in some instances. I don't think it's safe in any, personally, but the association says it might be safe in some instances. And these are front to a major road, and my specific example is Mana Esplanade and St Andrews Road. Front to a road used by heavy vehicles, which may not be, it is those two roads, but may not be. Or front to a road without a footpath. And there are many roads, particular Kahu Road, Kiriwai Road, don't have a footpath on one side of the road. If you end up building multi-storey buildings 1.5 metres back, the noise, the vibration, the fumes will be incredible. In these cases, we submit that a location-specific setback is applied to minimise health and safety impacts on residents. So I think rather than having a overall 1.5 metre setback, there needs to be a qualifying matter. I've made a comment here that the environment was concerned about separation distances on Mana Esplanade for health and safety reasons, and those properties had setbacks of 4 metres or above. Try imagine that situation with 1.5 metre setback. It wasn't agreed by the Environment Court, and I don't think they would like 1.5 metres either. The other issue is setbacks for steep slopes, and I agree with some of what the previous submitters said. Steep slopes, and by steep I'm saying, I would have said greater than 45 degrees, which is the standard angle of repose, but okay, council's going for 34 degrees. I think that's even better, provided that is measured from the horizontal. I'd say that it's not going to be safe or appropriate for any boundary or any, any property to be built within a metre of a boundary that has a steep slope on it. They talked about vertical slopes. That's just crazy. You've seen what happened in Muriwai. They were warned about it in '66, and they built on it in '86, and it collapsed this year. Porirua and much of New Zealand is predominantly clay soils. Not totally, but predominantly. Weather events this year have emphasised how poorly these soils perform on steep slopes under extreme weather events, resulting in major landslips. I just mentioned Muriwai. That's one, but there have been many. And they don't have to be vertical slips or very steep slips. They can be 60 degrees. It depends on what happens at the bottom. It depends what happens at the top, the structure of the soils, and what's on the soils. Large trees and bushes, etc., can bring it all down. We don't want this risk to people and property repeated in Porirua. You've seen what's happened around the country in the last few months Don't make the mistake here, please. So we submit that the PDP, maybe in the earthworks section, should require an engineering impact assessment of slope stability and a recommended setback above and below the slope, so, because landslides can affect people below as well, of height and angle that exceed permitted thresholds. So there could be cases where the permitted thresholds are still a problem, but it's not going to be that common, I wouldn't think. I'm speaking here as a professional engineer, but not as an expert, so don't take that as expert witness. Under health and well-being, I'd like to talk about natural hazards and climate change. Section 32 report, natural hazards, identifies the need to consider health and safety, social, cultural, economic well-being under Section 5 of the RMA. And also notes that councils are obligated to recognise and provide for the management of significant risk of natural hazards. A whole range of natural hazards are identified, but it doesn't cover in detail, any kind of detail, natural hazards of liquefaction or slope stability, which I think is a mistake. The Building Act and liquefaction may not go far enough. I'm concerned about slope stability. It's said to be covered when a resource consent is triggered for earthworks, and I don't think that's adequate. However, it does not cover situations where earthwork... Am I reading the right page here? Yeah? Okay. It's been a few hours since I read it. It doesn't cover a situation where earthworks consent is not triggered, but the slope has been modified in some way and the slope's compromised. And a typical example of this is manipulation of the toe of the slope, undercutting or cutting back. A report was written in... I note that the Section 32 report was written in August 2020 based on best practice guidelines available. We submit that recent extreme weather events show that a stronger emphasis on slope stability is needed in the PDP to mitigate risk to people and property. I've also talked about the PDP strategic directions about no significant increase in risk from natural hazards. What does that actually mean? If you think about it, it's a rather strange comment. If you put more people into an area, you're increasing the risk if the area has a natural hazard risk. The regional policy statement says that we should seek to avoid inappropriate subdivision development in areas at high risk from natural hazards. The NPSUD Policy 6, Clause E says, decision makers have particular regard to the likely current and future effects of climate change. So it's fairly clear climate change is an issue and it's something we need to make ourselves aware of. So we ask the question, why is Mana Esplanade and St Andrews Road considered suitable for high-density intensification? Yes, the area meets the mandated criteria for access to rapid transport, but have a look at the hazard overlays provided when you can find them, and the previous submitters mentioned how difficult it was to find. I'm used to looking at those maps, and I had difficulty too. But I did find them. It didn't take me more than 2 hours. The south end of Mana Esplanade is adjacent to the Porirua Fault. I mean, that's common knowledge. Parts of the Mana Esplanade and St Andrews Road flood heavily in major rain events. That's well known. These areas are clearly in a potential tsunami zone. Well, the maps say it is. We hope it never happens. Future impacts from sea level rise with increased coastal inundation and erosion, ground level water level rise. Those are and impact of sea level rise is definitely a big issue for Mount Esplanade and St Andrews Road. Increased potential for liquefaction with a high water table. It's not mentioned, but this is going to potentially be a future problem. And Goat Point is an area of high slopes to instability, and it always has been. And you've got houses just to the north of Goat Point that are identified as high density, 6 stories plus. That is just crazy. They back right up to that very steep slope and right next to the meters away from the road. The question is whether it is sensible to focus only on the requirements of the NPSUD, Policy 3, and ignore the obvious natural hazards that exist now and in the future. Is the Council willing to consider a future of managed retreat and compensation? And my final comment, I'd like to make the point that more residential intensification, whether medium or high density, will mean less areas of permeable surfaces and more runoff, leading to increased risk of flooding, particularly runoff from the hill suburbs. Water neutrality is a great, laudable aim. Don't disregard that, but it will be difficult to achieve in hilly areas with clay soils and sloping ground. Clay doesn't absorb a lot of water, and swales don't work on I don't know what the exact angle of the ground is, but certainly steeper ground doesn't work with swales. Swales don't perform well either, and soak pits are another option, but soak pits can also lead to landslip. Build up the water pressure behind that steep surface, and with clay overburden, it'll just collapse.
Thank you, Mr. Shaw. I didn't have any questions. Commissioner Sinclair?
No, that's very clear. Thank you.
I get off lightly. Great.
No questions from me, Martin.
No questions from me either.
Hey, me too.
Thank you very much.
Hey, drew the lucky straw.
I did, didn't I? Bit different from the last time. But I appreciate that. Thank you.
Thank you, Kia ora. We have next Mr. Alan Collett. Is that you on the line? Oh, no, you're in the back row. Mr. Collett. Good afternoon, sir. What can we do for you?
I believe Mr. McDonald saw fit to something I find quite perplexing, given the larger agencies, and it makes me feel. And the hazards there. During my 15 minutes. The email. Oh, sorry. Thank you. The emails were attached with my submission, but I can provide them later if it's required.
Can you provide us with a copy of that script so we don't have to write everything down you say?
I can leave it with you.
If you could leave, if you could just email it to the hearing manager afterwards, that would be fine.
Yep, that's fine. I wish to make it clear to the room that my submission is not based around climate change denial. I don't want to go down that rabbit hole. I'm calling the methodology of the flood mapping into question, and I want to concentrate on that. So the hearing panel has been forewarned of my submission on day one of the hearing. However, I feel this was done to mislead the hearing panel slightly. Mr. Osborne and Mr. McDonald led you to believe that my main concern was the representation of the topography of Grey Street and how it related to the modelling and my property. This was my initial concern. However, during the course of my investigations, I discovered and highlighted that it was the as-built drainage data that was used to build the modelling that was flawed and incorrect. And my reference to topography is essentially now a moot point. This is evident in the emails between myself and Mr Osborne between August and October 2022. And on the 4th of October, Mr Osborne emails Mr McDonald and myself and other parties that the online GIS information in regards to drainage was wrong and the modelling would need to be updated. I can only assume that this updating of the modelling had a dramatic effect as the extensive flood inundation of Pukemery Way and Grey Street was removed completely from the mapping. You would have seen this in figures 10 and 11 of Mr Osborne's evidence presented to you on day one. I feel Mr Osborne and Mr McDonald did not adequately explain this to you in the hearing on day one, and hence my suspicion that you are being slightly misled around my concerns and that they were more focusing on the topography. I think one of the panel members actually questioned Mr Osborne, and he replied that the change in the sump leads, the sizing, didn't make a difference in the modelling. Yet we see that all the inundated flood mapping has been removed from those two streets because of what I highlighted to them. However, it was then seen fit to put an overland flow path on my property, and this was expressed to you in figure 11 of Mr Osborne's evidence on day one. Mr Osborne states that the overland flow path is necessary in the event of network blockages or the inability to carry runoff in an extreme event. The Porirua Bay Stormwater Catchment Model Build Report clearly outlines the assumptions that were applied in its development. 3.6.2 hydraulic model assumptions clearly states that pipes are blockage and sediment free, inlets, outlets and sumps are blockage and sediment free. I provided evidence via email to Mr Osborne and in my submission that the sumps outside my property are served by a 300mm stormwater main. And using the Hazen-William equation for flow, highlighted that this section of drainage has a 5.5 cubic metre per minute outfall at termination. Now that is a substantial amount of capacity, and the drain has a more than adequate gradient from a drain laying point of view. In fact, it's quite steep. An email reply to me after I highlighted this drainage information on the 13th of September from Mr Osborne states, I agree that the drainage through the stormwater network would not be impeded by flow in the downstream channel to a degree that it causes the sumps to surcharge. In our modelling, however, the sumps are surcharging because of the small diameter sump leads that have been applied. Now, I've already proven those sump leads to be incorrect.
Scott, can I clarify when you're saying the incorrect? What are they showing on the, just what's the number shown on the plan and what's the number that you...
So if you look at the GIS Council website, it shows a 100mm lead from the sump going to a 300mm stormwater main drain.
Yep.
Through the course of my correspondence, I narrowed them down as to why the inundated flooding was on my property, and I've got evidence from Mr Osborne it's because of the size of those sump leads at 100mm.
Right.
I then physically lifted the manhole covers and the stormwater covers. I'm a drain layer by trade, and I discovered those leads are actually 300mm capacity.
Okay.
Treble what they modelled for.
300. So that's the leads. Does that flow into a
300mm main?
It
Yeah.
goes from, so 300mm leads into...
To our 300mm drain. Yeah.
Yep, okay, thank you.
And I've got clear evidence via the email correspondence that the modelling was based on 100mm leads.
Right, okay.
That covers my next point, which it's important to note that the leads are 300, not 100, as was modelled. So given that the modelling assumptions are that drainage systems are blockage and sediment free, as I've highlighted, and Mr Osborne's statement I have referred to above in email correspondence, how do I now find an overland flow path on my property due to network blockages and runoff inability? This seems to be now steering away from past explanations and methodology. The questions also need to be asked that does the cul-de-sac and Pukemery Way have the same overland flow path methodology applied to it? He does not reflect that in his evidence. or any other street in Porirua for that matter? Has an investigation been carried out as to how much incorrect GIS drainage data has been applied to this modelling throughout the Porirua City area? The models are validated through recorded events, as Mr Osborne stated to you on day one. Yet what recorded flooding events exist in the vicinity of Grey Street and Pukemiri Way? Porirua City Council is flippant in its responses on its flooding mapping Q&A page on its website when it comes to insurance coverage and the impact these flood hazards will have on property values. These are real concerns of ratepayers and should be more considered when applying flood mapping on existing properties. Especially so post what we have seen in the North Island recently. And that will lead, I am sure, to changes in attitudes from insurance companies in regards to coverage for householders. I encountered this when myself and my partner bought the property in 2013 because of recent set-in and Kaikoura quakes, and IAG put a freeze on Wellington insurance for houses. We were caught in the middle of unconditional settlement, and we found ourselves in a position where we couldn't get insurance. We were lucky the lending bank took pity on us and provided us the insurance we needed to seal the purchase. So these are real issues for people and constituents, and I just feel that this mapping and modelling has not taken a lot of stuff into true account, and I've shown that there has been flawed data into that modelling. Thank you.
Thank you, Mr Collett. As I say, before I forget, please email your script to the hearing administrator. She'll distribute it to us. Any questions, Commissioner Sinclair?
So just to be clear, Mr Collett, that the changes that you've identified in terms of what the actual correct leads and the main drain size are, that's, as you understand, that hasn't been accounted for in the model change, that hasn't been accounted in the model, and therefore that if that is included, it might mean that you wouldn't have the overland flow.
I think in Mr Osborne's evidence that he gave to you on day one, it has been taken into account.
Right.
So there was the whole of Grey Street and a big part of Pukemiri Way had inundation mapping on it prior to that change. That inundation mapping has now all disappeared.
Right.
Except for my cul-de-sac and an overland flow path down the side of my boundary.
Right.
Based on blockages.
Right.
And the inability for runoff.
And you're saying earlier that the blockages, given that earlier report, say that they shouldn't be taken account of.
Yep.
And
it was a modelling assumption.
Why is it?
Why is it now suddenly being applied to me? And if it is applied to me and it is the way they're going, then how many other properties are they applying it to? Are they reviewing everything across the Porirua City catchment?
Thank you.
Mr Williams?
No questions.
Questions? No questions. Nor have I think pretty clear.
Yep.
Where are you coming from, Mr Collett?
Yep. Thank you very much.
Thank you. Representatives of Araputama?
That'll be the guy on the line.
Mr Dale? Microphone, Mr Dale. You out there? Can't hear you.
invaluable.
Still nothing, Mr Dale? Yep. Still nothing?
No. Going out and coming again, suggestion maybe?
Why don't you back out and come back in again? What? Can you hear us?
He's unmuted.
What's this?
He's unmuted.
He is unmuted. So what's the system?
Mr Dale, can you hear us? Can you nod if you can? So he's not hearing us either.
Send him a text message. Out and come back in again.
Don't need this. Any progress? No. I think. Do you have a phone number you can call? Are you in phone contact with him? Still zip. Okay, can you ask him if he could come in at 1 o'clock tomorrow afternoon? We'll have another go. You hear us? No.
Yes.
Yes. We can hear you. Yes.
Oh, he can't hear us.
Dale. We can
We can hear you. Can you tell him we can hear him?
In case.
And just tell him to proceed, and we'll send him written questions if we have any.
Can you hear me now?
Yes.
Yes.
Yes, we can.
Can someone write yes or no?
Can you hear us?
Sorry, I can't hear you now. So if you can hear me, that's great, but I cannot hear you.
Just testing the audio. Yep, we're sending.
So the it's in his machine somewhere. Can you just ask him to present, and we'll send him written questions.
So can I just check that you can hear me? Great, thank you. I can actually hear you now, so something seems to have be corrected. So I think we might be good.
We've spent a bit of time, Mr. Dale. So if you can hear us, we can hear you. Please.
Brilliant. Okay. In the interests of efficiency, I'm quite happy not to read a summary. I do note that myself and the reporting planner following the issuing of the supplementary evidence are now in full agreement on all matters. So I'm quite happy to proceed to questions if that would assist.
Yes, it would assist. Thank you. The sole question I have is that it seems the reporting planner now accepts that correction facilities can have activities that are appropriate for an industrial zone. The question for you, Mr. Dale, is should a distinction be made in different types of correction facilities? As you say, there are activities on correction sites that are appropriate for industrial zones, but I equally foresee that there might be activities that are not appropriate for industrial zones. Should a distinction be made between the two? Is that even practical?
In my view, it's firstly unnecessary to do that. Community corrections facilities, in my view, are an appropriate activity in industrial zones. As I have said in my evidence, there's multiple examples nationally where community corrections activities are both located in industrial environments and also permitted by way of district plans in industrial environments. Because of the nature of community corrections facilities, which do have an industrial type component with them, I consider that they are therefore an appropriate activity. I do acknowledge that community corrections activities do have an office-based component to them, which could be seen as potentially at odds with some industrial environments, and in particular more heavy ones. I don't believe that is the case here in regard to the general industrial zone proposed under the Porirua plan. Looking at that zone, I do note that ancillary offices are enabled as a permitted activity, and I think also given that corrections current facility in Porirua is in a general industrial zone in an area which has activities around it which I consider are compatible, is evidence of it being appropriate in that zone.
Thank you, Mr Dale. I'll ask my colleagues if they have any questions.
No questions.
Just two, Mr Dale, it's Commissioner McMahon speaking. Just two questions from me. The first is, the department presumably don't seek to designate these sites in district plans, as opposed to full correction type facilities, like such as...
That's correct. There are some examples of community correction sites that are designated, but they are historical situations, and currently corrections does not seek to use that mechanism to enable new community corrections facilities.
Okay, thank you for that. And my second and final question was, as you alluded to, there seems to be a high level of agreement now between the 42A officer and yourself. Does that necessitate any changes to the policy framework to ensure that the policies align with the activity status? Have you given that any thought?
I have, and I don't believe there are no changes required. I think that the current objectives and policies have a focus on obviously protecting the industrial zones for industrial activities, but they also do enable non-industrial activities where they are compatible.
Yes.
And in my view, in this case, they are compatible, and therefore there is no required change to that policy framework.
Thank you. And it just strikes me of one final question along the same lines. Any changes to definitions required consequently, or are we governed largely by what's in the national planning standards?
That's correct. There was a definition of community corrections activity. It's in the national planning standards, and that was part of Potama's submission on the PDP and was addressed through one of the earlier hearing streams.
Okay. Thank you. Thank you for that, Mr Dale.
I think that's it from us, Mr Dale. After a slow start, it's fast finish.
Yeah, my apologies for technical issues. It's good that we got there in the end. Thank you.
You get that in the big jobs.
Thank you.
Thank you very much. We have the representatives of Mana Whenua.
Tēnā koutou katoa, ngā mihi nui kia koutou katoa. Ko Waiaho, ko Karadins te Moana, ko Kashkar te Maunga, ko Lazme Adige te Turkishewi, ko Honorakdam Lewis Tokungoa. No Porirua hau, and ko kai whakamahere o te runanga o tō rangatira. Good afternoon, Commissioners. I would like to acknowledge Jada Howard here, who came with me today to tōtoko our planning, Ngāti Toa Planning Kōpapa. Jada is our junior planner, and myself as the principal planner for Ngāti Toa standing in today. So thank you very much for being able to speak to our submission, OS114, and for listening to our whakaaro. So kei te minui. I'll make 14 points today, and all points will be made as they relate to our submission, so in no order necessarily, and in the same order they were written, dated 16th of September 2022. So first thing first, I won't necessarily repeat the contents of our submission word for word. Instead, I will make some fundamental points that this process must address. All right, so the first thing is it was quite disappointing, and in some places, actually, I'm going to use the kupu cringeworthy to read the Section 42 reports. And a bit of a background, we have given quite expansive and comprehensive planning advice regarding the feedback and the content that the planning officers in Porirua regarding the proposed plan and the plan variation. And reading how our submission have been considered and all the advice were provided, but the most important of all, how our submission was interpreted, is quite deeply disappointing to see. But now that's out of the way, I'll start with our first point. We oppose the wording of PFZ 04 and the content of what goes into defining a well-functioning environment. We understand this wording is a copy and paste of the National Policy Statement, Urban Development Objective 1, but given effect to urban development, NPS shouldn't be a copy and paste exercise. So if the meaning is maintained and the content of the objective can be improved, there's no one, including the MFE, can stop anyone doing better or wording better and the MB. So we oppose that Objective 1 puts our aspirations into words poorly, and we believe that when we have all communities in there, looks like no good attention was paid as to how Mana Whenua wants to see a well-functioning urban environment. So we asked this to be amended from its current form to a text that says a well-functioning urban environment that enables members of Mana Whenua, all people and communities to provide for their environmental, social, economic and cultural well-being, and for their health and safety now and into the future. So we request also environmental well-being added into this objective. We are our environment, and if the tire is sick, we are sick also. This includes things like, pipes falling apart and our stormwater is mixing up with our wastewater in Porirua. So just because NPS UD writers didn't click on the fact that socioeconomic well-being cannot be achieved without adding environmental well-being, we won't accept the poor and literal implementation of it. So cultural well-being, if it was meant to refer to Mana Whenua, certainly cannot be achieved without environmental well-being. We don't accept this wording, not just in Plimmerton Farm Zone chapter, but in all other parts of the plan, the clauses mentioned, similar clauses mentioned. So copying and pasting, writing provisions without considering what they cover and don't isn't mentioned in Section 42 reports, but we reject this way of logic making and planning. PFZ 05, so housing choice objective, and any other part in the variation one actually that deals with the housing choices also seems to be slightly problematic. So PFZ 05 housing choice that says precincts A and B provide for a variety of housing types and sizes that respond to housing needs and demand and the neighbourhood's planned urban built character, including 3-story buildings. So this proposed clause is such a social and colonial construct, and the phrases such as planned urban built environment, neighbourhood, housing type, and housing size, they never fully reflect how iwi and Māori wants to live. So we're not only in the opinion that the genericness of this objective makes it so open to interpretation, but its vagueness of it also makes us question whether a papakainga is included in this objective or not. And more importantly, whether a neighbourhood, because how it looks and feels, reflecting a te ao Pākehā housing, can actually absorb or take a papakainga development because it's so different how the neighbourhood is, which may blatantly dismiss papakainga. So we ask Mana Whenua housing choices being explicitly recognised in this objective so that any neighbourhood-based proposition doesn't discriminate papakainga type of housing choices in Porirua. And since this is such a highly interpretive space for consent planners, we suggest adding new policies and rules that support papakainga activities in the zone. So we're not seeing any papakainga necessarily supported in the zone either. So that brings me into the second point, is about the Ngāti Toa zone that you'll see in the Section 42 reports. So implementing National Policy Statement Urban Development Policy 3, meaning that upzoning areas in Porirua and giving effect to high density and medium density clauses generate an issue for Ngāti Toa and for the lands that we were given and that was returned to iwi and runanga as part of their cultural redress. So obviously we didn't have any say in the initial zoning of these lands, and now a proposed district plan or any operative district plan can come in and have the power to allow or disallow particular zoning, and it has no extraordinary powers on the lands that are returned to iwi as part of their settlement. We really object to this way of operation. So, and we refuse and reject any arbitrary requirements such as zoning and such imposition as brought via district plans. So this brings me to talk about the suggestion we made about a Ngāti Toa zone in our submission. So we raised this very point in our conversations with council planners as well regarding to high density and medium density rules coming into place. Since some of our sites of significance are not in the proposed and or operative district plan schedule for protection, improvement and management, NPS UD requirements coming into place with no appeal powers, we raised the issue how this could negatively actually affect us. And we suggested one way to deal with this risk is identifying a Ngāti Toa zone. That means a map overlay, a tangible map. We had communications as regards to what we exactly meant. So it's quite disappointing that this wasn't well understood in the Section 42 reports. We're not tired of explaining though, so I'm going to sort of explain and happy to take any questions what that means. Here's what Ngāti Toa zone means in Porirua. So we don't want developers to pick a site in Porirua and develop without knowing that it's the site's significance, or a site that is adjacent to what we already own or will own or develop and protect in the future. So we don't want land users or applicants to further subdivide in areas that are ring-fenced or for our use or allocated for the activities that we may choose to do on our land. We would also like members of public, including developers and land users and the Crown, when they hop on to look at the maps in the operative district plan, clearly identify and detect the Ngāti Toa whenua. And think how their activities actually could impact on the land we own or we might own in the future, regardless of how mana whenua wants to use that land in the future. So all sites in our deed of settlement are our SASMs, but not all SASMs are to be strictly protected from development in Porirua. So the way that current district plan proposed and operative views these doesn't necessarily deliver for what our people want from this chapter provisions. So given that not all our sites are in the district plan, Schedule 6, we made this point quite many of times, and we don't mind doing it again. A plan change needs to happen to include the sites that are not in the schedule as soon as possible. Sites of significance are a qualifying matter under the National Policy Statement Urban Development because they go under Section 6 of the RMA. Proposed and operative plan doesn't necessarily include all of our sites in a cultural landscape approach. So we suggested that an overlay map of Ngāti Toa zone should be generated to better address the issues I summarised just now. This map should include all the land that is specified in our Deed of Settlement Act, and this zone should be defined as a zone where Ngāti Toa has uninhibited tino rangatiratanga and mana is the mana whenua. This land includes the sites Ngāti Toa may want to develop in the future or preserve. And we are also more than happy to co-write the accompanying provisions for this overlay and generate a chapter in the plan. So that's the Ngāti Toa zone points that I wanted to make, which is quite substantial for the whole plan. The third point is about the general industrial zone. We are quite frustrated the plan chapters do not really speak to each other and don't necessarily make the connections such as the activities that are occurring in the specific zones, such as the general industrial zone, and its relationships of the zone and impacts to its environs. For instance, so GIZ P2 is too narrow-minded in the sense that an inappropriate use and development of the zone could have included, for instance, undertaking activities that might have negative outcomes for taiao, for streams and forests. So we asked that GIZ02 to spell out all of our sites' significance and any site we might own in the future as per our deed of settlement. The Objective 2 Clause 3 should acknowledge also our sites as well as the amenity values that it refers to, because amenity values ultimately includes the cultural values. It should say, for instance, buildings and outdoor storage areas that are designed and located to maintain the cultural, environmental, and amenity values of adjacent residential, open space, recreation, and Ngāti Toa zones. The policy 2 in the same zone is fundamentally hard to change as it only mentions the inappropriate use and development from a non-industrial activity perspective. And the rules under the chapter do not necessarily address what is an inappropriate development within an industrial activity perspective, and if it falls onto a SASM, such as the Mitchell Stream. Nor the chapter triggers discretionary or restricted discretionary status for sites specifically important in Ngāti Toa Rangatira, and these connections need to be made obvious to consent applicants, and if needed, trigger engagement process with us. My 4th point is about the high-density residential zone. We oppose the way that the proposed plan is taking liberty identifying minimum square metres for a Papakainga community and commercial activity floors, and that is based on a centre's hierarchy economic concern. I will refute these arguments and pick this matter up in a second, but I'd like to quote it on the sites and areas of significance, again, falling onto the high-density residential zones. Since the HRZ will have immediate legal effect, we are concerned and quite uncomfortable the way in which the rules and standards under this chapter may kind of bulldoze their way into many things we value without too much questioning and deliberation. One of the most important example of that is that we, for instance, lost the opportunity kind of to have a full schedule of SESMs in Porirua for the proposed plan. And in the absence of a full picture of our sites, nobody is in a state to argue against the development that will come on an officer's desk tomorrow after this goes through because of the no appeal power. We won't even know about it, and Joe Block would in no way be in a position to bear this cost and liability either. So because council hasn't identified them in full, and as well as the rules and standards that could go into the relevant chapter. So as you know, the chapter currently provides high protection for these sites. My fifth point is about the large format retail zone. And as stated in detail in our submission, the zone provisions have little regard or linkage or reference to the quality of our taio and intrinsic values of Te Awarua or Porirua. For instance, the intro text in that chapter that says, zone chapter that says, the design of new buildings and the design and landscaping of open spaces is of importance to achieving a high quality built urban environment in the zone. Any new development facing Te Awarua or Porirua Harbour and Porirua Stream will also need to address and, where possible, enhance the relationship to the harbour and stream. So this phrase is quite heartbreaking, like if you look at it from a mana whenua perspective, as it means to say the harbour is only instrumental to the way that things look and how the plan could achieve a great urban environment. Nobody talks about how harbour will feel about this, or Porirua Stream is asking the same question if only if it had a tongue. So it is disappointing to see these clauses, such as LFRZ 03, as written for managing the scale of use and development at the zone interface, and doesn't even have a single word on the environmental values and quality of the harbour and the Porirua Stream. So if the harbour smells awful and its water look like sewage brown and toxic green all the time, there's no amenity values there. So we really need to have these values incorporated into these clauses. So we oppose how the large format retail zone Objective 2 and Objective 3 is worded around amenity values in a way that distances the view of environment and the environmental quality. So these proposed changes and suggestions of the current wording potentially won't mean anything to developers or land users. They're quite fuzzy objectives to people who are not planners, and which no one would have clear understanding of how they will be implemented in consent process. So resource consent planners are invited to interpret them in return, the policy, and define many concepts such as this, enhancing relationships, which is too much of a liability for them to bear as well. So in our submission, we suggested strong and clear wording of the large format retail zone policy 8 in clause 3. So that said, where applicable, enhances the connection to Te Awarua, Porirua Harbour and Porirua Stream, and addresses potential impacts on the openness and historical and cultural values of these water bodies. So, for instance, it's not where applicable. It applies all the time whenever someone does something within a catchment that our harbour is sitting on. So it's not potential impacts, it will impact on our harbour. And it did so in so many years and decades now. It's not enhancing the connection, and it's not going to come naturally to Joe Block how to enhance this connection, because they might not even know what the connection is. So I'll leave it at that. The next point that I'll make for the zone is, as I previously made, which I'll come to that point in detail, is that we do oppose the arbitrary calculations of papakainga floors based on which zone they're based in and what activities they allow for. And I think this is completely a planning judgment matter, and that was done in the absence of mana whenua engaging on the matter previously, an engagement in the sense that providing numerical evidence to mana whenua how this judgment was reached towards. And I note again, I'll come to this matter in a sec, just bear with me after coming to this zone chapters. The sixth point is local centre zone. We oppose the way in which this chapter worded all over, especially specific sites have been identified where additional controls are necessary, but somewhat these are just physical heritage items and heritage sites, not the sites in areas of significance, and the interface with local centre zone and the sites in areas of significance are poorly phrased. The standards outlined in the chapter provide for instance, the heights and boundaries for sites that provide heritage values to the site, but they're quite silent if they're SASMs. For instance, say, what is the standard, as if they're blocking the views to our moana and awa. The 7th point is about the medium density residential zone. And as I mentioned earlier about my speech point on the high density residential zone, the speed in which to map and give immediate legal effect to MDRZ as part of the NPSUD is quite disappointing, because we don't see if the sufficient care was taken to understand the overlay of the MDRZ and how it impacts to the land development aspirations of Ngāti Toa. And this is why I will reiterate the point of having a Ngāti Toa zone, as we do not want a plan that imposes the littlest gross floor area for our papakainga developments, because they happen to fall on a medium density residential zoning overlay. We think the fact that MDRZ overlay overrules a papakainga, or may end up doing so, is quite unacceptable. The 8th point is about the metropolitan city centre zone. So the whole Porirua is a site of significance to Ngāti Toa Rangatira. The fact that appropriate activities are defined under MCCZP1 is quite ironic. We would like this chapter to be reviewed once the sites and areas of significance chapter is kind of concluded for. With the SASM plan change, we expect the sites to have a cultural landscape approach. With areas that have multiple polygons, we would like to use the opportunity how we want metropolitan city centre zone to interact with our cultural landscapes. The 9th point is the mixed-use zone. For us, mixed-use zone overlay, like the other zones, as I've just spoken about, doesn't establish great connection how our sites will be treated. We oppose any further damage or heavy modification that the implementation of this chapter could cause to our sites, just because the stuff under this zone is already acknowledged that it will encapsulate medium density and high density rules. We think that's not acceptable. The interface with our sites in the zone is vague, and like I said, in the absence of a new SASM overlay updated, we cannot be confident how these interactions will need to be managed and how Ngāti Toa is going to be aware of these changes happening in their own rohe in the first place. The 10th point is our comments regarding the neighbourhood centre zone. These are quite similar to what I've just said with the previous zone interfaces. We're not seeing clear instructions how the interactions will be undertaken in the with SASMs. Neighbourhood centre zone is another overlay in which the council took the liberty to identify a floor area that is too small for papakainga developments and arbitrarily reduce the numbers on the basis that neighbourhood zone has specific activity purposes. Forgetting that these purposes are socially constructed and hasn't really served well to Ngāti Toa in the past necessarily, because they're desktop theories. These theories, as explained in the Section 42 report, are all based on the centre's hierarchy. Now, I finally can talk about this. So this finally brings me to the issue of different and inconsistent community and commercial papakainga floor areas that are permitted in the plan. So in 2017, New Zealand Productivity Commission has prepared a report, released a report. It's called the Better Urban Planning. It's a 500-something odd page report. It's pretty cool. In this report, centre's hierarchy is refuted pretty well. And I'm going to talk about this as an example to disagree how it relates to the minimum floor levels proposed for papakainga in different zones. So the Commission's report says, and I quote, centre policies aim to direct retail and commercial activity towards specific areas, typically those where such activity currently takes place. Such policies often also seek to maintain a hierarchy of centres with the central business district at the top. Centre policies generally involve more restrictive activity classifications on commercial development outside designated centres and controls on the type of activities that can occur within the centres. Centres policies are common in Australian, British and New Zealand planning systems. 2/3 of the respondents to the Commission's, that's Productivity Commission, survey of local authorities said they had policies in place that restrict the development of large format retail or other commercial activity outside centres. Local and international experience with centres policies suggests that they often fail to achieve their objectives and can have negative economic impacts. For instance, in Auckland, a 2007 evaluation of the regional growth strategy noted that capacity for residential and business development was available within designated centres, but was not being taken up. The evaluation also noted that intensive housing was emerging outside intended centres and in business zones which had larger sites, fewer rules and less community resistance, or in areas of high amenity. The Commission brings some further beautiful questioning to centres hierarchy, a system iwi and Māori didn't sign up for or being asked to comment in the first place. And I quote, again from this report, Cheshire, Hilbert and Cuplinish compared English, Welsh, Scottish and Northern Irish planning policies and estimated an aggregate loss of total factor productivity of more than 20% on average since the late 1980s as a result of planning policies and their applications by local planning authorities. Noting widespread evidence that total factor productivity rises with store sizes, Cheshire concluded that there were good reasons to think that planning policies, in particular town centre first policies, directly cause a significant reduction in total productivity in retail. So why am I talking about this? Because we refute all the arguments made against why Papakainga commercial floors shouldn't exceed 100 square metres because of the centre's hierarchy. In Section 42 reports, there are plenty of evidence and papers written why we shouldn't base the numbers on a socially constructed system. Under the residential zone objectives and policies, we need sites in areas of significance again as a qualifying method to come across clearer and more succinctly. My next point is about the urban form and development. It is somewhat surprising that the whole urban form and development section of the proposed plan doesn't even mention once how the urban form and development could, and in some obvious instances, should occur in accordance with Te Ao Māori and he tikanga e matauranga ki te Ngāti Toa Rangatira. We oppose the way in which current UFD section is crafted, and we ask the section to include an entire separate objective that outlines and states urban form in Porirua is informed by mana whenua and inspired to indigenize the spaces that are important in Ngāti Toa Rangatira. The 13th point is the subdivision point. We oppose the policies from 1 to 7 in the subdivision chapter. Policies 1 to 3 have the potential to impact negatively how iwi would like to develop lands that are returned to them in different titles and iwi land ownership patterns. Since these provisions and the phrases such as creation of allotments, boundary adjustments, and update of cross-lease titles doesn't necessarily mention the alternative ways of owning and developing land, it is assumed they serve the iwi and Māori land development. Policy 4 doesn't recognise, for instance, allowing further subdivision contributes to negative impacts of climate change. And Policy 5 doesn't ensure, in the absence of infrastructure, how one can integrate the infrastructure, which is the word that is used. The plan shouldn't enable extra housing with no infrastructure, just for the sake of increasing housing numbers. And Policy 6 lumps our homeworker with the other residential zones in terms of the residential vacant lots, whereas not always a vacant lot might be used for just residential purposes, but also for papakainga and cultural purposes. Policy 7 is certainly at odds with the current future urban zone chapter and making an important legal situation like right to vest subdivision more complicated. Future urban zone identifies the areas that are ring-fenced for future development, but what FAS doesn't acknowledge or speak to the subdivision chapter is that there will be serious impediments to subdivision already. And my last point, which is about the Northern Growth Area development. So we have a number of concerns about the NGA, and we've given the details of these concerns already in our submission, and I'm not going to talk about them in detail. They're all in there in public domain. These concerns remain as we haven't received further information regarding the gaps our teams identified, such as the stormwater management plans, further specific cultural assessment in the light of our cultural landscapes in the mentioned area, the agility of the NGA structure plan in the face of inadequate and in some places zero three waters infrastructure, our confidence for ecological targets to be achieved, met, the interaction of critical roading and three waters infrastructure, trying to build more houses so that the need to creating new sewage treatment, drinking water and stormwater systems, all the while the whole Porirua suffers serious three waters and landfill infrastructure issues. Engari, I won't comment no more on this as we're in the middle of a legislative-driven engagement with the relevant parties for the overall assessment of the project as the specified development project under Section 29A of the Urban Development Act 2022. And with that, I conclude my comments and thank you very much, and I'm happy to receive any questions you may have.
Thank you very much. Commissioner Meyer.
Tēnā kōrua. ngā mihi nui ki a kōrua e hui hui mai nei ki rongi te kaupapa nui o te rā. O te rā ki a koe e te tuahine, te māngai o Ngāti Toa Rangatira, ngā mana whenua o te rohe nei. Ngā mihi nui ki a koe ki a kōrua ki a koutou, te iwi o tēnei rohe. Nā reira, tēnā koutou katoa. Kia ora, thank you very much for your very comprehensive coverage of your original submission points. You've added a lot more detail and explanatory discussion there, which is helpful for us to better understand some of those original submission points, which I had quite a few questions on, which you've now largely put to bed. However, I would request, if we might, be able to obtain a copy of your speaking points. That would be really helpful. Thank you. There seem to be more than 14 points there, but they may have been all interrelated and expanded upon, which seem to expand the 14 points into a much more lengthy submission. I think where I will start is with the Ngāti Toa overlay or zone, as I think you're requesting. I was really interested to hear in your oral submission today that the justification and sort of foundation for that zoning that's been provided through the Section 42A report and the 32A report actually initially doesn't accord with what you're saying. So am I right in hearing that when you first raised the idea with the council, the main concern from the Runanga was around the absence of the SASM overlay, given that, as I understand it, further work is being completed by the Runanga in partnership with the council to get that schedule finalised for a Schedule 1 process. Is that understanding correct?
Yeah. So we're working with the council officers, but obviously I don't think there is a council paper went that this plan change is going to go through yet. So we're working together, but at the moment it's a desktop work. So I'm not entirely sure whether actually the politicians know about this, but the SASM work is being done.
Right.
What we're asking for the Ngāti Toa zone is those are the lands that we might own in the future, we will own in the future, but it is not obvious to Joe Block.
Yeah.
And they won't know about it or they won't be aware of it unless they're being asked to look at it. And they should, because it impacts on the way that which we operate and how we value those lands. So it is our SASMs plus the land that is being given to us under our cultural redress.
Okay, so just to be clear, on the relief that the Runanga is seeking, it's for the establishment of a new zone, not an overlay, but a new zone, a Ngāti Toa zone, that will apply to high and medium density zones and lands returned under the Ngāti Toa Deed of Settlement Act.
Yeah, that's right.
Okay, and is it plus the SASMs, or is it that the lands returned under the DOS will become SASMs?
It is a plus to the SASMs because
the SASMs.
Yeah, because not all of the land in the deed has historical attachment or
that's right.
Or narrative or
So
it's just in some cases land just being given to us as part of cultural redress.
Okay. And so that includes all SASMs. So the ones that have already been identified previously and are in the process of being identified for the Schedule 1 plan change process.
Yeah, and I think that's why I sort of mentioned that the current chapter as it sits in the proposed plan needs to also go through a change, because at the moment SASMs are looked at as heritage items, right? Like they're all being vested high protection. Whereas what we're saying is some sites needs to be managed, some sites needs to be protected, some sites are going to be, developed. Like for instance, Takapawahia Pa, it's a current contemporary site that are people doing stuff on it, but it is a site of significance to us. So, that chapter doesn't really address the nuances that we're talking about here. So the chapter provisions also need to change, as well as the schedule mapping and the schedule itself.
So, if the Ngāti Toa zone was established, I'm understanding from the Runanga submission that what you're seeking is for that zone to sit within the urban environment, or sit within the district plan.
That's right.
I should say. So not outside the district plan.
That's right.
Okay, and so if it was sitting within the district plan, the SASM overlay provisions would still apply to the Ngāti Toa zone.
Yeah, absolutely.
Wouldn't they?
Yeah, absolutely. They need to speak to each other. If there was a Ngāti Toa zone overlay and a
Yes.
zone chapter and a SASM schedule, they will coexist, and they will have to speak to each other as well in terms of what they provide for, what activity statuses can be provided for. Yeah.
Okay. And so what do we gain? What is the Runanga seeking to gain by including the SASMs in the Ngāti Toa zone, let's say, as opposed to just applying the, district plan SASM overlays that already exist?
Yeah, SASMs have all of the cultural values. I think they have to stay separately. And Ngāti Toa zone has all of the lands that are returned in Porirua under the deed, which may or may not necessarily be a SASM site.
Exactly. So
If that makes any sense, if it is clear, because I think that the Ngāti Toa zone is including all of the deed of settlement, cultural redress, lands that are returned, quite a lot of land in Porirua. So therefore, it kind of safeguards the development rights, protection rights, and management rights.
I'm just going to jump in there. That doesn't quite align with what you said earlier, where you said that the zone should be a combination of the DOS lands plus the SASMs.
Yeah.
I think you just said in response to Commissioner Pomari that the SASMs will apply regardless of whether they're included in the zone.
I think, I would just like to make myself clear. Some of those sites are also SASMs. They
Some of the DOS sites.
Yeah, that's right. That's
Yes.
right.
Yes.
So that's why, I didn't want to sort of miscalculate the situation. I suppose they sometimes overlap.
Okay, so it's in the overlap.
That's right.
Got you. Okay, so it's not. So it's only where the SASMs overlap with the Ngāti Toa zone that they're actually included within the Ngāti
That's
Toa
right.
zone.
But the SASM chapter will take care of that.
That makes much better sense. Thank you. Okay, so can I refer you to Appendix H of the Section 42A report, which is the map that the council prepared on the request of Ngāti Toa in their further submission, which sets out, it identifies the deed of settlement properties to be included in the Ngāti Toa overlay.
Is it this one?
Yes, that's it. I did have it marked here. Here it is. Okay. So, you're familiar with this map, I take it?
Yeah.
Okay. In terms of the purple and the blue areas, the purple shows the deferred selection properties, and the green, or the bluey green aqua colour, shows the RFR properties. Are you able to, well, first of all, are you able to confirm that this is an accurate reflection of the distribution of those properties?
I understand the council has a GIS overlay of these,
Yeah.
so I'm hoping that I can trust that they've got it from the deep, but we need to double check, obviously. Yeah, development team.
Are you able to clarify whether all these properties sit within the urban environment?
Some of them probably won't because they'll be rural zoned as well.
That's right.
Yeah.
Yeah. Okay.
Yeah.
So there
Yeah.
is a.
Yeah.
Your understanding
And-
is that they're not
and-
all within the urban.
That's right. That's right. Actually, you hit a really, really good point because some of the zoning, like under zoning, is also, and that's why we really want this zone to be obvious because they're open space. You see, so some of them will be open space, and as you know, district plan is not very allowing and permitting for open space zone to be developed. So, and that's why I made the point earlier that we weren't in the process of zoning these lands in the first place, but we, had them because they've been given to us. So I think that's why it's important to sort of lay them out like this, so that to make it clear to other landowners around it, or using right now to give a signal of what the land use might be in the future.
Okay, so just to be clear, this map shows the deed of settlement properties that have been returned to Ngāti Toa, as well as potential settlement properties that may be returned to Ngāti Toa at some point in the future.
Kapai, yeah.
Okay, so just thinking about that in terms of the deferred selection properties, my understanding is that Ngāti Toa have a 10-year window within which to express an interest to the Crown to reacquire land that's been identified as deferred selection, and that window closes, I think, next year. So there's a very short time frame left now for the Runanga to reacquire whatever's left in the deferred selection bank. So with that said, what proportion of these, without having to go into a lot of detail, what proportion of the deferred selection properties have already been acquired by Ngāti Toa and sit within the Runanga's ownership?
Yeah, my understanding that there's still some work ongoing
Right.
about those, and I think what I'll need to do is once this is this proposal, that we're talking about is going through, then I can have a good conversation about what is the final map could look like, given that the realistic work underway.
So with that in mind then, would your expectation be that once those properties have been finalised, and there's no more opportunity for Ngāti Toa to acquire deferred selection properties, if there are any remaining, that they would then be deleted from the planning map and would no longer be subject to the Ngāti Toa zone?
Yeah, I'm guessing so. And as far as the Ngāti Toa zone chapter is involved, yes, because it will no longer apply.
Okay, thank you. And in terms of the RFR properties, there's a significant number of them, obviously, in both, mainly Porirua East, but also over to the west. And we know that Kāinga Ora have a significant property holding in relation to those RFRs. What proportion, are you able to give us any indication of what proportion of those RFR properties are already within Ngāti Toa's ownership?
Again, it is something that probably that I need to check in, but I do know that, again, there's a lot of work being done. Without Kāinga Ora, I think,
Okay.
With the other landowners,
Okay. My understanding in relation to those RFR properties is that there is the RFR applies for 169 years, within which time there may be opportunities for Ngāti Toa to acquire land that becomes surplus to Crown needs.
Yes.
But it is dependent upon
absolutely.
surplus land becoming available. So there is the potential for some, maybe quite a lot of those properties never actually making their way into Ngāti Toa's ownership. How does that affect the way in which that those properties might be managed within the context of a Ngāti Toa zone?
I view those things like the chapter zone provisions only apply when it's under the ownership, but at least you can see it in the map, what they represent and what they come under, because, you know, because we will have to define all of these things, obviously, when if we end up writing the chapter, that it will need to be made clear that they can only apply when this land is under ownership of Ngāti Toa.
Right.
Because at the moment, you're right, there's lots of clauses and conditions.
Yes.
But it doesn't necessarily sort of prevent us to go and use those opportunities. And I know that there's already like work in place with our land development team. They're doing a lot of work for that, you know, for making sure that some of those lands are returned to us. So definitely work needs to be done with the land development team to sort of go to granular detail of what is feasible to go to that map. But then at the same time, I feel that zone could trigger only, you know, when we have the ownership of those lands. I think it should be very clear.
Yes. Okay, that's helpful. Thank you.
And also, it is not only just for us or, you know, the triggering rules that sort of, as it relates to us, it's just giving direction also to other people as well, how to subdivide and what to do and what not to do, and the purposes of the land, how it's going to be used in the future. I think it's for everyone else as well as for us. I see that because at the moment, like, there's no such thing in the plan that could achieve those objectives for the land that we want to develop.
Yeah. Thank you for that. So, I mean, just thinking about what you've said, could there actually be opportunity, do you think, for the Ngāti Toa zone to apply in situations where the land hasn't returned necessarily into Ngāti Toa's ownership, but may, for instance, have an RFR on it, like a lot of the properties in Porirua East and on the western side, where Ngāti Toa are working in partnership with Kāinga Water to regenerate social housing and infrastructure there for the benefit of both Ngāti Toa and the wider community.
Yeah.
And so, in a sense, you know, that is an expression, I would have thought, of Ngāti Toa's tino rangatiratanga and mana and manakitanga, without necessarily having full ownership of the land.
Absolutely. And also, I can also give you another example, which, because you just triggered another wave that I'm going to surf on. So some of the, you know, work that we do, our teams do with Greater Wellington, DOC, you know, we can also, there are prospects as we might actually also be vested land as well under the open space, you know, the kaitiaki that we can take over. There's always those prospects with the, you know, the areas that are managed by the Crown. So I think this zone or the chapter provisions could also help that govern as well if such things happen, you know, under the open space or natural open space zones as part of our kaitiaki role.
Yes, yeah, absolutely. Yeah. So obviously there's, from what I understand you've been saying, there is a lot of work yet to do in terms of defining what those provisions for the zone might look like and how they'd need to take account of the different characterisations and potential uses of that DOS land, and how the zone would relate to other parts of the district plan. But it's not, I mean, there don't seem to be any insurmountable or obvious insurmountable barriers in the way to establishing a zone of this nature. Is that what you would agree with?
I think it will. It is probably. I haven't sort of come across in the other planning environments, but it is going to be very bespoke if we end up doing something like this. It will be quite cool. Yeah.
As an alternative to the Ngāti Toa zoning idea, the Section 42 officer has recommended or considered the idea of updating the tangata whenua chapter to acknowledge the importance of those sites to Ngāti Toa. Have you considered that idea?
Yeah, absolutely. And with all due respect, I really do appreciate that it's been taken on board like that, and appreciate the mahi that has been done. But what we're asking for is not quite something to include in Tangata Whenua chapter, because it is a statement, and it's public information, our Deed of Settlement Act, and what comes with it. What we're trying to do here is that to action those things, bringing into the action area, because everybody could open up the Tangata Whenua chapter or the Mana Whenua chapter, but what do they do with it? Usually nothing. And then we take the sort of the grunt, what happens afterwards. So I think what we're trying to do is to action our Deed of Settlement, action protecting our sites in the right way, in the most appropriate way, and make sure also help others, we're manaking the others to understand what district land does to our sites. That's like doing three things. So it will help other people to also approach how they're going to be like viewing these sites.
I understand. However, there have been jurisdictional issues raised in the opening legal submissions for the council in relation to Ngāti Toa's submission, and in particular the relief sought around the Ngāti Toa zone, the lack of clarity in terms of how it would work in practice and how it might be spatially defined and all those sorts of pretty obvious things. Yeah. But it does seem as though, from a legal perspective, there is nevertheless, or there may be jurisdiction to include an overlay across deed of settlement land, if it can be demonstrated that an overlay directly relates to the mandatory, one of the mandatory outcomes, which then becomes a qualifying matter, and you did refer to this earlier. So in this case, it seems that it wouldn't be too long a bow to draw to assume that Ngāti Toa would be able to demonstrate an ancestral connection in the context of Section 6E to a sufficient degree to establish a qualifying matter, which would then obviously provide the ability for more restrictive sort of controls and the imposition of protections on DOS lands within that Ngāti Toa zone. But again, there's a lot of detail that would have to be worked through with the council in developing appropriate provisions and so forth to give effect to a zone of that nature, and for a qualifying Section 6E qualifying matter to have full effect. So the council have said that they are, they're open to those sort of discussions and exploring what's feasible. What would the Runanga's response be to that?
Oh, we're more than happy to work through that, and we're more than happy also to direct and guide and co-craft such provisions, because I think we do have an idea of what might they look like. And yeah, we're more than happy to do that.
Great, thank you for that. I'm just looking through my notes here to see if we've covered everything off. I think you've done the subdivision one. There were just a few points in relation to your original submission. We've covered them all, except I just had one more question in relation to your original submissions on the Northern Growth Area.
Yes.
And the landscape values. You mentioned there, in terms of integrated cultural landscapes, you mentioned 2 or 3 sites. I think they're meant to be sites. Taupō Pā is certainly a site. Te Ara Taua, Porirua Bay, is that meant to be Porirua Pā or
Yeah.
Porirua
So
Pa?
I think I mentioned that so that people can have an understanding of
Yeah.
like it. So
The
that
connection.
whole, that's right. That
Right.
whole hill of the either side of the hill is a cultural landscape.
Yes.
And as you mentioned at the beginning of your question, we the sort of the new sites of significance schedule, the new maps that we're working with our Kōmatua includes those cultural landscapes.
Okay, good.
So at the moment in the schedule, they're either dots or areas of little, whereas in the new mapping that we've done with our people, they are actually a cultural landscape that covers from Porirua Bay all the way to goes to Taupapa and includes Te Arataua. And so it's huge. It basically, and that's why I made that point about the Northern Growth Area. It will impact that big cultural landscape that has many values, including the archaeological values, of
Yes.
course. But that's a new development that it needs to come part of that. And I think our people are going to work on a new cultural assessment for that. And because of the way that we mapped recently how we're changing our view on those sites. So those sites are because, when you look at the Porirua Pa, you've got this 4 dots, whereas we're suggesting that whole hill is the cultural landscape because it's got the awa, it's got the moana, it's got the urupas, it's got everything. So it's not necessarily those dots, it's the collection of the bigger dots.
Precinct sort of approach.
Yeah, that's right.
Okay.
So at the moment, that kind of view of SASMs are not really obvious to job log because it's not really like that in the plan. Or in the overlay maps, but it will be soon, hopefully.
Thanks for that explanation. That really helps. I'm just wanting to clarify the Te Arataua. Is that a reference to the Tauatapu track?
That's right.
It is.
Yeah.
Okay. And is that track included as a SASM? It
Yes,
is.
absolutely.
Okay, great.
Yeah. And all of the rivers and forests that are surrounding of it. Yeah.
And does that track traverse at any point the Northern Growth Development Area precinct? Must come pretty close.
Not directly, but I think the where the NG is, my understanding is, and I might be stood corrected for this, but the whole part of the hill is a viewing point at an important cultural viewing point. So therefore, the either side of the state highway is considered as the cultural landscape, which impacts on the NGA.
Got you. Thank you. Just a couple more. Okay, a couple more questions really quickly. Just to clarify some of the further submission points that you made. The Greater Wellington Regional Council has requested further provisions to give effect to the partnership with mana whenua, which you've naturally supported. But I just wanted to clarify with you what exactly you're seeking there. I understand that the Runanga has a formalised relationship with the council through an MOU that's based on a treaty-type partnership approach, which has underpinned the way in which the PDP has been developed. And we've heard from Mr McDonnell that from the council's perspective, this relationship is working pretty well. And I'm sure I got the impression that the council view the relationship as being pretty effective and, strong in terms of the way in which you're working together and being able to address a lot of these really significant issues facing the whole district. I just wondered, from the Runanga's point of view, what is your view of how effectively the relationship's working, and what exactly is it that you're seeking or supporting through the Greater Wellington Regional Council submission point there?
Okay, so I'm going to put up my planner hat rather than representing all of our people. But for partnership, I think it's always a journey, and it's a work in progress. And I do agree with Tori that we've got really a good sort of relationship, that we can raise issues and we can talk in advance. And I mentioned that at the beginning of my submission, that we've also provided we're available. And we are, and I'm not saying that in a sort of, we're available and we are able to respond to queries about our city Porirua, and that's quite important, and that's a big progress towards partnership. But I think what maybe the Greater Wellington approach that we sort of supported is that partnership comes in like in whole, like it's not in a silo. So our team, like Jade and myself and some of our kaimahi, works with Tori's team, but that's just the one team in the council. And our kōpapa in Porirua is quite ginormous. It includes our parks, open spaces, signage, waste, landfills, assets, resource consent. So, so the partnership at all levels are quite a challenging space. And yes, we do have an MOU. Again, it's a work in progress as well. I think that's probably towards that. And partnership also comes in, different layers. It's not just about participating to something with providing feedback. Like in some situations, we want to co-design the processes as if the resources allow. So, that's why I suggested that we're happy to co-draft the Ngāti Toa Zone or any chapter that kind of is interest to us, which is quite a different approach as compared to past. So those are the types of things, and just not seeing this process as a sort of like a Pākehā planning process where the officers do right, because we do come here and talk as well as part of the process. So that was related to that.
Thank you. That's really helpful and very clear. And just in relation to the Kāinga Ora further submission, seeking the extension of the Metropolitan Centre Zone across the large format retail area, and your opposition to that, you have cited there that the potential impacts from the height variation controls to be increased at Takapuāhia and have an impact on Takapuāhia Pa, which is a site of contemporary significance to Ngāti Toa. Is it now included as a SASM?
It should be, yeah. Like I think the Takapuāhia Pa is a site of significance to people of Ngāti Toa. It is a contemporary site because people live and do stuff there. It's not just a heritage site. Obviously, it's got a lot of historical narrative. But, and that's why I mentioned the SASM chapter needs to have like quite a nuanced and leveled out, should be able to respond to these different types of nuances. And at the moment, we don't have that as either high protection or, I think with that, Takapuāhia is quite important to our people, and we don't necessarily want to have those, things being around us without no consideration.
Yes.
So, but this process, as I mentioned before, might actually end up doing that. Although, the council officers tried hard to find out, to model how potential height controls and things could happen. But we never know until someone does a proposal and what they're going to be doing with it. So, and that's why it's quite important to map all of these sites, and they've got legal effect in the plan schedules, not just, they're in the DOS.
Yes.
Yeah.
Yeah. So the Ngāti Toa Zone would effectively be used by Ngāti Toa to provide the kind of protection necessary against inappropriate development.
Yeah, and it will trigger engagement. We might not have any objections to something. I don't know what the proposal X, Y, Z, but at least it will give us the opportunity and the right to veto or right to say something about something inappropriate proposed.
One last question, I promise. I'd be really interested in your views on the extent to which the more enabling provisions for greater intensification of housing in Porirua might help to address the specific needs and aspirations of Ngāti Toa in terms of meeting their housing needs. I'm aware that Ngāti Toa has its own housing strategy and is diligently working towards addressing the needs of the Ngāti Toa people here, and that they are quite different from the rest of the community.
Yeah.
And that housing ownership, for instance, is a big priority, which requires overcoming the biggest barrier, of course, which is the lack of affordability. So just wondering whether you can provide a brief explanation on the extent to which that the housing needs of Ngāti Toa may be met by this plan change?
So for medium and high density, I think our land development team tells me they've got different aspirations for different land, and where it is and what it serves. And in some cases it might be 3-story, in some cases it might be just 1 story, But I think as far as the our people's aspirations are involved, Papakanga is a big aspiration, and it's not necessarily at odds with high-story buildings. But densification might be a different matter, because densification how? Like, I think if it is in Arohe, then it supports the Papakanga setup, which is quite different than te ao Pākehā housing. So so that means different things. So but in terms of high-story buildings, that doesn't necessarily clash with the Papakanga thinking. But I also saw Papakanga that is not high-story. So it is that sort of communal living which supports education, rongoa, commercial, community, like our whānau, everything. So it requires space,
Yes.
which may or may not fit with the high density or medium density comprehension. It may also not fit with how people want to travel. Again, that sort of Western centric thinking of rolling in the MPSUD, where how people travel. People travel together. They might not necessarily take the train, or that's obviously we will need to think about the environmental implications of that. But I think in a nut case, it doesn't necessarily clash, but it doesn't necessarily overlap.
Yes.
That the Moriora framework that we have. But what I can tell you is also that Moriora framework has the environment, the taia, in the center, which basically taia is the people. So if the taia is not very good, then the people are not going to be living in a good place. So I can imagine that high density, unless it's been supported with clear environmental objectives, then it might not be appropriate either, unless that plan achieves those objectives.
Thank you. Kia ora.
Kia ora. Kia ora.
Yes. Question.
Thank you very much, both of you. Appreciate your time and your input. You've given us quite a lot to think about. We'll adjourn for 5 minutes and be back to talk to the Kaingaora team.
Thank you.
waiting patiently. We are planning to go as long as we need to go tonight, maybe quite a long time. So over to you to kick off.
Tēnā koutou. Thank you for accommodating us and within one time rather than splitting the time across days. I have here with me the Kāinga Order witnesses. To my left is Brendan Liggett, who will give corporate evidence. To his left is Nick Ray, urban design. To the far left is Karen Williams, planning. To my right is Mike Cullen, urban economics, and to the far right, Martin Gledhill, who is the electromagnetic field expert.
So the opening question is, nice to see Mr. Gledhill. Is there anything left for him to talk about?
Well, potentially. The position that Kāinga Order takes on that issue is not identical to the one that Radio New Zealand takes, as is recorded in that final memorandum. And we thought it might be helpful, in case there are questions that you have about his evidence, to have him here.
Okay, all right, fine.
So look, I'm in your hands as to how you want to proceed. My intention was for me to start with legal submissions and then to hand over to Mr. Liggett. Mr. Liggett may have an issue he needs to jump out for, in which case this is solved. Okay, in that case it doesn't matter. So Mr. Liggett will come after me, and then we'll move to the urban design and urban economics evidence. Finally, Mr. Gledhill, and then wrapped up by Ms. Williams. That's the plan of attack that I was intending, but we can go really with whatever you like.
Happy to proceed on that basis. Let's. I think the watchword is we've read all the evidence. The only thing that I particularly want your witnesses to take us through is the joint statement, which I see has just landed on my table. I've read the first 3 lines, which has stopped at introduction. So we'll need Mr. Ray to take us through where he and Mr. McIndoe have landed on that. But otherwise, I think we want, if we could keep the opening presentations as short as possible. And so we've read all the evidence. We've got a lot of questions that we want to go through, and we'd like to focus on the things that we want to explore with your witnesses and not
listen to us.
Well, I wouldn't be quite so cutting. Not still be here at 10 o'clock tonight.
No. Right. Well, look, I'll jump straight into it. There are 5 things that I'm going to discuss with you. The first is the position for the large format, retail zone. The second is Porirua Bay and Paremata. The third is shading as a qualifying matter. The fourth is height controls around heritage items and SASMs. And then the fifth is just Radio New Zealand. So it's really 4 because that Radio New Zealand one isn't going to take very long from me. On the large format retail zone, I just really want to explain Kāinga Order's position because the situation's not exactly, or the position remains fluid, if I can put it that way. And I think I'll start just by highlighting a couple of paragraphs from Mr. Ruckland's, I hope I pronounced that correctly, updated statement, which I was sent by email. This is on the rezoning of LFRZ at land to the north of the Metropolitan Centre Zone. Now, what I understand Mr. Ruckland's position to be is that extending the Metropolitan Centre Zone northwards brings into play the possible requirement to upzone Takapū here to high-density residential zone, and that really is the issue. And he, that as he correctly identifies, raises possible Section 6E and Section 8 matters of the RMA, and goes on to say that for those reasons, he doesn't consider that this is the appropriate time to upzone or to change the zoning of that large format retail zone. And I just wanted to highlight the way that that's phrased because he doesn't say that the large format retail zone is the most appropriate zone, the most appropriate set of provisions to apply to that zone. And Kāinga Ora's position is that the correct approach here is to change that zoning to metropolitan centre zone. But if you are concerned about potential Section 6E and Section 8 matters, to limit the height of that zone, probably by way of an overlay, to 22 metres, which is the current large format height limit. And on that basis, it can't be said that the enabling of additional height could engage those Section 6E and Section 8 matters. So that, for stage one, I suppose, is Kāinga Ora's preferred position. That then has a consequential issue raised by Policy 3 of the NPS, which is what happens to the high density or to the land around it, which would, under Policy 3, be increased to high density zone. And Kāinga Ora accepts that the situation is that there's not enough evidence before you about what Section 6E or Section 8 matters arise, whether there might be an appropriate qualifying matter. The evidence base for a qualifying matter simply hasn't been adequately explored by any of the parties, Kāinga Ora included. And so that leaves you in a position where there are two options. One is for you to direct the relevant parties, which would be Ngāti Toa, Kāinga Ora and the council, to caucus and see if they can reach an agreed position on the appropriate treatment of that land within obviously a very short space of time. And if that was not possible, the second is for your recommendations to record that in respect of that land, the NPSUD has not been given effect to. And in my submission, what that would trigger is a duty on the part of the council to formulate a position and obviously consult with Ngāti Toa and Kāinga Ora and progress that as a plan change or a variation. And if you're going to do it that way, rather than directing the parties to caucus now, in my submission, it's important that it's recorded that the NPS has not been given effect to, because it does raise a duty, as I say, under Section 77G of the legislation for the position for the NPS to be given effect to. And whether that's through Policy 3 or Policy 4 is a matter for the parties to resolve. Mr. Chair, there's a question from one of your colleagues.
Several questions, actually.
You go.
Thanks, Mr. Wing. So, do I understand you correctly in that the only issue is in relation to if you were going to rezone large format retail, the metropolitan, that it's only for the extension to the land beyond in Takapua here? Is that what you're saying?
There's a map, helpfully actually, in Mr. Ray's evidence, map 13 of attachment F, I think it is. Actually, it's not. It's on the attachment C. There is a
attachment C to
Mr. Ray's evidence. Right on the first page of that attachment is a side-by-side comparator of the large format retail zone with metropolitan centre zone on the right. And it also depicts the high density up to 36 metres in and around Takapua here.
Yep.
So what we're proposing is, I suppose, a slight variation on that right-hand photo, that right-hand depiction, where the MCZ would extend up to the water, the way it's depicted there, but only up to 22 metres. So it would be more enabling, more consistent with the metropolitan centre zoning that the evidence of Mr. Cullen and Mr Ray, and now agreed to by Mr McIndoe, suggests is the appropriate zone, but it wouldn't have in my submission the same Section 6E concerns because the height that it's enabling is exactly the same as the large format zone, which, as I understand it anyway, Ngāti Toa and the council are both otherwise happy with.
My question though is that the Section 6E and Section 8 matters in relation to the HDZ zone shown on the plan?
Yes, well,
or does it relate to other Section 6E and 8 land that's in the large format retail zone, or both?
Well, as I understand the issue, the concern that's been expressed is that imposing metropolitan centre zone, as Kāinga Ora has proposed, has not considered adequately Section 6E matters. My understanding of that is that it's because of the increased height up to the waterline and accessibility to the water and matters of that nature that it causes, or that it engages.
Right, so it doesn't apply to sections, land that might be Ngāti Tauas or the other Tangata Whenua owned land that's within that area?
I'm not sure I follow your question.
I think the answer is, Commissioner, it's with the large format retail, and they're addressing it by the means of the control on height. So it's can go no higher than at present.
Yeah, or no higher than as the notified.
Present under the notified provisions.
That's right. So the Section 6E, it's an interim position effectively. The question for you, if you're concerned about Section 6E and the effect that has on rezoning of this large format retail zone is, do you go with the large format retail zone, which based on the evidence now of 3 expert witnesses is not really the appropriate zone? Or do you go with a metropolitan centre zone, which the 3 witnesses agree is the most appropriate zone, but protecting or limiting the potential effect on Section 6E concerns by reducing the height? Now, we can't really progress an equivalent interim position for the high density alongside it. It just needs to be explored, more work needs to be done. But in my submission, no more work needs to be done to reach that interim position that the appropriate zoning is metropolitan centre, but with a reduced height limit. And through the process that the parties go through, it may well be that can be increased. That 22 metre can go up to, say, 53 metres or at some intervening point. That's something to be worked through. But in my submission, you can go that far without engaging Section 6E matters.
Mr Whittington, you were referring to Mr Racklin. You were reading from a document that Mr Racklin wrote. What was that document and what paragraph was it?
It was a document that I was sent by email, which I understood to be an updated statement. It's a half-page. Yes. It's simply got a heading: rezoning of LFRZ at land to the north of the metropolitan centre zone. It's got 5 unnumbered paragraphs.
Yeah. Which unnumbered paragraph was it that you were referring to?
Well, it's short enough that I was effectively referring to the whole thing. It explains his process of reasoning, his concerns about Section 6E, and reaches the conclusion that therefore it's not appropriate to upzone.
Yes.
And my point was that what it doesn't say is whether large format is in fact the appropriate zone. It just simply says because of Section 6E we can't upzone right now.
My understanding from when we questioned Mr Racklin on this was that he verbally told us that he was still opposed to the upzoning.
Okay.
That was followed up by the
Yes, and then he went on to consider the walkable catchments component as that in terms of the high density residential zone.
Yes.
Yes. Okay.
Please.
Thank you. So look, that's all I wanted to say on large format. As I say, I've outlined two potential ways of trying to resolve the issue, whether that's through relatively urgent caucusing or whether that's through a separate process is really a matter for you to consider and direct. There may or may not be enough time to do that. Obviously, council officers have replies and all sorts of other things going on. Kāinga Ora's involved in other IPIs up and down the country, but can seek to make this a priority if that's thought to be the best way forward.
Yes. And if we don't, then we should clearly record that the decision doesn't give effect to the duty under 77G.
That's right, because whether or not you're imposing what Policy 3 would require or something less than that to account for a qualifying matter, both courses are implementing the NPS, and so if you don't take that course, then the result is that the council won't be giving effect to the NPS in this route, specific area.
Yes. We might come back to you on that because that seems a little bit at odds with Kāinga Ora's position on Porirua Bay in terms of giving effect. But we might park that for the moment.
Yeah. Well, I'm moving on to Porirua Bay now, so I'm happy to deal with that, and I suspect the distinction that I would rely on is that in my submission there is an available route for you to give effect to the NPS without undermining the position that I've just put forward to you, or acting inconsistently with the position that I've just put forward to you. So, Porirua Bay, the starting point is the joint witness statement of the urban design experts in my submission. That's Mr. McIndoe for the council and Mr. Ray for Kāinga Ora, and they are agreed that if it is zoned high-density residential around the rapid transit stop in Porirua Bay, then the boundaries shown in Mr. Ray's evidence, that's attachment F map 13, are appropriate. So that if you accept that evidence, that position really means the issue is not so much one of where do you draw the lines, where do you draw the walkable catchment, it's what do we, do we zone it high density or not?
I'm not sure that's right. Mr. McIndoe can only agree in respect of urban design matters, which is not the only issue on the table.
Well, I said, if you accept that evidence, by which I mean if you consider that to be the controlling consideration. Now, I do consider it to be the controlling consideration. I'm not aware of any other evidence suggesting, can I put it, non-NPSUD reasons why that would not be upzoned. There's not, for example, Section 6E matters that I'm aware of in that area that could act as a qualifying matter to suggest otherwise, but I'm happy to be corrected if there are.
Okay. Keep rolling.
So, and it's the same for Paremata. They have the position at 8.1 in that joint statement, which I will... This is the first one, by the way, not the one that's just landed. Yes. So 8.1, Mr. McIndoe acknowledges that some of the area identified by Kāinga Ora offers opportunity for increased height given the walkable distance to the train station. These would be the lots fronting Paremata Crescent and Papakowhai Road. This should allow a height increase to 6 stories. Having discussed this further, Mr. Ray agrees that those areas up the hill and beyond are marginal and not worth pursuing. So again, there is a degree of agreement between the experts about the appropriate location of the catchment. If you accept that evidence, then the only real position or the only real issue for you is whether it's upzoned or not. Now, the concern that Kāinga Ora has in relation to the council's position is that there is no qualifying matter identified, no process has been gone through that is consistent with the NPS or the legislation to establish a qualifying matter, but the position that's been reached is not the presumptive outcome that the NPS directs. When I say presumptive outcome, I've been musing over the last few weeks about what it is that the NPS does, and the position I've reached is that it effectively creates a presumption of the MDRS or Policy 3 in all relevant residential zones, except where a process has gone through that establishes that something less than that is appropriate. And that process is confined, but if it's not carried out, then the presumptive position should be imposed.
Question for you. I was going to ask you in the context of your submissions, you said, well, the qualifying matters or bust, effectively.
Yep.
Isn't there a preliminary step to defining a walkable catchment?
No, I
You're
think...
only qualifying within a walkable catchment?
Well, I think the first step is to identify all relevant residential zones, and if there's no dispute that this is a relevant residential zone, then I jump to the question of, is this a mass rapid transit service? If yes, is this a stop? And then the question is, how big is the catchment? Now, you could decide to based on the evidence, the catchment needs to be very small. But I don't think that evidence is before you in Porirua Bay. And there's a secondary, it's not even secondary, it's really I referred to it in my legal submissions as a change of mindset, but what we're trying to do here is create a forward-looking plan. And in my submission, it's not consistent with the thrust of the NPSUD to say, well, Porirua Bay doesn't have a supermarket. Therefore, we can't impose high-density residential. Because in my submission, that's something that the market will provide, if appropriate, in the future. We're trying to lay the groundwork for a future urban environment. As part of that, what, in my submission, the NPS does is tell you what a well-functioning urban environment is. And that is one where more people live close to public transport so that they can get around better and access more services without having to get into their cars. So the fact that there's not a supermarket in Porirua Bay at the moment does not mean that the area should not be significantly upzoned, because people will be able to get on the train and go to other centres where there are supermarkets until such time as Porirua Bay has a supermarket. But in any event, it may not be a supermarket as New Zealand currently conceptualises a supermarket with a huge amount of parking around it and a big box sort of thing. It may well be that as the centre increases in size, as the commercial development occurs, that there are smaller types of markets that you see in large cities around the world and in neighbourhoods to enable people to go and get milk and cheese and eggs and the sorts of things that people often want to pick up on their way home from work, getting off the train and picking up. So that's the sort of thing that's the way that we will live in 20 and 30 years' time. That's what this NPS is laying the groundwork for. And in my submission, it's cart before the horse to suggest that because something's not in place now, we should not zone for the future environment that we want.
Mr. Whittington, I understand the point you're making, that you plan for the future, and Mr. Ray makes that point a number of times. But at a certain point, there is a suspension of disbelief. Having undertaken a site visit and driven round the metropolis of Porirua Bay, and having stood in the car park in front of the bookshop and the dairy, you look around and you think, is this really an environment for high density residential activity? As I say, there's a certain suspension of disbelief required. As I understand the issue of plan for the future, but at a certain point, you think, this is surely a bridge too far.
Well, it may not be a very effective answer, but I answer it with another question. Why not? The market will provide if consumers demand it. If people living around that area, and if there are enough people living around that area that this is something that they need, that makes it financially worthwhile for a supermarket or other commercial enterprises to start up around that area, then the current car park and single story 3 or 4 shops that are in that centre will look completely different in 20 years' time. And the question is, do you enable that to occur? A lot of the enablement that these plans throughout the country put in place may not have any effect on the development that occurs in those places. They may stay similar to the status quo for many, many years, but if it's not zoned for, it simply won't happen. And that's the concern in my submission. That's the mindset change that the NPSUD requires in my submission. The Productivity Commission in 2015 identified that we simply have too much restriction on development, whether it's commercial or residential, and if we don't allow it to happen, we don't enable it, then the market simply won't provide it. Or it will provide it in areas which aren't necessarily the best areas because, and we heard from Ms. Octum just before about how previous restrictions have resulted in residential going into business zones because that was where there was going to be the least opposition. That's a perfect example of the sorts of incentive traps that previous zoning structures have created.
So to put that differently, Mr. Whittington, you're saying that the combination of the legislation and the NPS make it clear that in the absence of a qualifying matter or a process to establish a qualifying matter, that the council's hands are tied, and that if there is any discretion, it's in the size of the walkable catchment around the zone.
Yes, effectively. Having not gone through the process to establish a qualifying matter, really you're required to impose high density residential around that rapid transit stop, and the only question is how wide do you go? And there are factors you can consider, but the urban design experts in front of you are agreed that the map put before you by Mr. Ray is an appropriate outcome.
Okay.
You may not accept that evidence. You may decide that in certain areas it needs to look different, but the evidence of these 2 experts, and I don't think there's a third urban designer before you, those 2 urban designers are agreed on that position.
Yes. On the concept of walkable catchment, there's no, well, the NPS in itself doesn't provide any guidance on what that is, does it? It uses the term in policy 3 and 4, I think.
No, it doesn't define it. It's left it to evidence to and recognises that the size of the catchment will be different in different locations based on other factors such as topography, for example.
Yes.
Now, in saying that, I think too much weight can be put on matters such as topography. The way it was put, and this goes back to my point about planning for the future, and the market will decide whether something's a good idea. If you have a very steep site, you may think that people won't want to walk up this goat track to get to their housing, but some people will. Some people will be prepared to get to walk up this this goat track to get to their housing, because otherwise they may not have housing. And so, to the extent that someone's motivation or difficulty of walking may suggest that a walkable catchment should not be included within a certain area, in my submission that again puts too much weight on status quoism.
Thank you.
Now, to go back to the question Commissioner McMahon asked about, is that consistent with the large format retail zone? In my submission, it is. The issue in the large format retail zone is that all parties accept that there may be Section 6 issues. There very well may be a qualifying matter that has not been adequately explored. But that's not the position for Porirua Bay. As I understand it, the council is not asserting that there is a qualifying matter and saying, unfortunately, we haven't done the work to establish it. It's simply that it's concerned that the outcome will not be consistent with Objective 1 of the MPS because it won't be a well-functioning urban environment. And in my submission, that's cart before the horse. You can't say that. Kāinga Ora certainly doesn't agree that it would not be a well-functioning urban environment. And in my submission, when you work through the objectives and the policies, Policy 3 is seeking to create, it's telling you expressly how to create well-functioning urban environments. And so, to that extent, the council's position subverts the king salmon cascade. And that's the difference. I'm going to go next to shading as a qualifying matter in the south-facing slope. In terms of the south-facing slope steepness issue. And the issue there is, you'll see in my submissions, I've raised a potential argument that actually shading is not an available qualifying matter. It's something that the NPS already controls, and you therefore can't interpret any other matter within the legislation as including shading, for example. But I'm not going to press that particularly strongly, because the position that Kāinga Ora really takes is one of questioning whether the evidence base that's been put before you justifies the imposition of the restriction on urban development that it imposes. Now, and this is a theme again of not just this but other submissions or other points that Kāinga Ora is raising in terms of the evidence base, which is the process required by the legislation and by the MPSUD requires a fulsome cost-benefit analysis and a specific cost-benefit analysis. What Kāinga Ora is concerned about is the transfer of cost from an upfront cost to establish the qualifying matter onto parties who then seek to undertake development in situations where they've been constrained or restricted because of qualifying development matters. That's why the legislation puts it right up front and says if you want to establish a qualifying matter, you've got to do the mahi. There's got to be an evidence base. It's got to be shown that the costs that the benefits of that qualifying matter outweigh the costs that it imposes on urban development. And in my submission, that's not the position that the council has reached with shading. The evidence that that restriction will impose or will benefit health outcomes because of additional sunlight access that people will have in those sites is weak. The literature doesn't show a causal, or the evidence that shows a causal relationship is, there's not much of it. And Mr. McIndoe has identified papers in which lament the inadequacy of the evidence demonstrating that link. But even if there was a link, you still have to go through and quantify and measure the costs and the benefits. And in my submission, that's not what the council's done. What the council has done, and this is in my submissions, I refer to part 11.2.2.1 of the council's section 32 analysis, and that's at 6.5b of my written submissions. It says that there's no tension between the controls of seeking to provide for health and the national significance in urban development. And that, in my submission, misses the point entirely. There's an obvious tension between those two things. And the job of the council seeking to establish a qualifying matter is to explain why it puts more weight on the health outcome as opposed to the constraint on urban development. And it just hasn't done that. It's not enough to say that, or to assert without more that there is no tension, because the whole underlying point of the NPSUD is that there is a tension every time you impose a restriction on development over and above what the NPS would otherwise require.
Mr. Whittington, I have one quick question of clarification. You say that an exercise of quantifying the costs and benefits needs to happen up front. Is that the way the legislation and the NPSD view it? Because my reading is that to establish a qualifying matter, you've got to establish the merits of it. Then you've got to go through a site-by-site analysis on the ground to determine what sites are affected. And then there seems to be a sort of an overall judgment at the end where you decide whether the qualifying matter should actually be applied, having regard to its impact on housing intensification overall. And that's where I thought the cost and benefits analysis might come in. Do you have a different view on that?
Yes and no, helpfully. I would accept that it's not a simple matter of quantifying the costs and the benefits and deciding which one trumps. It's not a mathematical exercise. It's a judgment call at the end of the process based on all of the information before you. So the council may not succeed in its Section 32 analysis in establishing a qualifying matter, but it may, through subsequent information that's provided and perhaps through the information of other submitters, reach the point where you can say that we are satisfied of the merits of this qualifying matter. But it's not enough in my submission to just assert it, if I can put it that way. And in my submission, that's what the council does in its current Section 32 analysis. It avoids addressing the question by saying that there's no tension.
Okay. I thought you were saying, though, that the cost-benefit analysis should be undertaken in that very first step
Well, it should. It absolutely should. Yes, it should. But if it's not done, then I'm not saying that.
Not fatal.
It's not fatal if information is subsequently provided that does that.
Yes. And that third step?
Yes.
Yes.
Well, so that at the end of the day, when you have all of the information before you, because at the end of the day, you will make a recommendation based on all of the information before you and in accordance with the legal framework that applies to your decision. And if at the end of the day there is information, regardless of where it's come from, that satisfies you of a qualifying matter, then you will accept that.
Yes.
And impose a limitation to the extent necessary to accommodate that qualifying matter.
Yes, or not.
Or not, yes.
We might establish that there's a qualifying matter based on shading.
Yes.
We might apply that to see what resource in the Porirua city is affected by that.
Yes.
That's what Mr McIndoe's done. And then we might evaluate the entire thing and decide that, well, the balance favours intensification over that.
Yes, that's
shading.
exactly right.
But, yeah, that's one option.
But yes, but what I suppose I'm worried about is that you go through that process and do it in an information vacuum where you haven't been given enough information about the costs that such a restriction would impose.
Was a risk of double counting costs if we do it in both steps 1 and 3?
Well, I'm not suggesting that it happens at multiple steps. At the end of the day, you will do it in your decision-making step, but whether the information on which you base that has come from the council when it notified the plan or subsequently is, in my submission, irrelevant.
Okay.
Changing focus, I'm reminded of the Project Hayes decision where the High Court said in a normal RMA consenting process you don't need to undertake a cost-benefit analysis. And the reason it said that was because typically in a situation where you're comparing monetary and non-monetary values, you can never undertake that. Sometimes the economists can come up with a
monetary
pseudo,
equivalent
means to quantify the value of things like an outstanding landscape, which it was in that case. But ultimately, it's never going to be a quantification, it's going to be a judgment. So in terms of the costs of not enabling intensification, they're going to vary according to where you are on the supply and demand curve. And similarly, you can't put a cost on adverse health effects, or I suppose the government does through hospital costs, but that's only capturing part of the equation. It's not capturing the personal cost people have if their health is impaired.
Well, I think I can answer that by also moving on to the next topic because it comes up there too. But just on that last point, I think you can quantify the health impacts. And the fact of the matter is that based on the literature, it would not be apparent that there would be very many costs at all because it's by no means apparent that the difference between what Kāinga Ora is proposing, i.e. no qualifying matter, and what the council is proposing will have an adverse effect on health outcomes, and if it does, it will not be particularly significant. You can then compare that to the costs of imposing this restriction on landowners and the additional consenting costs if they want to develop over and above, and an economist could tell you how much that would amount to. Now, what I'm also concerned about is in undertaking that process that you look at the HBA and say, well, we're already enabling enough. The HBA requires us to enable a certain amount. We're enabling enough. Therefore, we don't need to enable it here. We can be less enabling in these areas where people are asserting qualifying matters. And in my submission, that's not right. That's inappropriate. just because we are currently, there may be a difference in the numbers being enabled by the HPA versus the bottom line required, does not mean that you should not still be more enabling. You still have to hold the line on qualifying matters. You have to be satisfied that it's appropriate. And it's not, in my submission, correct to be less exacting simply because there is enough apparently enabled elsewhere. You still need to go through that process. And to go back to the Hayes decision, which is not one I'm aware of. I may have read it, but it doesn't ring a bell.
AKA Meridian.
Right. Well, in my submission...
And Otago Regional Council, it might have been, I think it was Otago Regional Council.
What I would say is that that's about a resource consent, and it's entirely right, it seems to me, that it's to identify that it's difficult to undertake a cost-benefit analysis in relation to a resource consent. But the Productivity Commission recommendations, which have led to the change in the legislation and the NPSUD, are crystal clear that on the Productivity Commission's view, the sorts of cost-benefit analyses which have been undertaken by councils imposing restrictions on urban development are woefully inadequate when they're done at all. And that was one of the drivers behind creating a framework for qualifying matters to be assessed. And that's why, in my submission, it requires a more exacting cost-benefit analysis before imposing a restrictive rule. I can send through, perhaps while some of the other witnesses are speaking, I can find a reference to the Productivity Commission report where they considered these previous cost-benefit analyses and recommended that, or identified that they were, in the Productivity Commission's view, inadequate.
And so that's in relation to Section 32.
Yes, that's right. That's saying that Section 32 analyses underpinning urban development just have not been good enough. And it's had the effect of overly restricting urban development, and that's how we end up in the situation that we are now, where the government is, through the NPSUD, trying to be significantly more enabling of urban development and wanting decision makers to be significantly more wary of justifications for imposing limitations. And that's why we have Policy 6B, which is the one saying that just because things will change does not mean that that's a bad thing. And that's why we have this increased rigour required for cost-benefit analyses.
So, cost-benefit analysis of this, is that the same thing as a benefit and an assessment of the benefits and costs of the environment?
Yes.
One meets exactly the other.
That's right.
Okay.
Topic 4.
Yes, so just in the same way that I identified the paragraph of the Council's reasoning in its Section 32A for shading, I've done the same in my submissions for height adjacent to heritage and sites and areas of significance to Māori. Now, the quote comes from, I think it's 11.2.2.2, so it's a couple of paragraphs on from the shading one. And it's quoted in 7.2 of my legal submissions. And actually, it might be worth just identifying, because there are 3 sentences, and I just want to sort of pick them apart for you. But the first sentence is, as identified in the Property Economics Report, there will be costs associated with the controls. Absolutely there will. And the report does not consider what they are, how much they may be, and what effect they will have. However, in terms of housing supply, they are negligible. which I understand to mean that the HBA is already enabling enough. So the effect of not enabling the full effect of the MPS here will be negligible. And I don't agree with that. In my submission, that is faulty reasoning. The starting point, the presumptive outcome, is what Policy 3 requires, or the MDRS in this situation. And so if you establish a qualifying matter, which theoretically you could here, there's no doubt that sites of significance and heritage items are Section 6 matters. There's no doubt that it could be a qualifying matter. You then need to ask how much do you need to reduce that presumptive outcome to accommodate that qualifying matter. And that's not what the council's done in that passage. It then, in my submission, goes even further in a worse way and says there will be a direct cost to the landowners, however, the controls are no greater than those imposed by the PDP. And again, in my submission, that is completely irrelevant. If you're going to impose a cost, if you're going to impose a restriction, the question is, how far do we need to restrict to accommodate the qualifying matter? You don't leap straight to simply imposing the status quo. Now, I mean, this stuff is hard. I don't disagree with that. But there's a process that the legislation requires, and what I'm saying is that the council's reasoning is not compliant with the NPS. Now, in all of these, this is a position I've identified before, in all of these areas where people are concerned about the imposition of the presumptive position under the NPS, and they're worried that there may be unidentified qualifying matters, just because it's not identified or established through this process does not preclude people or councils from identifying them in a further plan change. Those provisions remain part of the RMA. These plans are not locked in. We have this very intense IPI process to put in place a new planning regime that is quickly and urgently required according to the government policy on housing and the policies behind the legislation that Parliament has put in. Doesn't mean that if we miss some qualifying matter areas that they can't be put in place through a subsequent plan change.
Is the reality, though, that by that time the horse will have bolted? If there's a 6-storey apartment block next to a heritage site, it's not going to be torn down because that's subsequently identified as a relevant qualifying matter that needs protection.
Well, I don't. There's no reason why a council can't seek immediate legal effect for any new qualifying matter it identifies. It just needs to go. In fact, I'll have to look at the legislation. It may actually have automatic immediate legal effect, but if it doesn't, then it can go to the Environment Court and seek such an order. But secondly, specific to this issue of SASMs and heritage items, Kāinga Ora's position is not that no restriction is appropriate, just that the height control that's imposed is not appropriate. A height in relation to boundary control remains appropriate. Kāinga Ora accepts that. And it accepts that despite the fact that the evidence base is not there for that either. It's just that it agrees with that. If I can put it that way.
That would suggest that we should be concerned. Your same logic is we should apply the same rigorous analysis on all points.
Yes, I agree. That's exactly my position, but I act for a client who's comfortable with a height in relation to boundary position there. So that's the difference in front of you. This is an adversarial process.
So what are the other?
I'm not sure I'd agree with that characterisation either.
Well, I'm certainly also not saying that my client's taking an adversarial approach, but it's one that we have different parties putting competing positions.
Okay.
So if they're, if you're saying that we remove the height in relation to boundary in relation to those matters, what's left within the plan to protect those things?
The height in relation to boundary control. It's the height control that's
Height
the
control,
that,
right.
that Kāinga doesn't agree with.
But you're
Adjacent
you're
to.
happy with the height in relation to boundary?
Yes, that's right.
Okay,
Yeah.
thank you.
Well, Mr. Whittington, I think you've occupied nearly an hour.
I've spoken much longer than I intended to. If you have no more questions, I'm happy to stop because Ms Williams will and Mr Gledhill will address the Radio New Zealand position. I was going to state what Kāinga's position is, but
I think we'll hear from the witnesses.
yeah, thank you.
Mr. Leggett. With that ringing tone, Mr. Leggett, I really don't want you to talk too long.
Kia ora, and thank you for that guidance. I think with that point to be noted, I'll keep this quite brief. I think there's a couple of observations in terms of the journey that this process has taken us on from the original PDP to where we are now. And I think one of the sentiments that we need to reflect, or we have reflected in our submission, is with the variation 1, there's a very different starting place from what council was notified from where we were at with the PDP. Yes, we're still seeking a change with respect to the distribution of zoning as related to walkable catchments, but not to the degree that we were apart with respect to the original proposed plan as notified versus the variation. That said, you've heard Porirua Bay, Parramatta, very similar issues there for us in terms of what we've identified in our submission and sought changes to. The other big driver that comes from us wearing both our public housing hat as developer landlord, but also in terms of the urban development, a lot of the relief that you'll hear from our witnesses that we've put forward relates to the region as a whole. And we're seeing how this plan works in conjunction with that of its neighbours in terms of the 5 jurisdictions that make up Greater Wellington, and looking for a framework that can work well in Porirua, that can equally work in Hutt, that can equally work in Kapiti or Wellington. Because if you're developing in the region, you tend not to just be developing in one place, you're working across the region. So a number of the respective changes that we've sought come from that angle. There's been a lot of commentary in the evidence around design guides and their role, and I think the one thing that I would offer here in terms of how we use those, and there's been some commentary around pulling out particular clauses from our own internal documents, and I think the challenge there is it's not individual clauses. You can't just read one clause as a single outcome. You actually need to look at all of the rules. Front fencing is stated there in some of the evidence, but equally so is private outdoor living. So if we have outdoor living to the street, then we're not going to see a 900 or 1200 high fence. Our design guides are going to call for fencing that provides privacy, because we do install pool fencing or equivalent. If we leave it bare like that, and that is the private open space, people who populate those dwellings will come with their own makeshift amendments to that fencing type to provide the privacy that they need in respect of the outdoor living court. So the design guide for us is a big part of our briefing process. It's our instructions to our consultants, but it's by no means a regulatory tool that we use internally as a stick, you must tick all of this in order to have the project proceed. It's part of the material that we provide our design consultants, our view of best practice as it applies to public housing and the urban development activities that we undertake, but by no means is it the ultimate arbiter or decision-making tool. It is part of the process that we use for design. That also links to some commentary that you will note is offered only in my evidence and it isn't picked up in the evidence of our witnesses, which relates to the number of units permitted in the high density zone. And that's part of the tension that we see as applicant, in that the high density zone, where you're using 3 units as the trigger for design assessment, doesn't give you that degree of certainty with respect to the higher intensity that's anticipated there. And I guess a degree of nervousness from us as applicant, looking at just shooting straight to a design guide, which invariably when you work through it, if you read it as a number of standards to be complied with, there's an inherent conflict between them as you break them down individually. That you don't just read every single design guide as a whole story and have an automatic outcome. There is trade-offs within the design process, and elevating the design guides to a decision-making tool, in our view, makes those trade-offs regulatory, as opposed to part of a design process that informs a total application that should be submitted to council, then considered against the objectives, policies and assessment criteria that council has prescribed for the district plan. So that's how those two things tie together, and why that's referenced only in my evidence and not that of our witnesses. I think I'll leave it there in light of the brief that I've had, and see if there's any questions.
Only one from me, Mr. Leggett. You've emphasised in discussion of policies relating to health that it's not something that planners are particularly good at exercising and assessing, and the emphasis should be more on amenity effects. The question for you is, at a conceptual level, why shouldn't health be the priority and amenity secondary?
I would have to agree with that statement. Amenity would be a subset of that. Health takes primacy, and if you go all the way back up to Section 5, it's the health and well-being is what's cited there. So,
Commissioners, any other questions for Mr. Leggett?
Mr. Leggett, on the issue of design guides, I acknowledge what you're saying about danger of getting into a checklist tick box type scenario with those. We put this to Mr. McIndoe on last week, and he agreed that's not the role of the guidelines at all, although that might have been the approach in other jurisdictions. So I just wanted to let you know that we have some questions from Ms. Williams and Mr. Ray on that in respect to how particularly the term consistency with the guidelines might be interpreted, and there's no real question for you, but just to acknowledge your point there.
Yeah, that's the exact concern.
Yes.
Who's next?
Before I hand over to Mr. Cullen, I just thought reflecting on what Mr. Liggett's just said and the question, the discussion earlier about the role that Kāinga Ora is playing here, we are testing the council. There's no doubt about that. But at the same time, I should have acknowledged right at the start that, as you may have read in my submissions at paragraph 1.3, that Kāinga Ora considers the outcome that the council has come up with here to be one of the best in the country in terms of implementing the NPSUD, and I think that's important to recognise. But we are still testing the position in a few areas to drive hopefully a better outcome. So I'll hand over to Mr. Cullen.
Thank you. Perhaps in starting I might, and I apologise for this, you've not allowed Mr. Leggett to do this, but I might tell you a story about who I am and what I do. And my area has evolved from working for a firm of economists and statisticians where we modelled all of Westfield's shopping centres across Australia. And when you're dealing with large econometric models, that are gravity models, regression models, transport models integrated together, and you're dealing with homogenous entities like shopping centres, it became very easy for us to determine the performance by retail category of particular shopping centres under Westfield. So, but it became very clear to me after working for this firm for about 7 years that there were a whole lot of other values that centres provided that shopping centres didn't. And so I left that firm, started my own practice, and started looking at things like the urban environment, things like traffic, things like architecture, and those sorts of things that seemed to make a difference in the way that we understood and worked with and liked places that were very different to shopping centres. So as a consequence of that sort of working with the Western Australian Planning Commission, I was asked to evaluate all 63 centres in the metropolitan area of Perth and work out whether there was an employment story related to built form and centre type that was important when planners were considering how they valued centres and hierarchies. And I will say, as a consequence of that work, it became very clear to me that you need hierarchies when you deliver retail-only shopping centres, but when you're operating centres in the urban environment, hierarchies take care of themselves. And so hierarchies are very much a product, I think, of 50s and 60s planning as a consequence of allowing the overdevelopment of shopping centres, and it has to do with movement and a whole range of other things. But one of the things that we did discover in looking at all 63 centres in Perth was that shopping centres on average employ in Perth about 606 people, and we separated these centres into three categories: shopping centres, which were just, as we understand it, internally focused, car parking dominant, not mixed use, and then mall-dominated town centres, where you had a traditional urban centre that had a mall grafted on it to the point where the mall had taken most of the activity out of the public realm. And in reverse, you could possibly describe Porirua in that category, and I'll talk about that in a minute. And then urban town centres, where if there was a mall, it wasn't dominating the pedestrian environment in the street. And then we looked at the employment performance of each. And as I mentioned, shopping centres employ around about 600, a bit over 600 people. Mall-dominated shopping centres were employing a little over 2,000 people, and urban centres were employing about 2,600 people on average. We also recognised that mall-dominated shopping centres were 67% of those were regional centres, in other words, very high in the centres hierarchy. But town centres without a mall, about 23% of those were regional centres. In other words, smaller centres that were urban were generating more employment than larger centres with a mall attached to them. This is important in an economic story in the sense that the characteristics, the built form and urban characteristics of a centre are meaningful in terms of economic performance, because we know that retail jobs are the lowest paying jobs in the economy. But if we use retail as a lever to generate intensive pedestrian traffic in the urban environment, then that switches on the demand for a whole lot of other things to want to be in the same place. And I wanted to talk particularly about that because it goes to my expertise. I don't do detailed, very intensive macroeconomic studies that you get from people like property economics or market economics. I take that work, I used to do that work in the past and I understand it. I take that work and develop it into, I guess, a more subjective story about the qualities of the urban environment that we need to understand in order to get urban economics to work better for us. So I hope that gives you a bit of an understanding of where I come from, because perhaps my evidence is a slight variation on what you're used to seeing. If I need that sort of work, I'll grab Tim Heath or Doug Fairgrave and get them to do it for me, but typically my work takes over from that. How do we convert that into something that's meaningful in urban economic terms? One of the things, just in terms of density yields, I accept the existence of local politics relating to growth and density. It's difficult for politicians and councils to take a step beyond what is the minimum required in terms of the NPS. And going beyond that does present a political risk. Having said that, I agree with Mr. Whittington, that you've done better than most. So Kāinga Ora's propositions represent only a marginal increase in total development capacity, and I don't believe it's overreach or over the top. The other thing that I question is the method used to calculate the supply requirements of the NPS do not appear to include levels of dwelling undersupply that are mentioned in section 32 and 40A reports for Porirua. Infrastructure, I noticed that some consultants in other parts of New Zealand have evaluated infrastructure ready in terms of their application in terms of growth and timing. And I haven't seen that in Porirua's case, so it's a question for me. In terms of place by place and determinations of short, medium and long-term targets. Are we infrastructure ready? What does infrastructure ready mean in terms of those? We all accept that proximity to goods and services is an appropriate inspiration for density. The NPSUD uses the term at least a walkable catchment to measure intensification boundaries. I wish to refer to a range of walkability studies that highlight the influences of design and mixed use on walkability. That's the 3Ds at least, density, design and diversity. Diversity is not just in housing, but also in land use. Planning tends to ignore the influence of the quality of the walking journeys in its definition of walkable catchments, instead relies on the appeal of the destination, whether they be centres or stations. And Kāinga Ora proposes an incremental ground floor provision with a low entry planning threshold for apartment buildings. Commercial, I should say. Small and incidental street-friendly outcomes, if allowed, can increase walkable catchments and enliven otherwise monocultural residential neighbourhoods, and they come at no competitive cost to centres. We're talking a very small development option or opportunity here that does have a major effect on walkability. The supply effect on affordability, I submit that Kāinga Ora propositions deliver greater realisable yields as they offer more development potential on essentially the same sites as Variation 1 PC 19. Council has followed the guidelines that the NPSUD set out in Objective 3, but I submit not Objective 2, where competition for market share and affordability are the prime objectives. Kāinga Ora's increase in realisable capacity in part addresses Council's obligations under Objective 2. Addressing the viability of Porirua Centre, I admit or confess to being one of the consultants on the 2009 Porirua City Revitalisation Plan. At the time, we didn't challenge the appropriateness of large blank wall boxes at the interface of the city and the harbour. In those days, we all believed there was a net benefit of using the city as a destination for all major shopping, including LFR. As time passes and we all learn, we know now that LFR has almost no relationship with other retail, especially in Porirua. The shopping mall's appeal as the major shopping destination compromises pedestrian energy in the city centre. This, combined with poor urban architecture, subordinates the urban environment to the point where it lacks vibrancy and a sense of place. How and where do we find an amenity lever that changes these dynamics? I submit that the answer does not sit within the current Porirua Centre. For me, the only other place available to us is at the harbour interface. We made a mistake, not fatal, turning our backs on it and allowing big boxes to block our experience of it. That's all from me.
Just picking up on the last point, Mr. Cullen, is there a danger if the metropolitan centre is expanded to what is now the large format retail zone, that it'll effectively pull commercial activity to the north and hollow out the area we're sitting in, and so you'll have two major metropolitan areas, one centred on North City and the other up the road, and something akin to a commercial desert in between.
Well, I think the benefit that we're sort of seeking in relation to the zone is more to do with residential and incremental retail on ground floor and the harbour interface. We've got buildings with tilt-up slab concrete walls that ignore context and ignore the harbour. So I believe within 22 metres we're not going to get anything above in terms of another multi-level shopping mall, for instance. I just don't believe the market. And hopefully the planning provisions won't allow it anyway. But for me, it's about where do we start our residential story? And at the moment, we don't have a trigger. The amenity and the quality of the public realm inside the current or the proposed metropolitan centre zone isn't good enough. It's spatially loose. It's architecturally ordinary. And so that's what worries me. But I think you're right. It's a concern. I don't categorically say it won't happen. But what I am saying is that the current condition is so ordinary as to require adjustments that we haven't made before, because we're essentially trying the same things that we were looking at in 2009 and nothing really meaningful has happened.
The other way of putting it, can't get any worse.
Well, interestingly enough, if it does get worse, it may actually be easier to redevelop it. That's the other thing in economic terms. At the moment, I hesitate to say it's on life support, but because it's possibly not. But the inspiration to knock it down and start again probably doesn't exist at the moment.
In relation to your discussion of Mr. Osborne's supply and demand assessments, you've said your view is that what Kaingora are seeking is not overreach. Have you quantified the effect on of the upzoning that Kaingora has proposed on theoretical and realisable capacity?
The answer to that directly is no, but we've done the same exercise for Wellington, and we got to about 20% incremental increase. I suggest it's probably less here because you've gone a bit stronger, but it's in that region. It's not multiples. It's marginal increases. But again, I can't put a number to it. That's just my wet finger in the air.
And in terms of the effect on affordability, of course, we've seen in the last 12 months housing prices drop significantly, but affordability doesn't seem to have improved any. If anything, it might have got worse with increase, and if it hasn't got worse yet, it will be when everyone's fixed interest comes off. So is the classic supply and demand analysis borne out in practice, or are there too many multiple variables sort of stirring the pot?
Yeah. So people at Treasury would probably think that housing supply is the major issue in terms of affordability. I don't entirely agree with that because the multivariable issue is at play. So my best, I suppose, advice would be that we're obliged to go for more. We should go for more because it does have an effect on price. The level to which it has an effect on price is possibly muted. And you might notice in my evidence, I think somebody put, it's a trite statement to talk about the supply effect on affordability. That wasn't supposed to stay in the evidence. That was a correction, an error from somebody else saying it's a very trite thing to say, Mike, and it stayed in the evidence. But no, it is influential, but the level to which it is influential is very much multivariable, for sure. And at the moment, you've gone through, like Australia, a process of interest rate increases where you'd come from before the ability to borrow huge amounts and leverage huge amounts on a small interest rate. And so, for sure, affordability is being attacked from both ends at the moment.
Taking your paragraph 8.3, growth supported by plentiful housing ahead of market demand. And I'm thinking, well, an institution like Kaingora with social objectives can and possibly will move ahead of market demand, but it's hard to imagine any private developer willingly or knowingly doing that.
You're identifying one of the multivariables, yes.
Any other questions, Commissioners? Julia?
Just one from me, Mr. Cullen, and it's goes to the directive in the MPSUD about providing sufficient capacity. And in your 615, you say, well, we may have to increase the 11,800 target figure. And for that reason, you don't consider that additional dwelling capacity sought within the KO submission is an overreach. You've seen Mr. Osborne's figures. I think they were updated when he presented, and I'm not sure that we asked Mr. Osborne for a table of updated.
No, not yet.
Yeah, it was sent through early afternoon. I've fast admin to forward them to yourselves.
Okay. I can't remember the figures offhand, but it struck me at the time that there was still sufficient capacity. I think he even updated his figure on the hoof from 11,800 to 13,000 to reflect a idiosyncrasy. So we're still, in his view, there's still sufficient capacity.
Yes, well, it depends on how you define sufficient capacity, I guess, and how certain we can be about 30 years of cost variations, 30 years of demand. I can go, and so are we looking at multiples, or is it appropriate to simply take, well, we've achieved the target and therefore we have sufficient capacity given the variables of the market in the next sort of 30 years. My view is that he doesn't know, I don't know. He's complied with I guess the methodology provided for him, and for me it's as good as it gets. I mean, I'm not questioning the amount of effort and intellect that's gone into this. All I'm saying is, for what reason would we stop adding more or enabling more? Is essentially my point, and I just worry about the fact that that an undersupply is referred to but not numerically quantified in the documents.
Just repeat that again.
The undersupply, there's references, and I can't remember if it's in the Section 32 report, I think it is referred to, no, actually it may be in another document, but officers are referring to ongoing undersupply, but we don't actually have a figure for that, so we don't know what that is. And so I guess my point is, let's assume that some exist, but what's wrong in terms of realisable capacity by asking for a bit more, just to ensure ourselves from the uncertainties over the next 30 years.
Okay.
That's not easy. I understand that's not easy.
There's no question here, but just for your information and for the benefit of Mr. Ray and Ms. Williams, we've asked the council to give us some proportions of, or a number of things, how the general residential zone was split into high and medium, then what proportion of that is taken up by the constraining height variation controls, what proportion is given to the more positive height variation controls. So that information's yet to come.
Okay. Well, that would be helpful for all of us.
That's what we thought. That's why we asked for the information.
I think that's it from us.
Thank you.
I also think we need a cup of tea.
Yeah.
Before we roll on, fortify ourselves for a discussion with Mr. Ray. So we'll break. We'll try and be as short as we can, just enough to have a cup of tea and slurp some of it. And we'll be back on the job. we wondered if, before launching into Mr Ray, we should hear from Mr Gledhill, and he could do a runner.
Well, I just checked with him actually, thinking he might have to run away to get a flight, but he's staying here tonight, so we're really in your hands.
Over to you.
What I was going to do was, if you're happy to, in the question you asked of Mr Cullen about Kāinga Ora social obligations and the way private developers tend to follow the market rather than jump out in front of it, Mr Liggett actually might have some brief reflections on that point if it would assist, but I'm in your hands.
Mr Liggett is going to tell us Kāinga Ora has no social obligations and operates solely as a business. Sorry, just kidding.
No, not quite. Just to reflect on that point about how we may do things differently, and the reflection of the market activity responding to that. But the key, or some of the key ingredients for us to deliver that. So, if I was to draw on Hobsonville Point and on our Northcote project, the planning framework was a big part of both of those, and getting those settings, dare I say it, forward-looking, not status quo. When Hobsonville Point started, the first thing that was done was a recraft of the planning framework to actually facilitate a very different outcome on that site. You know, there's 3,500 homes to go in there. We're almost finished, but if we took the operative provisions at the time, would have been about 1,000. And when you're having the conversations with developers right at day one, everyone's saying, we build 1,000 houses, we'll cookie cutter the sections, we'll standalone houses, done, we're out. It took the planning framework first to be adjusted to facilitate that outcome. Now we're seeing bleed from our site across Hobsonville of new typologies and things being done differently. In that site, yes, there is still market and very high value stuff, but equally there's a range of housing types in there, to the degree where we're below, in some of the product, below Auckland average prices, and that's a new build subdivision. Similarly for Northcote, the original scheme for that, dictated by the planning environment, 450 homes on that site. When we ultimately took it to the final design testing and the plan provisions being crafted through Auckland's process, we're set up for 1,500 homes out of the plan provisions. Now, on the ground, that project will deliver between 1,300 and 1,500 when it's finished. But it took the planning framework to give certainty, even to our organisation, to actually push the innovation forward, because we still had to deal with the back end of contracting with the market to deliver that outcome. We needed something certain in order to allow the innovation to occur. So I think the reflection of forward-looking, and in the case of Porirua and going to that metro centre zone movement, what is the difference here? Well, if you're moving north, you're moving towards, despite the previous submitter, you're moving towards an amenity that doesn't exist in what is currently the metro zone. You have the coastal outlook, albeit of various states, depending on the people you talk to, and yes, there's environmental concerns there, but there is a different degree of amenity offered there than what you see in the heart of Porirua City.
Okay.
Mr Ray.
Good afternoon. I'm just wondering whether that joint witness statement has been printed and circulated.
Yes, we have it, but we have not read it. Where is it?
You guys got it
in my pile of paper. So, cutting to the chase.
Anyway,
do you and Mr. McIndoe disagree on anything, and if so, what is it?
we have agreed on a lot, and it has addressed a lot of my points in Appendix B of my evidence around the design guidelines. And it's through discussion with him has been very useful to understand the intent and how it was meant to work. And I also raised the issue around the consistency and relevance type wording. And that's the context in which I tried to assess those guidelines. And from my perspective, if there's a clear policy of outcome, which then needs to be assessed, which the guidelines helps you with that assessment. And I think that's the best way of doing it, particularly when you might get a non-complying activity status and you're required to consider the objectives and policies in more detail, perhaps. It basically sends you directly to the guidelines and whether you're consistent with that. And so we've basically recorded that all the matters in the guidelines are relevant, and it's then a weighting as to, you might get to a point where a particular part of it, I've considered it, it actually doesn't apply, or and you record that in that assessment.
So you said all matters are relevant, and then you said you then consider it and decide that some aren't relevant. So I think you need to explain that to me.
Well, that's right. So the matters in there are relevant for consideration, and when you then consider them, you might determine that a particular issue might not be as important. Like, I think we used the example of a development on a rear lot. The matters of the building fronting the street is not so relevant, and you would record that in your assessment. My concern was that you would get some pretty savvy developers who go through and try and determine what's relevant and what's not, and then how are you consistent with that? So the proposition is to basically say, here's the policy, in which basically if you look at P7, P8, they list out them quite specifically the matters that need to be addressed, like shading or sunlight access. And we're suggesting that P10 should do the same thing, and then that's backed up by assessment using the design guidelines in terms of that assessment.
In terms of that issue, we discussed with Mr. McIndoe at some length whether it was the whole design guide that consistency was required with, or just the design objectives in the design guide. And then we went to the next phase, is it just the relevant design objectives? And Mr. McIndoe thought the latter. And so what we tossed around for policy P10 was a provision that said something like, I've forgotten the context, but it was... so the test is whether the development is consistent with the relevant design objectives of the design guide. Now, does that go part way? I'm not suggesting it might solve all of your problems, so that then all the illustrations are just that. The focus from a regulatory point of view is on the design objectives.
And so that's, that's part way. However, we've tried to take those objectives out of the design guide and put it into the policy. So if you see, there's a relationship there of what's listed in Ms. Williams' evidence.
So the next question is, what's in your policy that's not in the design guide, and vice versa, in terms of design objectives? Are your policies at a higher level, or but capture everything in some form or other, or are there some missing? Or
can I just rephrase that? I think because there's potentially discussion at cross purposes here. What you're doing, Mr. Ray, is in the absence of having a design guide sitting in the plan, isn't it? That the policies contain the matters to be considered.
I think it could be both.
Yes.
But it was in the context of it not sitting in it.
Yes.
Exactly.
What we put to Mr. McIndoe is that if the design guide remains intact, or
as a concept,
why not provide some guidance in P10, in particular to ensure that the consistency test is not undertaken in relation to every single guideline, but is undertaken in relation to the relevant design objectives that sit above those individual guidelines, so that there's a sort of a hierarchical type of approach.
Yes.
So that were the two. Well, there are two options that are in front of us.
Yes, so that's one way of doing it.
Yes. Okay. I guess we've got to decide.
And it comes down to the plan and how it works, right?
Comes down to what's most appropriate.
Correct.
Yes.
And to your, and what's the answer to my question? To your mind, are the policy directives that you and Ms. Williams have suggested in P10, do they include things that are not in the design guide, and do they omit things that are in the design objectives? And if so, what are they?
It started off as taking the objectives into the policy, and then we have refined that in terms of how they might better sit as a policy. Whether they include other things, I'm not entirely... Can I just...
So, putting words in your mouth is the answer, not intentionally.
So P7 and this is in. Oh, have you got the residential one? No, let's let go. I don't think there's anything in there that's particularly different. It's trying to simplify that into a policy using those design objectives so that you then look at that and you say, what's a high quality, legible, safe circulation? And then you go to the design guide and you try and work that out in terms of the context and what you're proposing. So it's still relatively high level.
I don't think Ms. Williams was pursuing any changes to P8, though.
No.
Res P10 is the policy we're referring to.
Yes.
Yeah.
Yes.
Because that's the policy that
Cross-references the design guide.
Yeah, yes. And it's triggered for 4 or more development, 4 or more units.
Yes. No, you'd mentioned P7 and P8 earlier, but
yeah. So they list out things like the extent to which shading is. Well, I could probably bring it up.
And if the policy refers to the design objectives in the design guide, and the design objectives in the design guide are not materially different to the policy direction that you're suggesting, does it come down solely to an issue of policy of drafting preference at that point?
I think it would enable both to occur, and if you are mindful to have the design guides not in the district plan, it provides a very good policy to talk about what's required. When I assess proposals, I work out what criteria we need to look at, what design guide is helpful to explain or come to a conclusion on a proposal, and it generally is not necessarily just what's in the district plan, but other examples and other matters. So it was drafted to enable both. I'm not particularly concerned either way. I think someone has to assess whether you achieve these outcomes, which is what's listed in the design guide, and therefore you can have it in in the plan or outside the plan. If it was in the plan, you may not need to double up on it.
You place some reliance in relation to the design guides on the fact that Queenstown went the non-plan route, sitting outside the plan. I don't know.
Jack's point is Queenstown Central's not.
Yes.
Yeah. And it depends on how it's administered, right? So Hobsonville Point's another example where it's basically a developer-led design guide, and they go through a plan process to work out whether it's appropriate before it goes through to a consent. And if it gets a tick there, it's seen more favourably, let's say, in the application. Jack's point is another one where they want specific outcomes that are quite fundamental to their environment, and they manage it through a separate what's it called? It's a design panel within their rules and local. What am I trying to say? The Residents Association. That's what I'm trying to get to. Yes. So they and they're embedded as part of a resource consent. So they've been developed as a resource consent. That's the outcome that's meant to be achieved. The association puts together a design panel, they review it, they say yes it does or it doesn't, we're happy with that, then that gets put forward to another resource consent or if necessary.
At this point I should tell you I was on the panel that decided the design guide should be outside the plan for Queenstown, and that was a situation where the council planner said that the council didn't want to manage design, and there were a whole lot of holes in the draft design guide, so it ended up being quite an easy decision that it be outside. But so the proposition I'd put to you is that the Queenstown situation may not be as applicable as you're suggesting.
Okay, sure.
But another regime that you'll be familiar with, Mr. Ray, is the New Plymouth regime, which might be more applicable. I'm conscious that you gave evidence in that regime, and those decisions are yet to be released. Yeah,
correct.
Okay, let's go into we haven't got diverted into design guides. Are there any more questions on design guides?
Have we finished the joint witness statement?
I think the answer was you've agreed on everything within the design guide.
What we could discuss, there was a couple of matters that we haven't we didn't get time to.
Say, you better tell us what those are.
We deleted them. Can I provide that to you subsequent? I'm just not going to, it's going to take some time just to work through that.
Well, I wonder if you think about it. Well, Ms. Williams is giving evidence.
Right.
Just park that thought, because
Okay.
I think we need to collect everything we need from you, if at all possible, tonight.
Okay.
And it will be tonight at this rate.
And I just say that in there we've also agreed some changes to some of the wording, to some of the policy design explanation.
In the guidelines themselves?
In the guidelines themselves, yes.
So can I just slightly come back to sum up your position, which is you are neutral on whether you have guidelines as part of the district plan, or they sit outside, but either way you'd like to increase, if you like, the criteria that are embedded in policy 10.
Yes.
Right.
Yes. So it's clear in the policy what the outcome is expecting, and the guidelines help you assess whether you achieve that or not.
you don't see that as a slightly more, in the interests, I think Mr. Rackland discussed quite a lot with us about simplicity and easy understanding, that you're maybe adding to the complexity with a belt and braces approach. So you're adding extra detail in your policy, and you've got your design guideline. You don't see any issues with that?
I just think that a policy should say what the outcome is. I mean, if it's directly embedded into the plan, yes, we might be doubling up on it. But the design guide would say when considering this policy, because we haven't copied word for word, they're slightly different, and we've massaged that to be different. And then you go through the design guide. You're not just looking at a tick box exercise on each of the objectives in there. You're kind of saying, well, how does this achieve that policy? How does the proposal achieve that policy? And I'm going to use the design guide to understand and come up with some assessment as to how it does or it doesn't, or whether it's relevant or not. And I think the discussion with Mr. McIndoe has been very positive in that regard, and that he doesn't expect that the design guide is a tick box. You have to read the whole thing in its totality and go, okay, this is a rear site, right? How do I do this? This is a front site next to a commercial centre. How do I do that? What's the design implication of that? Do I achieve all of these things that set out in the policy? Yep, by doing these things. And that's rather than just saying being consistent with it, trying to set the framework for which you assess that. I mean, it's quite planning actually, but that's how I learned anyway. And like I say, if you're trying to work through a non-complying activity where you're trying to determine whether you're consistent with the objectives and policies, then that adds another layer of consistency to the design guide, and it's like, all right, okay, how do we do this? So I'm trying to simplify it actually by saying, here's the policy, here's the design guide, and here's some examples of how you can achieve that outcome. And I'd note that the guide is relatively open. It's not specific, and so it is really, you need to look at the context and say, how am I responding to the context? And I want to, the whole planned outcome needs to be factored into that, because we're potentially changing the urban environment, urban form quite significantly, particularly in the high-density residential area. And so what might be appropriate and a response in terms of the existing physical environment might be quite different to what is expected in a planned outcome in terms of what you might want to put there in terms of a 6-storey building. And so, and I think that comes to the crux of the issue around height in relation to boundary and height and all those sorts of things, and how you're expecting that change to transition over time, and how much you apply a protective nature to existing development within those high-density residential zones, for example. Because the policy, NPS, talks about that these places will change. And we're saying that it's not necessarily appropriate to make sure that the building responds exactly to its existing neighbour, because you probably never get to 6 storeys in that regard, because it needs lots of transition and space. And so what is that planned outcome? Is it 6-storey buildings? Is it 5-storey buildings with a height in relation to boundary? How much 6-storey buildings are we enabling here? And so that, I mean, it's all tied together as a concept. And perhaps if I'll go on about that height in relation to boundary and that proposition, there's kind of 2 different options here. One is enabling 6 storeys, but to a potentially lesser degree than what the 19 and 60 would enable, particularly on smaller sites. So in other words, you might get more smaller sites being able to be developed to 6 stories with 19 and 60. Is that a good outcome? Probably, because it widens the market. Right. And the concern that Mr. McIndoe's got around that bulk to the street, if you were to amalgamate, which we're saying is probably likely, you're going to probably amalgamate some of these sites, and it might be 2 or 3. And again, if you have to amalgamate sites, amalgamating 2 is far easier than 3 or 4 or 5 or 6. So are you enabling density on 2 sites? Okay. And then if you amalgamate, say, 4 or 5 or the whole block, then you've got effectively the same outcome in terms of the opportunity for buildings to front the street as what the 19 and 60, because the 19 and 60 disappears. There's no height in relation to boundary on corners. All the internal boundaries get, you don't have to comply with that rule. So then it comes down to, is it a good design? And then you're designing the building. Okay?
So, Mr. Ray, can I take you back to what I understood you to say before, was that you said that there were some amendments to the actual design guides that you and Mr. McIndoe had agreed to. Are they in this joint witness statement?
Yes, they are in red, particularly at 8.
Right.
Actually,
Don't go there. We can read it later.
Yep. So they're contained in here. How many are there?
There's one change
Just one change.
to building height. No, sorry, entrances.
Right, 2 entrances. Excellent. Thank you.
So going back to the start of your evidence, can I ask you, you took 1.6, you visited locations on the public road network and reserve in Wellington District. Sorry for the fact we're not in the Wellington District, but it's not really picky.
Sorry, region, yes.
And your visit with Mr. Cullen focused on the centres in the Wellington region. So where in Porirua have you actually had a good look at it on the ground?
I've had a good look around the centre. I've, as part of the Linden example for Wellington, looked around the Linden southern area. We have driven all through Cannons Creek and the eastern side of Porirua. I haven't been to every particular location and site and boundary. I've been to Tahi Bay and looked at the centre there and the opportunity around the centre and the beach, the mixed use zone there. I've been to Parramatta and gone around those areas, mainly at the centre area. So when we filter further out, I've gone to less of those more suburban locations. Mana have gone to those areas up on the hill and around and where we're looking at providing higher density versus where the council sits on that. Plimerton, we have gone through the centre of Plimerton. I note that the area to the south east of Plimerton that's proposed for high density, I've mainly looked at that through Google Street View. And then we drove around the coast a little bit of Plimerton. I haven't walked all of that area. And then Porirua Bay, been to standing on the station through to going down as far as we could on some of the higher roads that overlook the beach to understand the topography and the school and the relationship to all of the centre and the station. The western side of Porirua Bay is, I haven't physically gone down as far as we're now recommending on the 800, mainly relying on Google Street View on that. Where else did we go? Whitby. Yep. So the main centres where the growth was proposed around it, we have looked at, and it's not an extensive walking scenario. It's mainly by vehicle.
Next, on terms of your methodology for walkable catchments, you say you're emphasising the not just based on the existing condition. Understand the point, you need to look forward, but do you need some reasonable certainty that something's going to happen?
I think there's some. I think there's some expectation that there's reasonable opportunity. Whether that happens or not is going to be market led. And if I take Porirua Bay versus Parramatta, for example, Porirua Bay has a greater opportunity for high density to be delivered, and hence, I started questioning, well, why is the centre not bigger? If you're, because the two need to go hand in hand. If you're creating the opportunity for more people to live there, what are the services to support that? And Parramatta is actually pretty constrained in terms of connectivity and steep streets. And so through the process, we're saying the analysis is basically determining that Parramatta is less appropriate for six-storey development because it's really hard to get there. But other places like Mana actually have a really good opportunity for particularly development up on the eastern side of Mana Esplanade around Mana View Drive, where it provides amazing opportunity for higher density amenity, where the private market would more likely build apartment buildings. And the fact there that it doesn't have a school is one aspect that could be addressed in the future if there's a demand in that area. However, it's got amazing open space networks. It's got really good opportunity for the centre to grow, and particularly now the pressure of the state highway has been reduced. And so I looked at the plan and said, well, if you're enabling high density residential along the Mana Esplanade, why does it not go further up the hill within a walkable catchment of the train station?
Well, on that score, you said 6.3, parts of the street network to the east of Mana are steeper than ideal. How steeper is steeper than ideal?
So I've done a bit more work on that, and I think it's really hard in Wellington because you've got steep streets and people still walk them, and it's steeper than perhaps other centres in Auckland, for example, where I'm from. The local Government Act requires that no streets be steeper than 12.5%, unless applied for in a district plan or enabled in a district plan.
That's a really old standard. That's the...
That's yeah, that's right.
That's the 74 Act, isn't it?
So in terms of government direction, that's where I've started from. And it does apply to new streets. So any new development would not have anything steeper than that. And
there's a New Zealand standard that governs that, isn't it? Is it 4404?
The subdivision standard, yes. Yes.
The gradient of streets.
It includes street design, yes. And Auckland, for example, has a maximum of 8%. So it's where you strike that balance, and because it's related to pretty much existing streets rather than new streets. What's the opportunity of those streets? And there is some quite steep streets that have really no footpath, no opportunity for a footpath to be added, and basically requires people to walk on the street. And in that regard, it's not an appropriate environment. And basically, there's a steep drop either above it or below it that doesn't provide for that connectivity.
Go back to the original question. How steep are those streets in Mana?
So in Asheron Street, it's about just over 12.5%, I believe, in places. So they are up there. However, if you were to walk to the centre or a distance from the centre from Mana View Drive, it's only sort of 300 or 400 metres, depending on where we're taking it from.
Yes, but if you're looking at those gradients, I mean, you gave a lovely little bit of information about yourself riding a bike to the supermarket with panniers, but I suppose I'm putting my mind to thinking of pushing a child in a buggy up Asheron Street, or carrying my groceries, including large packets of disposable nappies, or even, heaven forbid, towing a toddler up, you know. And we had a very impassioned submission yesterday from someone who was less than physically abled, and the implications for people, for the sort of people who may be able to live in developments on those steeper gradients.
I'd agree.
So,
it's a real issue.
That, no, does that change your mind about the extent of that high density?
I have thought about that, and from where I'm sitting, it's providing an opportunity for more people. It's not going to cater for everyone, and it's, when you think about Porirua, there's actually not a lot of high density residential zone really enabled. There's effectively, one side of a street at Parramatta. I mean, it's around a station that provides direct connection into Wellington. It's nothing. And it's been limited through our process so far. And look, I'm not saying it's perfect, and we could, there's still potential for that to be refined further. And the discussions we've had with Mr. McIndoe has been quite useful in that regard. But yeah, it's providing the opportunity for more people to live in a different density at a walkable location to the centre. It's not going to provide for everybody, that's for sure. So, but there is opportunity at Mana Esplanade for accessible options. I mean, it's just the same as whether you go and, you say you can't put MDRS up on the steeper land because people in wheelchairs can't access it. I don't think that was the intent of the policy.
No, and I don't think that was the intent of my point. But you've made a response, but I still think that there's a limitation on. It's not the people you're excluding; it's the limited range of people who you actually are including in those steeper areas. And let's face it, as you go all the way through Porirua, what you have is a narrow coastal edge, and then you've got a coastal escarpment, effectively. So your opportunities for expanding up into the hill areas, which, as you say, are they're steeper than ideal from a walkability perspective, but they are limited. I mean, we drove and did some walking yesterday, and a lot of questions came to mind about just how walkable these are.
And I suppose it's a consistency thing as well. And so the area that I was talking about before, south-east of Plimerton, the council's proposed high density that snakes up the hill up onto the top. Now that's the same sort of steep gradient. And to me, that doesn't make as much sense as the area right next to Mana, where it's got all the facilities. So if you're saying that you can't have it because it's too steep, then there's probably areas in there you've got to take out as well.
Well, the Plymouton Residents Association have suggested just that to us. So, I understand the point about consistency, but it works both ways too.
Sure, absolutely.
In terms of the point you make about sort of the Mana having potential because less traffic, the traffic evidence we've heard is that the effect of Plymouton Farm, Northern Growth Area, will pull traffic through the Mana Esplanade to pre-TG levels. So I'm wondering whether you have factored that into your...
Is that heavy vehicle as well as private vehicle stuff in terms of the type of transport?
I think less heavy vehicles, but still as a proportion, but still quite a few.
The ones that avoid going over traffic.
You don't want to pay for the extra fuel.
And yesterday, Mr Blackmore from Waka-Kotahi did confirm that they have no intention to revoke the state highway status of the road.
And so there's Mana, and of course, and this also goes to the Porirua Bay Centre, which will still have a state highway through the middle of it, particularly if it's expanded to be both sides of the road. So as I say, accepting that paraphrase of the traffic evidence we heard, what's your reaction as an urban designer?
I would hope that we could do something about that and actually create a street that caters for both, and that may encourage trucks to go another way, i.e. slower speeds, design interventions that actually create the place for people to walk.
You'll understand that the Mana residents are a bit cynical, having been promised the earth by the road transport authorities for decades, and not.
Yeah.
And now being told that they're going to get precisely zip out of the
Waka-Kotahi.
Out of Waka-Kotahi.
Well, that's a shame, isn't it? I mean, what the alternative motorway has really enabled is for these places to become really good people places. Yes, they still have a transport function, but there's many roads in Auckland, for example, that have high volumes of traffic through it. There's still high density development proposed around them. So again, it's the speed and the noise management of that. And so that, and actually, Porirua is another example where they've retained the state highway as the alternative route through the toll motorway, and that's actually been enhanced through urban design initiatives to slow the whole traffic down. So it still provides an alternative route, but provides a much better urban space for people, and development has occurred around that because of it.
Commissioner McMahon.
Yeah. Mr Ray, I just had a question on the Porirua Bay centres and your paragraph 8.1, conscious of the position of Council for Kaingaroa about mandatory approach. If the panel were to go down that line and identify Porirua Bay as a high density residential zone, might there be a case to have a reduced walkable catchment associated with that of less than 800, say 400?
There may be a case in that it might direct people to that area first, but I think the plan, because it's so forward-thinking and change, it should provide an opportunity for that change, and it may not happen for 30 or 50 years.
Yes, I'm conscious that in another jurisdiction, the Wellington one, you said that you had regard to urban form in considering walkable catchments. Is there a case for considering urban form at Porirua Bay in terms of defining walkable catchment?
In that regard, I have actually changed some of the submission positions because it didn't make sense from an urban form perspective.
And where did you land? In the case of Porirua Bay, you've still landed at 800 though, haven't you?
Oh, yes. So we as a principle around a station, it starts at 800. And then where does that leave you? And does it make sense from an urban form perspective, connectivity perspective? And some of those areas that were in submission were reduced. And we've considered the relationship of where that interface might change relative to the block pattern. Yeah.
Have you given any thought to the connectivity at Porirua Bay in terms of the ability to cross the highway?
Well, so I was hoping that, and assuming that, given that, but this might have changed from Wakakataki's perspective today, is that again could be enhanced and should be enhanced, and actually regardless of whether there's high density there or not, because if you're going to create 3 sites with 3 dwellings on it, three dwellings on a site, you're going to potentially increase the opportunity for residential development to occur around there anyway who'd want to use the train station. There should be a pedestrian crossing that really facilitates good access to the station. And I know there is overpasses and things like that, but they're not as desirable from a walkability perspective, certainly equal access opportunity.
The overpass is also quite a long way down the road.
Correct, yeah.
Okay, thank you.
And the other important perhaps is the redevelopment opportunities around the station to actually open up and provide a visual connection to some of that infrastructure, because a lot of people wouldn't even know there's a train station there from the western side.
I'm not sure everyone wants visual connection to the railway station, but...
But I suppose it's coming down to the street environment that's providing a good walkability that you know you're encouraged to go down there because it's got good overlooking, it's got people there, it's safe, it's not dark at night, and so from a public realm perspective, it could be significantly enhanced to assist with the safety for anyone, regardless of the zoning that we put in there.
Okay, Commissioners, my next question's on section 17, so that's well advanced. So has anyone got anything prior to that?
heading the same direction, I think so.
So this is the height of local centres. Consistently at 22 metres. And it's a planning point, I know, but the NPSUD, as regards centres smaller than city centres, metropolitan centres, says that density and height should be commensurate with the level of services, and which suggests to me an intention that it would be variable.
I think that's correct. I think it will only get developed if there is support for redevelopment in those areas. I suppose the 22 metres enables the opportunity to be more than it is today, and it's consistent or slightly higher than the surrounding residential intensification precinct provided. So from an urban form perspective, you could still maintain a bigger bulk, potentially higher building slightly than the surrounding residential context.
you. Well, that was it from me. Any more for any more?
Mr. Ray, I notice, just going back to the first joint witness statement, that the matters considered at conferencing. I'm just looking at point 2, the extent of the potential HRZ at Porirua Bay. You've agreed in a rather contained way that if the panel were to favour rezoning an area of Porirua Bay to HRZ, the boundaries proposed are acceptable. Did you make any agreements about the extension of the NCA, the neighbourhood centre zone?
No, we didn't. No. We didn't discuss that particularly, actually.
Right, thank you. And do you, well, to come back to that then, would you still favour the extension of the neighbourhood centre zone across the road in the light of our earlier discussion?
I think that centre zone provides the opportunity for a commercial ground floor opportunity, but it does also, depending on where you land within the high density zone. It could be either, with the proviso that the high density zone enables commercial at ground floor. So it's in trying to encourage a multi-use outcome through to the station on the eastern side of the state highway.
Did you walk around that area?
Yes.
Mr. Ray, can I take you to attachment F of your evidence with the maps, sheet 3 of 13? And the bit with the extension of the metropolitan centre zone and Mr. Whittington's option of just making that 22 metres, is on the opposite side of Tatahi Bay Road there, is there a change in terms of the height or whatever in relation to your maps that's a consequence of that change?
Yes.
What would that be?
I think that's tied up with the future outcome, but and let me qualify that north of Awarua Street, where it's I would say you take the whole height overlay to 36 metres off there.
Yep.
In that scenario.
And take that, and then what would it be if it wasn't 36? What would be the?
Well, I think it defaults back to the high density residential zone, which is 22. So it's the same height outcome.
Right.
Subject to any other additional height implications from iwi on that. Yeah.
Okay. Thank you for that.
That's it.
Mr. Ray, it's a pretty complex subject, this, and we spent a lot of the first 3 days trying to get our heads around what was being proposed, and we put lots of questions to Mr. Racklin and Mr. McAdoe, and Mr. McAdoe took us through the Urban Design Memo 20, which was attached to the 32. You've seen that document? Yes. And so we were just testing his methodology, really, and how it had been applied and whether it was understandable, rectifiable, that sort of thing. I've got 2 questions. Firstly, have you got any general comments on the readability of the methodology in terms of how it's portrayed? I'm not asking you to comment on the merits of it, but I mean, one of the things that peer reviewers often do is they ask themselves, is the methodology understandable and can it be replicated easily? So does it
Yes,
sort of...
yes, you can do that. Yes.
You can do that,
Yes.
okay. And in relation to the walkable catchments...
Well, sorry, I just thought because there's the criteria in there, which is the three main aspects, along with the distance. So supermarkets, park.
Yes. Schools.
Schools. But then there is other things like topography and those sorts of things.
That's what I was just going to come on to.
Yeah.
Yes.
So in terms of that, there's no clear, what's the trigger point at which it's in or out, right?
Mr. McIndoe described those as secondary factors, if you like, to nuance walkable catchment boundaries, and he's listed 10 of those on page 3 of the memo. And I just wondered whether you had any comments on those, any of those.
I think they're all relevant considerations for walkable catchment, and it really comes back to the point of, that they need to be there now. Is there opportunity for them to be there?
Well, doesn't it make sense to, I mean, you can apply, and otherwise we just draw concentric circles on a map around centres,
Exactly.
wouldn't we? So isn't this an attempt to at least nuance them into realistic?
Yes, it is. Yes.
Thank you.
And I agree with that.
Thank you.
I think that's it from us, Mr. Ray.
I'm just wary that supermarket and Porirua Bay question was not something that you asked any questions of Mr. Cullen on. Do you want to hear from him on that? He's just spoken up to say he's got a point to make about that if you want to hear it. But
You'll have to remind me what the question was. Since I've asked one or two.
Well, it was about the urban form of the Porirua Bay area if it was upzoned and the issue of the services and the environment that would be created. That's effectively what this all turns
Mr. Cullen
to.
has a contribution.
And
the stopwatch will be on.
Okay, we'll be here. Thank you. And it also goes to Commissioner McMahon's point around the document that he was just sorting through that comes from Mr. McIndoe. One of the perceptions about supermarkets is they're large boxes. And when you think about supermarkets, they don't need to be large boxes. They can come in quite small delivery packages commensurate with the catchments that they serve. So we can get what would normally be a New World or a Countdown supermarket of around 3,000 plus square metres. These days, supermarkets are down to about 20,000 stock keeping units, SKUs. They've got them down that far because of home brand things. So we can accommodate 20,000 SKUs in a box of 1,400 square metres, for instance. The difference is instead of 3 bays of Coke, you have 1 bay of Coke, and you're relying on just-in-time logistics to make up effectively what is the storage component in the larger supermarkets. So for instance, for a 1,400 square metre supermarket, you need about 1,400 dwellings in order to be a viable catchment. So when you start thinking about catchments, there's a whole lot of, I guess, mystique about, what are the operational criteria of supermarkets. We can get much smaller stores with effective full SKU capability for quite small catchments. And the other point of that is they don't have to be full SKU supermarkets. They can be much smaller. So around Porirua Bay, for instance, I think we can get a reasonable supermarket with a high density zone and a double-sided centre zone that gives us greater capacity to deal with the road as an interface between the catchment and the station.
How many people does 1,400 dwellings equate to?
Multiply it by 2.5, so about 3,000 people. More than that, about 3,500 people. And you're right, you've got about 700, I think, in Porirua Bay at the moment.
700 dwellings or 700 people?
People.
The other point is that, speaking as one who now lives in Hawke's Bay, the attraction of just-in-time Logistical dwellings have soured recently. So natural hazard resilience in our, well, we're favoured with all manner of hazards that you don't get on on the West Island.
Can I click the 10.3 for evidence? The centre currently serves 1,800 residents, so where do they come from?
Good question. I may have got my numbers wrong, Commissioner. Yeah, for some reason or other, I remember 700.
Right.
And that may have come from property economics assessment. Yeah.
Well, that may be all the people on the escarpment track. Not sure there'd be that many. Okay, let's roll on. Thank you, Mr. Cullen. That's an interesting point.
It's got 3 pictures on here. Hopefully 3 things.
Okay, so figure 1 on there shows the outcome of the joint witness statement between myself and Mr. Steve White. And effectively we draw a line which shows, as a function of distance from the Radio New Zealand mast, and above that line you can't be completely sure that exposures to the radio frequency fields from that mast would comply with the limits in the New Zealand standard, but you could be pretty sure that they will comply below that line. And I would like to emphasise that there's a lot of conservatism in there, both in the way the standard is formulated and also in the way the calculations are done to draw that line. And it requires particular circumstances to actually get close to the limits as well. So that joint witness statement resulted in figure 2 in the revised rules for the radio transmission height control area. So figure 2, I've shown that same blue line again, and the red line shows the proposal for where you would need an EMF assessment. Anything above the red line would require the assessment. Below the line you wouldn't. But you'll notice that beyond 528 metres, there's quite a large gap, a large and growing gap between the red and the blue lines, which effectively means that there would be a lot of unnecessary EMF assessments required, both for sort of residential, for any constructions, and also for the temporary activities associated with those constructions. So wouldn't you know it? What should be figure 3 under paragraph 9 shows an alternative proposal from Ms. Williams, the green line, which sort of approximates more closely to that blue line dividing where you can be sure and can't be sure of complying with the limits, which would avoid a lot of the unnecessary EMF assessments that are shown in the first figure 2. And so in the end, I leave it up to your judgment as to which approach is preferable. I mean, really, the bottom line is that anything above the blue line, you really would require the EMF assessment. The advantage of the green line is it might be an easier rule to implement and more comprehensible for people using the plan.
I'm not sure your assessment of what Mr. Smeaton was proposing is actually accurate, but we understand what Ms. Williams and the Radio New Zealand team have landed on. My sole question is, we asked in Ms. Williams' version, there's a square bracket for the grid reference. We asked Radio New Zealand to give us a grid reference and to check and make sure you agreed. They gave us the grid reference, but they hadn't, I don't know if they'd talked to you or that, so where have you landed? Do we agree what the grid reference is?
We've got no reason to believe that Radio New Zealand's grid reference is wrong. We haven't got the capacity or inclination to check it against information.
So we can take the grid references as not in contention.
That's right.
So the point memo from yourself, Mr. Whittington, and
Mr. Pedler?
That putting forward.
Yes, that's right. So as I understand it, Radio New Zealand is happy either with Mr. Smeaton's position or Ms. Williams' position. Kāinga Ora's position is that it prefers Ms. Williams' proposed rule framework.
That's what's in, Ms. Williams is what's in the joint memo from yourselves.
Yep.
That's right.
And illustrated by figure 3.
Yes.
Any questions from Mr. Gledhill? That was easy.
Excellent. Well, I'll hand over to Ms. Williams to bring it to a close. Actually, I can do it now or at the end. I mentioned that I'd provide you a reference to the Productivity Commission report.
Yeah.
So I'll just read you the finding. This is F for finding 5.19 of their 2015 report, Urban Land for Housing. It's about 500 or so pages. But the finding is that inadequate underpinning analysis for district plan rules and provisions is a key source of unnecessary regulatory costs for developers. And there's a whole bunch of analysis that leads up to that finding, but that's the key finding that I was referring to earlier.
Okay, Ms. Williams. We've traversed a whole lot of issues with Mr. Whittington and with previous witnesses. How do you propose to handle this?
I think in the spirit of the time of the evening and trying to perhaps bring things to a close for us all, I'll take my evidence as read.
Good choice.
And I'm happy to just go straight to questions.
First question, 2.9. Variation 1 submissions largely supersede those. That largely leaves fertile field for uncertainty. Which submissions on the 2020 notified document, which Kāinga Ora submissions should we treat as still live? And can I say in advance, all of them is definitely the wrong answer.
So in regard to the zones that we're dealing with through this hearing stream, you can take the submissions on variation 1 as being the relevant submission points. There was a submission point in relation to the Eastern Porirua regeneration strategic objective that I've referenced within my evidence. I think it's at 3.1R. So just mentioning that I agree with where the council has landed on that. That came from the PDP submission, so that's an older one. All submission points relevant to noise, corridors, vibration, setbacks from the rail corridor, natural hazards as they relate to this hearing stream, all of those submission points on the PDP remain valid.
Remain valid. I mean, just in the interest of time, we might invite you to formalise that because throughout the 42, there's a number of comments that KO are not pursuing the PDP submissions. You've listed in your, I can't remember what one, 18 matters that you're generally in agreement with, and you're not pursuing it on an evidential basis. There's the supplementary report from Mr. Rackland, which lands a couple of issues. So I guess it would be useful as a panel when we sit down to deliberate, having that sort of index in front of us.
Yeah, sure. We've got a table underway at the moment, so we can certainly make that available.
A table would be good, but also some sort of high level one, descriptor would be good. But table would be useful in terms of knowing which matters we no longer need to make a decision on. And I'm guessing, Mr. Whittington, that there's a difference between not pursuing a submission and withdrawing a submission.
Yeah, that's right.
Yes. Can you be more helpful? I mean, are there any matters at the Congress? Are there any withdrawn submissions?
Well, none that immediately come to mind, but I mean, a lot of them have just been made redundant by the fact that variation 1 has come along. So I'll certainly make that clear in the table. Any that are withdrawn.
Yes.
Yep.
I mean, for example, what Ms. Williams just said about for the zones, really variation 1 is the go-to document now, isn't it?
Yes, absolutely.
Submissions. So why wouldn't Kaingaroa withdraw their submissions on the PDP?
Yeah, that may well be the case. I'll certainly make that clear through the
Leave
table.
that with you.
Yeah, thank you.
Timing?
Well, when do you want it by? I could do it by Thursday, potentially.
Like
3 days time. Today's Monday.
Thursday would be good.
Okay.
So long as that doesn't mean that the table that Ms. Williams referred to is going to be compromised in any way.
Like, yes.
It's the same table.
Like we'd prefer it to be comprehensive and a little later than on time and qualified.
I had been hoping to have it here today, but the problem is it's at the moment 50 pages, so it will be comprehensive. But as I say, it's I will look at it again with the lens that you've asked me to of making sure what's withdrawn.
Might draw on the Section 42 accept reject table.
It does to some extent, yes.
Yeah, that would be useful.
Yes.
So, Ms. Williams, kicking off, I go to your discussion at 4.9. You characterise Kaingaroa submissions as supporting, as you support them. They maximise the opportunities for intensification. And the thought occurred to me that maximising the opportunities for intensification would be all urban land is high density residential with no standards at all. But I don't think you mean that.
No. Certainly, there's a qualifier. I guess that applies here. It's I guess it's enabling at the greatest extent, as I see, relevant and appropriate to the zone framework that applies here and the outcomes that are sought within those zones.
And that ultimately, therefore, you're not maximising, you're making a judgment call, and we're talking an issue of degree. That fair? Like you're pushing the needle a little further, and I think Mr. Cullen's tried to put his finger in the air and quantify how much further. But that again, where the council's sitting is a lot further along the spectrum than the 2020 notified version, which is in turn further along the spectrum than the ODP was.
Correct. Yep.
do you have anything to add on design guides to what Mr. Ray provided?
I think there could be some benefit for the panel in just understanding the process that was undertaken in formulating policy, for example, Res P10. So largely those, the points, one of the first matters that was expressly undertaken in this exercise was outlining that the planned urban built environment was a relevant consideration in considering these outcomes that we've referenced below. So just making that quite explicit within the policy. Many of the policies, well, all of the policies effectively are based on the design objectives of the design guide. There is instances where they have been combined into one particular policy subpoint. In terms of what's not in there, which is in the design guide, the two key things that I can consider or that I can identify that aren't in those in the policy. First is A6 within the design guide, the design objective around character, which is to respect the identified valued aspects of neighbourhood character. And this is in reference, or the reason for that is recognising that we're looking to the future, to the planned urban built environment. So not drawing on the existing context so much. And the other matter that I can see is not translated through to this policy is C7, which relates to conspicuously tall buildings in the residential intensification precinct. As I understand it, all other matters are within there, but reframed.
In what precinct was that? Conspicuously tall buildings in what precinct?
In the residential intensification precinct.
Oh, yes. Thank you.
What might be useful, I certainly understand your preference for the design guides to sit within the plan. In the event that they're not, it might be useful from a drafting exercise only to understand how P10 might need to be redrafted from and altered from your blue line version attached to your evidence.
I think it's the reverse. If they are in the plan, you said if they weren't.
Sorry, if they are in the plan. Yes, I did. So if the design guides remain in the plan, how might P10, if at all, be redrafted from your blue line version attached to your evidence? Bearing in mind what you just said about A6 and C7 not being from the guideline not being present in the policy framework. Is that an exercise that you could address?
Yes, I guess if the design guides are to remain in the plan, as I would, if the design guides remain in the plan, I would seek that there is explicit reference to whatever the outcomes are that are critical within that design guide be translated through into this policy.
Yes, more so than what the wording change that Mr. McIndoe suggested to P10 in terms of referencing the relevant design guide objectives.
Yeah, I would seek to have them actually brought into this policy.
Okay. Well, I think that would be useful to see that.
Sure.
The question is,
are you able to do that in the same timescale that Mr.
Yes.
Whittington's just volunteered?
Yes, as I understand, the submission text actually has largely brought in those design objectives as they are within the design guide, but yeah, that's certainly an exercise.
don't feel constrained to having to do that on your own. To the extent to which you want to discuss that with Mr. Racklin or others, you don't need it. You shouldn't rely on a direction from us to do that. And it might only be from a drafting assistance perspective. You still might retain your position that the design guidelines should be outside the plan. just before we leave design guidance, just quickly, what's the policy, and I apologise, I should know this, what's the policy reference for design guides, non-residential design guides? Is it still P10 or is it, it's not, is it? It's some
P7.
P7, okay. And just remind me, what's the trigger for that? It's 3 or more units on the rears, but what's the, is it a floor space for commercial?
Space, yeah, typically 450.
450, yep.
In the larger commercial areas.
Thank you.
Going to walkable catchments, you've cited MFE guidance on 800 metres being an appropriate starting point, say that's commonly accepted New Zealand international standard. I've only read the first section of Mr. Ray's evidence, so I don't know what he's going to say about Wellington, but that's not the approach in Wellington, which is a little closer than international comparators. I'm working on it, Mr. Ray.
Sorry, I'm not sure I understand the
Well,
the
point,
question.
the point being, in the nearest territorial authority isn't using 800 metres, and more generally, how much weight can we put on MFE guidance anyway? Something I've waxed eloquently on in other fora.
Yes, no, so yeah, Wellington City is not applying 800 metres around all of their train stations, as I understand it. I understand that's a fairly vigorous point of contention amongst submitters.
As I say, I confidently expect to read quite a lot from Mr. Ray on that subject.
And guidance from MFE, it is just guidance, ultimately. It's very useful to try and get some sort of general consistency across the board, but it is just guidance.
Yes, I'm just aware that the Environment Court has been very terse about suggestions that MFE can alter the meaning and effect of national direction after the event, in effect suggesting what they wish they'd said but didn't actually say. So we'll just take that as a given. In your discussion of shading, you refer to Aries et al. Mr. McIndoe was able to give us a copy of the summary of that paper. Are you able to give us the whole paper? The summary certainly suggested that there were relevant health effects.
I actually haven't accessed the entire article, so I guess the point of my evidence there is citing research that has referenced that particular article. I've read a summary of it. Certainly my take of it is almost, in my view, lamenting the lack of evidence around this particular issue. So it's not saying that the issue isn't there, that there is no issue, there is no health effect, but more having undertaken an exercise to actually review what the evidence on it says, there's very little evidence linking it. So, and I think I make that clear further in my evidence, where I'm not disputing that there is a health implication there. It's just the extent to what that is, and whether a 3-month period is of such significance that it warrants additional controls and measures is unclear.
And I suppose just making the same qualification that Mr. McIndoe made, he observed, in relation to the reference in that paper to lack of sunlight causing myopia, emphasised that he wasn't an eye specialist, and presumably you would make the same qualification. You're not purporting to give us medical evidence.
Definitely not. Certainly not within my area of expertise.
Where does that leave us, Ms Williams, in terms of, I mean, I rather crudely referred to the three-step process for identifying a qualifying matter, or a matter that's not listed as an automatic qualifying matter, and that's clause H in the NPSUD anyway, and 3.33 takes you through a process for actually then determining what should be a qualifying matter, and then how it's applied on a site-by-site basis. But in terms of that first step of identifying, is it something that's should be captured? What are you saying about the evidential basis?
Well, effectively that there is limited evidence provided in the council's reports to clearly demonstrate that the health effects are of such significance that for 3 months of the year it is worth reducing development potential of a site. So there is no accompanying evidence from a medical expert or public health perspective that might provide a bit more illumination of that issue.
The evidence that we've got in front of us comes directly from Mr McIndoe's UD20 report, and I think section 2.2 on the rationale for the height variation controls. There's 5 points made about the shading. Is that what you're referring to in terms of the absence of evidence?
Yes. Okay. So again, I acknowledge that sunlight is absolutely a factor that contributes to one's health. So I don't want it to be considered that I'm refuting that particular issue. It's just the evidence as to whether or not the level of shading and loss of sunlight is of such scale and significance to warrant this particular control.
Thank you.
I was going to go to the large format retail zone. Suggestion that it should be moved to a metropolitan zone. And the reason given in the 42A report for large format retail is that there are a lot of large format retailers sitting there. The NPSUD, of course, requires us to meet business demand as well as residential demand. So the question is, like Mr. Cullen's thesis is, we should be transitioning that to a metropolitan centre with all of the services that go with it, including apartments, ground floor, commercial, that kind of thing. So where does the plan then identify as appropriate for large format retailers like the ones that are currently sitting there?
So the plan would continue to provide for that activity. The provisions, the amended provisions within my appendix for the Metro Centre would continue to provide for the large format opportunity. In my opinion, extending the Metro Centre essentially just creates opportunity as and when it arises for a range of different activities to locate within that area. And residential is one, but there's a broader range of amenity offerings such as hospitality, broader range of urban amenities, cafes that aren't currently provided in the large format centre that would support a residential population base.
I'm conscious of the market phenomenon that I've seen elsewhere, where the plan opens up opportunities of that kind. The incoming users basically value the land more highly, and the large format retailer exit stage left and because effectively they're outcompeted. And so the question then becomes, well, the Metropolitan Centre didn't manage to retain the large format retail. You still have to provide the demand, so you have to find somewhere else. So it becomes like chasing a cat chasing the tail. Is that a potential concern?
I think the reality is that these activities co-locate in the same location typically. So while perhaps a ground lease issue from a market condition as costs increases as broader activities can enter that area, if that has an implication around an activity having to exit, I think the risk of that is very low. As I say, the plan still continues to provide for that act. Or the amended provisions that I recommend would still continue to provide for that activity. I think the risk of that is quite low in my opinion.
And the other question about that particular zone is that a large chunk of that zone is devoted to the Whitireia Tertiary Education precinct, which on the face of it isn't going anywhere. Well, that particular activity does it matter what it's zoned? Like there's a very large, well-established education facility there that on the face of it is clearly not going to change the profile. You wouldn't have thought it was likely it was going to have apartment blocks in the middle of it, but I suppose we never know. Is there a case for treating that sector differently to the balance?
No, I think the Whitireia precinct is a precinct within the large format zone at the moment because it's not otherwise provided for as an educational facility. The Metro Centre would enable that activity as of right.
So on one view, it might be a benefit then.
Certainly not an inhibiting factor.
I was intrigued by your description in 8.26, talking about people passing through Porirua Bay, and I wondered if that's a Freudian slip, that's what people do. They pass through, they don't stop. As a justification for an expanded neighbourhood centre.
There's not, an increased neighbourhood centre would provide greater amenity benefit for other commercial activities, which could enhance the destination aspect of it.
I think that's a bit of a stretch, isn't it? Downtown Porirua Bay is the ultimate shopping destination. Oh no.
No, certainly not. So it is one end of the start point of the track, and certainly if you go down the line to Paikakariki, that's often the preference landing spot for people doing that walk because it is a greater destination. It has better services, it has better amenity. So it's effectively just making the point that an expanded service centre could provide for that same amenity.
Plus you're walking downhill for the Coastal Escarpment Walk.
Next question relates to the enabling capacity of the zones, talking about spatial extended walkable catchments and everything's, you're saying this is about enabling and not requiring, may not, this is Mr. Whittington's point, may not lead to any change. One issue might be that it might lead to sporadic change. The odd 6-storey building among a group of 1 and 2-storey houses. Is that a problem? Like that we need to take account of?
No, I think the reality is that a greater spatial extent of the high density zone does absolutely increase the opportunity for development to occur in different parts of the city. But ultimately, that is what the MPSUD is anticipating and directing.
But is it anticipating one 6-storey block, at one 6-storey apartment in a block, another block, one 6-storey apartment surrounded by 1-stories? Or I thought the planned urban form was a preponderance, like the way the objectives are framed that you've supported. It's a preponderance, predominantly 3 stories in the MRZ and predominantly 6 stories in the, if that's the planned urban form, and the end result is only sporadic examples that are out of step with the remainder of the housing in the area. Is that really what the MPS is trying to get to?
So yeah, so there's going to be that transitional period. This is a future focused framework that over many decades, this is the emerging outcome that is anticipated and expected. So there will be the first large buildings in different parts of the city as that transitions. The market's not going to provide for it everywhere, so you're not going to get that uniform built outcome everywhere.
In a planning response, is it desirable to try and concentrate it rather than that also goes to an urban form issue? Like, yes, the market will do what the market will do, but in terms of, to the extent the plan can give guidance, should it be trying to concentrate larger development?
Yes, and I think from an infrastructure perspective, it's obviously beneficial to have development concentrated where possible. And in my view, that's the approach the walkable catchment has taken. So yes, there are multiple walkable catchments across the city, but there's not high density zoning across the city. Only in the locations where there's walkable catchments. And in Porirua, the high density zone is actually quite confined, as I think Mr. Ray touched on. So it's not as an extensive zone as you see in other districts.
Oh yes. Paragraph 1110B. You said you agree that provision remains relevant. You don't agree with safeguarding. I had a discussion with, I think it was Mr. Racklin on that issue, and he's gone away to ponder what an alternative word might be. What's your definition of what an adequate provision for privacy would be?
I think ensuring that there is some element of privacy there. So, in my view, the concept of safeguarding holds that sense of amenity and privacy as it is now.
You don't go there. I had that discussion with Mr. Rackley. It's something short of safeguarding, but not nil. So where is it in the spectrum?
Yeah, I think that the concept of adequate provision captures that, and then it's on a site-by-site basis as to how that is actually reconciled, whether it be through open space design, placement of screening, windows offset.
That's me, commissioners. Have I burnt everybody off? Okay, you go.
Just a couple from me, Ms Williams. They're quite specific. What's it in relation to? It's in relation to intensification, where we're looking at that 19 metres plus 60 versus the 8 metres plus 60. You cover it at 10.3. I think you've said that you would actually add a building coverage standard, I think, of 50% to balance it out. I just wondered whether there's scope, in your view, to do that.
There's a submission point that seeks consequential relief.
Yes.
There is also other submitters who have sought site coverage provision in the high density zone.
Yes. Presumably the building coverage would constrain the 19 metre relief to a certain extent. So could it be argued that that's within the envelope of what Porirua were originally asking for?
Within the submission point?
Yes. I mean, if an original submission point asked for the increased starting point for the height in relation to boundary plane without any additional site coverage. So the addition of a site coverage rule would presumably reduce the applicability of that rule. Or not reduce its applicability, but reduce its the extent to which it can be applied.
And perhaps, but the 19 metre height in relation to boundary control only applies for the first 20 metres of the site anyway. So it's not anticipating that it would typically apply perhaps to a full site.
Okay.
So, but yes, for a smaller site, it could.
Okay. And my last question was just this is in relation to the health and wellbeing policies, and this is at your paragraph 11.4 on page 41. You're asking for references to amenity, and I was surprised to see those, particularly in light, and it's over on 11.8 also, on the policy P7. And I was surprised to see those in light of what policy 6 of the MPS UD talks about in terms of don't go there in terms of amenity. Did you give that any thought?
So policy 6 is anticipating that there's going to be a change in amenity. It doesn't seek the full removal or completely detract from the fact that the amenity is still an outcome that should be achieved on a site and with design and site planning. So in my opinion, amenity remains a relevant consideration. It's just...
I might be getting ahead of myself in terms of what the NBA is trying to achieve in relation to amenity.
Does it, I've just looked up page 6, it says may involve significant changes to an area.
Policy 6, yeah.
Yeah, policy 6, that may detract for amenity values appreciated by some but improve for others and are not in themselves an adverse effect. I wonder if it's overselling it to say it's saying, well, it's putting it out completely out of court.
Yeah, I agree. It's within. It's still a matter that should be given consideration to.
Thank you for that.
Any more for any more? Well, 7:13. Panel are feeling a little jaded. I'm sure everyone present is probably also feeling a little jaded. Thank you all for sticking with it, including and certainly not limited to our heroic administrative guru. So. Yes? That's a good idea. Anything that gets us out of here in the next 30 seconds is a good option. Good. That's fine.
How many
So on that happy note, I'll leave that with Mr. Ray to confer with Mr. McIndoe and file something tomorrow. It summarises how what's not agreed. And thank you to the Kaingora team en masse for hanging in there and assisting us to the extent that you have. Yeah, I won't say you haven't given us quite a few curveballs to think about, but that's what the job entails.
Thank you. And can I add Kaingora's thanks to the council staff as well for accommodating us, and to the commissioners, obviously, for accommodating us so late into the evening.
Thank you. Adjourn until 9 o'clock tomorrow morning.